again. Yes, Mr. Chaudhary, seeing you after long.
That's the usual vagaries of practice, Milord. Sometimes it's up, mostly it's down.
No, it will go up again, I'm sure.
Lordship, as for admission item 17 and 18,
17, 18.
day before yesterday, I had filed an IA as an intervener.
Hmm.
So it's not been listed. I request that it be requisition, Milord.
Okay, you give the requisition and they'll bring it.
Deeply obliged. to me.
Yes, it's okay.
Ladies.
17, 18, right?
17, 18.
Okay.
They'll be with,
Huh.
I will be with it.
Yes.
Yes, I beg to
Yes,
mention
Mr.
for
Apte. Yes, huh?
testing of a criminal petition, my lord.
So you approach the registry, they'll do it.
My lord.
In case they do not do it, then you come to
My
me.
lord.
Yes.
It's already.
Whoever is mentioning for listing, please approach the registry.
My lord, only thing I was forced to appear before my lord, my lord. It's a motion case on last month, 29/7. It came, but Mr. H.R.S. Chaudhary was leading me in the case.
Hmm.
So I took time for a week.
Huh.
After that, it is been now, it is about 5th week. It's not coming. I tried my level best from criminal section to the,
Mhm.
ultimately, my lord, is not
What is that matter? Petition?
petition, my lord.
Okay.
So I thought of tomorrow, but then I realized that possibly your lordship has got quite a few matters, the
Mm.
motion side,
So, okay, next week?
Monday,
Okay, Monday.
deeply obliged. Wait, Mr.
Item number 51.
51.
51. the last
Supplementary?
item. The
No.
last item.
Huh.
daily list,
Yes.
Daily list.
Hmm. Oh, it's for hearing.
It's for hearing and Mr. Larned, my lord, senior counsel is not well today. So this matter may be listed on Tuesday.
Okay. On the prayer made by Miss S.B. Chaudhary, learned counsel appearing for the appellant, list this matter on Tuesday, that is, 7. Oh, Tuesday is a holiday. Then Thursday, 3rd? 3rd of it.
Wait for listing criminal petition. More the matter is to default bail.
Not tomorrow. Tomorrow it's a long list. Matters will not reach. It will be of no use.
Monday.
You please approach the registry. They'll do it. Okay?
Monday.
No, it's okay. You approach the registry because they know how to list it. I don't want to overburden other courts as well as my court with so many matters. It doesn't reach us, then due to paucity of time, I have to get it. So you approach the registry, they know it better.
Wait, Mr. Lordship. You are concerned with the other side, Lordship. I beg to mention item number 43, Lordship.
43, yes.
And today I am going to file, Lordship, affidavit in objection.
What you are going to file?
Affidavit in objection, Lordship.
I am going to appeal, Lordship.
This is
Yes,
nothing, delay or.
Delay, Lordship.
Yes. I am going to appeal, Lordship, 25,000 deducted from my salary level for every month, Lordship. I am suffering so.
Compensation. Oh, I mean,
Yes,
there's
yes, yes.
maintenance.
Yes, Lordship.
Date may be fixed on next week, Lordship.
He want to file some affidavit in opposition.
So very short date will be given, Lordship.
Okay, you are for,
I am for petitioner, Lordship.
you are for petitioner. And I is filed by you. He only.
Yes.
For,
Delay.
For delay,
for
Lordship.
delay. How many days delay?
Lordship, so many days, Lordship, about
Achha.
yes.
Okay, let him file the objection. You want to file
Our
objection?
civil suit
Okay, I,
declare court's marriage, Lordship.
in the delay condonation.
Lordship.
Okay, heard, Mr.
M. Mondal, Lordship.
Heard Mr. M. Mondal, learned counsel appearing for respond number 1, and Mr.
A.K.
A.
Ahmed, Lordship.
A.K. Ahmed, learned counsel appearing for the petition. List this matter on 8th of September.
Yes, Lordship.
Oh, but uske pehle likho, Mr. Mondal submits that he has to file an affidavit in opposition to the delay condonation petition. Prayer is allowed. List this matter on 8th of September.
Obliged.
Obliged, Lordship. Yes, Lordship. Back to mention item number 3.
3.
My lord, matter may be taken up, my lord, next week, my lord.
This is AB motion.
My lord, as per instruction by client, my lord.
When do you want the matter to be taken up?
Next week, my lord.
Next week.
My lord.
Okay, you are for the petitioner.
Petitioner,
Okay, Mr. M. Hawk, learned counsel, M. Hawk.
my lord.
Learned counsel for the petitioner prays that the matter be taken up on a later date. Prayer is allowed. List this matter on.
Next week, my lord, any date, my lord.
Last week, there are only 2 days.
My lord.
2 working days. So list this matter on 2nd of September.
My lord.
May please, Your Lordship. In item number 21, it's a criminal appeal. I file an interlocutory application for extension of bail, my lord. That was not come up, my lord. That may be called for in 20
Extension of bail, you're already on previous bail.
previous, but it was going to be expired on 5th of September, my lord.
Mm.
So it may be called for, my lord. Today it was come up at another
Okay,
20.
you bring it.
Can I give a requisition slip or requisition slip, my lord? Highly obliged. And this matter will be taken over.
Or for listing the IA, what
I have
needs to be
prepared a
done?
mention memo also, my lord. But,
No, you want to bring it today, right?
yes, my lord. In earlier occasion, I also took time, my lord, because on that day I have filed a IA, and your lordship has granted time and fix it today, my lord. But although the criminal,
You give a try. If you can bring it, fine.
yes, sir.
Or we will postpone it to some other day.
You also may take it in 2 p.m., my lord.
Hmm.
Immediately it may come up.
Taken up.
So I will give a requisition slip or mention memo, my lord. It is,
I don't know what is the procedure.
I give a mention.
As far as calling the affidavits are
Evidence a
concerned,
requisition
okay.
slip, my lord.
But here the IA has to be called.
I give a mention memo, my lord.
You give the mention.
I write the
Hmm.
item number.
Lordship, with the consent of other parties, Lordship, I beg to mention item number 23, Lordship.
23.
Yes, Lordship. Lordship, in this matter, 2 weeks time may be granted to file reply, Lordship. The standing counsel in.
You are for the private respondent.
Lordship, I am for the complainant,
You are for the,
petitioner, complainant.
this is criminal petition.
Yes, Lordship.
And the petitioner, you said that you want to file affidavit in opposition.
Reply.
Reply, okay, okay. Okay, so your name please?
Arguably,
If Miss R. Jugli, learned counsel for the petitioner submits that she has instructions to file her affidavit in reply in the instant case, prayer is allowed. List this matter when?
to it.
List this matter on 16th of September.
May it please your lordship, I beg to mention item number 40.
40.
40. There is some difficulty on the part of my senior, Mr. D. Das. It may
Wait
be
one
listed-
second. Let me take out. 40 is what? Order matters.
Orders matter, my lord.
I think this is for suspension of sentence.
Suspension of sentence, my lord.
Then what is
My
the
lord,
problem?
My senior is having some difficulty. He has also given letter of absence, my lord. Anything next week.
Your senior means Mr.
Mr.
S.
D. Das.
Gogoi.
D. Das. I am for the respond number 2,
You for the respond number 2. The informant.
my lord.
Okay, Mr.
BJ Talukdar.
BJ
BJ
Talukdar.
Talukdar.
Learn, your senior is Mr. BJ Talukdar.
I'm busy.
Oh, acha. Mr. BJ Talukdar, learned counsel appearing for the respondents. You have informed Mr. Gogoi? Acha, you are there.
Yes, sir.
Submits that and the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. The said prayer is not objected to by the learned counsel appearing for the appellant.
Lordship, kindly fix the date, Lordship.
List this matter on when suggest on a date,
Lordship,
10th
can
of September,
11th of September.
11th of September.
Lordship.
Oh, Hemenda, let me take bail matters first. Yes, Mr. Bhattacharya, you are waiting for which matter? I can take it up. Which one? 17 and 18 details. I'll take up your matter as the first item. But 17, 18 it is adjourned.
No, not a jump. I filed an IA.
Oh, acha, acha, yes. Yes.
That's registration.
But then it has not come.
On the way, my lordship here to the battalion. I'm not opposing anything that we use the bail for. I just want to state as a prohibition.
Or if Mr. Bhattacharya wants to do it little later, I don't have any issues.
All records. Records come.
Records.
Records have come.
Records are here. PCR is here. 5 number of files. Tomorrow? Okay. By that time, your application. Tomorrow? Okay. As prayed for by learned senior counsel, Mr. A.K. Bhattacharya. No, don't write. As prayed for by the learned counsel appearing for the petition.
Sorry. Your number 17 and 18, my lord.
Hmm.
Not tomorrow, my lord. Kindly on Monday, my lord.
As for Mr. Bhattacharya's prayer. Tomorrow. And as prayed for by learned counsel appearing for the petitioner, list this matter tomorrow, that is on 28th of August, 2026. tomorrow, both the matters.
How much?
Yes. Motion আছে ন? এই motion petition বহুত আছে তো। পোন্ধৰ টা। কি কৰিব? মাতি দিব পাৰো দে। ফিৰিলে যাওক। Yes, withdrawal. Yeah, Mr.
AJ Sharma, your lordship.
AJ Chamua,
AJ Sharma.
AJ Sharma.
Sharma.
Learned, Mr. AJ Sharma, learned counsel for the petitioner submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as written.
Your lordship, kindly grant us liberty to file a press.
Liberty is always there. Prayer is allowed with the liberty that petitioner can approach this court if required.
Please, your lordship.
Bail application.
Bail application, lordship, in this case, lordship, co-accused case is already fixed today, item number 26, lordship. Probably, lordship, case study is there, lordship.
Oh, in item number 26, in this court?
Yes, lordship.
Yes. Okay. Yes, 26, or I'll take up this matter with 26.
Lordship. It will be
Okay.
better.
I'll take up this matter with 26. 26 alone matter. এইটো কেছ 26 লগত মাতিব একে ইজ ডাইৰিছ এইটো কাউন্সিলে নাই Yes, no one appears for 52. Okay, could we call up after some time again? All of them. 53. Yes, Mr. Ranpi.
Yes, Your Lordship, this is a regular bail, Your Lordship. This is behind the bar for 10 days, Your Lordship.
What, 10 days?
10 days behind the bar, Your Lordship.
10 days only.
Lordship.
What is the offense?
303, Your Lordship.
What is 303?
Theft, Your Lordship.
Theft.
Yes, Your Lordship.
Okay, take me to the FIR.
The affair is a page 8, Your Lordship. The relevant portion is page 9, Your Lordship.
It took life.
They were caught red-handed.
Yes, Your Lordship.
On what grounds are you praying for bail? But they are, you are amongst these four.
Yes, Your Lordship, among the four.
Rahul Das.
Yeah, hold on.
Carried for
Item
Rahul
four.
Das, Your Lordship.
Okay. So, what are your grounds?
Lordship, actually, he is the only person who's earning in the family, Your Lordship. There is no one other, Your Lordship. Even the.
That doesn't mean that you'll go and steal,
Yes, Your Lordship, I understand that.
but they are caught red-handed by the police patrol,
Yes, Your Lordship.
trying to steal so much of rods belonging to our project. Our project is, what is this project? SPS
Yes,
Construction.
Your Lordship.
Majgaon. What are they constructing?
Bridge, Your Lordship.
Bridge.
Bridge, Your Lordship.
So, what does the forwarding report say? Stolen articles which were stolen by accused person have been recovered
And recovered, Your Lordship.
along with a dhow from their joint possession. Or let the case diary come. But you were caught, had you not been mentioned in the
The articles have been recovered.
articles were recovered, but
What red-handed?
but See, bridges are being constructed for the public use, for the benefit of the public, and you'll go and steal those iron rods. Let the case diary come.
He is the owner of the vehicle, your lordship. We just took the 3%, your lordship.
He is the owner of the vehicle.
Vehicle, your lordship.
But vehicle is used in the commission of the offense.
Yes, your lordship.
It was loaded there. Right. Let the
Was
case
not
diary come.
His knowledge that such things will happen, your lordship.
But then it's not reflected anywhere. Okay, case diary?
Lordship, a short
Huh?
may be given, your lordship, because son is suffering, your lordship.
Okay. This is from what? Oh, this is from here.
Yes.
Gauhati. Okay, heard Miss H. Terangpi, learned counsel for the petitioner, and Mr. K.K. Das. By this application, the petitioner has prayed for bail in connection with North Gauhati PS case number 83 of 2026 under section 3032, 317 to 3 subsection 5 of BNS 2023. Call for the case diary. List this matter on 7th of September.
Yes, sir. Oblige, sir. Before.
Maybe.
Yes.
We will have the 483 BNS Miller and section Miller 108.
108 is what?
Abatement of suicide.
Abatement.
Abatement to suicide.
Only Miller from my phone, if phone was going to her Miller, she has a stroke Miller.
Acha, where is
Install.
the FIR?
Kindly say page 8 Miller. I have a situation that she has Miller a tea stall about 150 meter distance. She always supplies me tea, etc. Other water. I said that village also my mother works in a different student type dress, shop and maintain our food, but no reason for Janab, our village also will not assist my mother.
What kind of blackmailing?
There is not nothing. And particularly there is nothing, only military blackmailing. And it is not that she is very, she is a poor person woman.
I mean,
And she has happened Miller and
assisted by mother for, so he is working in the tea stall,
yeah, her own Miller.
her own tea
Own
stall.
Miller.
And the petitioner has been, it was working in her tea stall.
In his.
No, but,
I have a Miller stole me stationery shop.
but he said assisted my mother 4 months ago.
Only to establish her Miller shop, tea stall. Earlier she was the labor Miller in different hotels, Super Miller, Subsidiary Miller. I and others also Miller assisted her with some money Miller to establish her own hotel. And that is 150 meter around distance.
Where is the vernacular?
Vernacular Miller page, kindly see page 9 Miller. Miller, correct? We assisted Miller to establish our hotel, but he still may not, and now Miller, they are blaming.
One second. I have not finished reading.
One thing Miller, last.
What does it say? কিন্তু আজিৰ পৰা প্ৰায় 4 মাহ মান আগত চিনাকি হোৱা ফয়জুল হক. What is this গাঁও?
That is not correct, Miller. About 6-7 years she is working. Miller,
Jonab,
as a labor.
Jonab.
No, Jonab then.
Jonab, I am.
Gau.
Fazul Haq, it is-
গাঁও বৰ পিষ্টুপুৰ
ব্যক্তিজনে
ব্যক্তিজনে
বিভিন্ন
বিভিন্ন
প্ৰলোভন দি-
প্ৰলোভন
Translation is totally wrong.
Maybe Miller.
প্ৰলোভন দি ভগ্ৰাপাৰ
ভগ্ৰাপাৰ
এখন চাহ হোটেল পাতি দি এটা সম্পৰ্ক গঢ়ি তোলে আৰু দিন যোৱাৰ লগে লগে মোৰ মাক বিভিন্ন ধমকি, বিফৰ দ্যাট ধমকি বিভিন্ন
মোৰ লগত বিভিন্ন
হুমকি দি ব্লেকমেইল আৰম্ভ কৰে। মোৰ মা মানসিক
Blackmail আৰম্ভ কৰে।
ভাঙি পৰি
মোৰ মা মানসিক ভাৱে ভাঙি পৰি
যোৱাকালি ইমান তাৰিখে
যোৱাকালি
ৰবিবাৰে
9,
আমাৰ
8,
দেহত
9, sorry, it should be 9, 4,
দেহত বিষ বাস
9,
কৰে।
sorry,
যদি
তাৰিখে ৰবিবাৰে আমাৰ গৃহত বিষ-পান কৰে, যদিও মেডিকেলত
So he has been inside the jail for how long?
12 days. 12 days.
13 days more.
13 days.
The nascent stage, Lordship.
Otherwise, the abatement is not, I mean, it is not seen in the FIR
But the what
because
kind of
he
lodging,
helped her. She was working in different hotels and was maintaining the family. He, in fact, helped her to set up a tea stall. Maybe there was a relationship. But then, apart from trade, what kind of threatening? Nothing is written. Maybe for some other reason she died.
But the
And she
blackmailing is
there
there.
about 14 years.
Blackmailing. Acha, anything in the forwarding report?
Boarding report Milan mentioned only I have a phone call with that phone, her phone call Milan. About Milan 2226 phone. About last 6-7 years, not 1 day, but 2 days or 2 years. As because she was a Milan working as alia as a labor Milan, so we always Milan ask her to bring tea etc. Milan or water etc. And the person Milan who is before worship, he is also suffering from illness Milan. And different medical reports they have annexed.
In forwarding report also nothing is written. Only that Faizul Haq made illicit demands, issuing threats as well as relentless mental harassment over the phone. Nothing to substantiate. Only these words will not establish. What kind of illicit demands? They were already having formed an intimate relationship. Okay.
With
Heard,
the
Mr.
advantage of our weakness, Lordship.
It's okay. Heard Mr. A. Rashid, learned counsel for the petitioner, and Mr. K.K. Das, learned AP for the state. By this application, the petitioner has prayed for bail in connection with Ghograpar PS case number. PS case number 31. No, 81. 81 of 2026, registered under section 108 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged by the son of the deceased on 10/8/2026, stating inter alia that his mother used to maintain the entire family by working in different hotels. By working in different
Hotels.
বিভিন্ন hotel restaurant, by working in different restaurants. And that 4 months back, the petitioner helped her in setting up a tea stall setting up a tea stall, and in the process, the petitioner and the mother of the informant developed a relationship. Full stop. However, the informant stated that with time, the petitioner started threatening his mother and also had blackmailed her, and that his mother was upset and consumed poison on 9/8/2026 and died in the hospital. Mr. Rashid, learned counsel for the petitioner, submits that the story narrated in the FIR is a concocted story, and the petitioner, in fact, helped her to establish a shop, and there was no question of any threatening or blackmailing the informant's mother. He further submits that the petitioner was suffering from various ailments, and the medical certificates are annexed in the petition. Mr. K.K. Das, learned APP, however, submits that although what kind of a threatening or blackmailing is not mentioned, but the same would be revealed on perusal of the case diary. On consideration of the submissions made by the learned counsels, more so in view of the fact that the abatement is not explained. No, more so in view of the fact that the the threatening, the alleged threatening or blackmailing has not been stated with any specification. And also due to the fact that abatement has to be properly stated, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the
CGM Nalbari.
CJM
Judicial Magistrate Nalbari.
Nalbari under the following conditions. वो साला दे देना. हाँ.
In my submission, only one point, that there are frequent calls has been made between these
Acha.
two parties.
Mr. KK Das also submits that the CDR of the phones carried by the petitioner and the victim was checked, and repeated phone calls were found to have been made by the petitioner to the victim. Petition is disposed of.
Item 4.
May I please, Malad?
Hmm.
Malad, this is anticipatory bail application. Malad, the allegation is that, Malad, one person
Hmm.
being suspected of a theft, Malad, he was caught in a market. Then he was beaten by several persons, and subsequently he died, Malad. Petitioner is not named in the FIR, Malad. Thereafter, after completion of investigation, police submitted charge sheet, and the petitioner is shown as absconder. Malad,
Show me the FIR.
FIR is at page number 15, Malad, 15.
You are not there even in 5 criminals that were mentioned.
I am not named, Malad. Page 27, Malad, charge sheet, Malad. Petitioner name is at page 27.
27.
Yes, Malad.
But what are the materials that were found by the?
Page number
Malad,
32, Lord.
page 32,
CCTV footage is also there, Lord.
page 32, last two line, Malad.
Last paragraph may be read in, Lord. During investigation, there is a CCTV footage is also there.
And last two line is the,
Mhm. Sorry, someone took care.
second line from the bottom, Malad, petitioner name is Saddam Hussein, Malad. And
Okay, heard, mister.
Malad, one of the similarly situated person has approached this honorable court, Malad. And Malad, the lordship
It's
order.
okay. Heard Mr. A.K. Gupta, learned counsel for the petitioner, and Mr. K.K. Das, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Digboy PS case number 12 of 2026, corresponding to GR case number 44 of 2026, registered under section 189 subsection 4, 127 subsection 2, 196 1 within bracket, and then again within bracket small b slash 1031 slash 1032 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged on 12/2/2026, in which it was inter alia stated that when Oh, no. 12 to 2026 by the brother of the deceased, stating inter alia that on the day of occurrence, when his brother went to the market to fetch discarded vegetables to prepare the pig feed, PIG, Gauhati khana, to prepare the pig feed. Some of the persons of Digboi market assaulted him on the ground that he had stolen some fish, and as such, stolen some fish, full stop. It was also stated that the said miscreants had tied his hands and feet and severely injured him. It is also stated that thereafter, several persons joined the assault and injured the victim. The victim was later on taken to the hospital where he met his death. Mr. Gupta, learned counsel for the petitioner, submits that the petitioner was not named in the FIR, and that during investigation, the police, by way of examining the CCTV camera installed in the market, implicated the petitioner as one of the miscreant who had participated in the assault. Mr. K.K. Das, he participated in assault, full stop. However, he submits that there are no materials to show that the petitioner had assaulted the deceased. Full stop. Mr. K.K. Das, learned APP for the state, submits that the police had found out the rest of the accused persons who had assaulted the deceased, apart from the miscreants named in the FIR, by seeing the. Who is it? Why it is listening? After seeing the recordings in the CCTV camera in the market, installed in the market, the assault submits that the petitioner is involved in the assault made on the deceased. On consideration of the submissions made by the learned counsels, more so, on the stipulation made by the investigating officer in the charge sheet that the petitioner joined the unlawful assembly and participated in the assault, which was without any substantiating materials. This court deems it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority. Under the following conditions, he will go and appear within 7 days, 10 days, 10 days from the date of the order. Rest, huh? He will not influence, he will not any harm.
Charge sheet is submitted, I will appear before the court, and market.
Oh, yes, charge sheet, sir. He will appear before the court within 10 days?
Yes.
Okay. Acha, to the satisfaction of CJM?
SDGM, Margarita.
Oh, arresting nahi, huh? SDJM Margherita. He will appear within 10 days before the court of SDJM Margherita. And the rest, huh? Petition is disposed of. 5. Yes, 5. Mr. Bora.
May I plead the lordship? My lord, this is an anti-semitic bail application. The allegation is, my lord, purely, my lord, civil in nature, my lord. The
318 is what?
cheating, my lord.
Cheating.
Cheating, my lord. So the allegation is that, my lord, informant gave some money to the accused person, and accused person utilized the money for some business purpose. Then, my lord, he gave some check to the informant. The check got bounced, and thereafter he has filed the FIR, my lord. That FIR, your lordship will find as 15, my lord. No at all any criminal ingredient. Purely
Maybe
civil.
he contacted him and he did not give any importance. So what? I'll just save it.
Yes, my lord.
Page number 16.
16, my lord, FIR, my lord.
Thank you for that. What other? How much of money was given to him?
My lord, because the accused person, they are running nursery business. So the informant also interested in the nursery business and he has earned profit also, my lord, from there. And for investing in business, my lord.
So he has come to know that he is planning to sell their land and all.
My lord, for that purpose also, he should put them in the court, my lord. He could have been an injunction order or otherwise, my lord. And otherwise, my lord, the claim of the informant that some amount he has paid by way of accountant first. But other he has claimed to pay in cash, my lord, from where he got so much of cash. That is also a question, my lord. And when the check got bounced, he had the remedy, my lord. He took the-
NI Act case is pending.
No, my lord.
Acha.
He
That
was-
was not instituted.
No. So,
Acha, this is AB.
yes, my lord. Because number 3 is the petitioner hearing.
Which is this Caesar list. The police has seized what? Police have seized?
He is, my lord, some agreement copy and the check, my lord.
Okay.
5 numbers of check, then, my lord.
Yes, Mr. Sharma, in fact,
Yes, Lordship.
you have moved an application, AB, before.
My lord. It was, yes, my lord. AB
Page
was
31, Lordship will kindly come to page 31.
Opposing the which paragraph? Second
Page
paragraph?
31, Lordship, yes, opposing the bail, Lordship will kindly go through and next page also, just for a moment.
Careful examination of CD that the IO has collected various bank statements. These statements now. The account of their 5 bizarre. Inception thing, see, he was taking money, on various dates, right?
Yes,
yes, sir.
This entire money was not given in one day.
no,
On 19/2, I paid him.
yes,
So on 10/3, okay.
between January and March.
So that was a very good relationship. There was a very good relationship between them. He was also perhaps investing
Yes.
in the nursery business. And then, the check got bounced, but whether that will amount to cheating?
Lordship, Lordship will find it at case 31.
Huh.
Informant paid a total of 46 lakhs so-and-so through PSN online channel between January and March. Instead of utilizing this capital for the agreed nursery business, the principal accused so-and-so in active collusion with so-and-so systematically diverted the funds to purchase landed property and a vehicle in the name of the two accused.
It is, this were taken out from where? Perhaps from the statement of the informant.
Yes, my lord.
For that purpose, Lordship will have to
Amin or something,
Ruhul Islam.
Ruhul Islam.
Yes,
Accused person actively attempting to liquidate and
yes,
dispose of.
he is an
That is a
independent.
separate course of action.
And for their purpose, my lord, the informant has got a civil immunity, my lord. He could have approached the civil court, my lord, his party, then he could have got a reflection, my lord. But my lord, where is the otherwise concerned matter seems to be a money dispute. He took money, he did not pay back,
It was not matter what is, where is the criminal engagement?
Keep going if you. Positively.
Yes, madam.
But Mr. DP, one only, right?
Yes, madam.
And there were so many accused persons, you are
Three, I am the accused
after
number three.
booking.
Yes.
Number three.
Three, madam.
But so it's for petitioner and Mr. B. Sharma, learned AP for the state. By this application, the petitioner has prayed for a pre-arrest bail in connection with
Lonka PS case number. क्या थे कि वो हुए simple? Lonka PS case number 132 of 2026, registered under section 318, subsection 4/316, subsection 2/61 for BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged on 19/6/2026 by the informant stating that that there is a business from stating earlier that there was a business transaction between the informant and the accused person, which are three in numbers as arrayed in the said FIR, and the petitioner being accused number 3. And in pursuant to the said business transaction, the informant has given money to the accused persons who were involved in a nursery business. And that the petitioner, that the informant had given 46,14,000 rupees, 46,14,000 through cash and online channels to the petitioners, to the petitioner and others. Also, it was also stated that an agreement was entered into between the parties, and it was specifically stipulated therein that if accused number 1 fails to pay the money back to the informant, accused number 2 and 3 would pay the money, and that accused number 3 is the petitioner herein. Also, it was thereafter stated that although the accused persons, including the petitioner, had issued checks to the informant, but the checks were dishonored due to insufficient funds. As such, the informant alleges that he was cheated by the accused persons, including the petitioner. Mr. D.P. Vora, learned counsel for the petitioner, submits that the allegation made in the FIR involves civil disputes, and at no point of time any criminal offense is made out, much less cheating, which requires cheating from the which requires what? fraudulent purpose from the very inception. Full stop. Mr. B. Sharma, learned APP for the state, however, submits that the bail application filed by the petitioner before the learned court of Session Judge Hojai was rejected on the ground that the money which was taken by the petitioner and others were not used in the business, but rather it was used for purchasing landed properties as well as vehicles. On consideration of the submissions made by the learned counsels, more so in view of the allegations made in the FIR which amounted to civil disputes, this court finds it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount with the satisfaction of the arresting authority under the following conditions. He will appear within 10 days from the date of the order before the arresting authority. Rest of the eligible influence. The petitioner, this petition is disposed. Yes. सीधी ना मतलब कौन सा लंदन कुछ इमाम कौन सा लिसे ठीक है Yes, this is revision against what?
For an order whereby my Jima petition was rejected, my lord.
Oh.
That order is the page number 98.
98.
my lord.
Jima of what?
I seek Jima of 111 number of cattle which were seized from my,
111 number of cattle.
yes, from my home, it was seized.
Home, not from,
Not from
Vehicle.
outside. Initially, there is an FIR against some other person, my lord, here in Rani, my lord.
বা সিধা কৰি দিবা। এই monitor থলে সিধা কৰি দিবা।
And it is admitted fact that my lord, these cattle are belongs to me, I am the owner. There
So
is
the
no
allegation is
regarding
that it was stolen.
My lord.
Allegation that it was a stolen
In the
cattle.
FIR on which these cattle were seized, my lord, it was stolen, my lord. And there are other allegations of cruelty, my lord.
Acha,
So
where
far-
is the,
So far the ownership is concerned, my lord, that ownership has not been disputed. Even in the order by which my Jima petition was rejected, my ownership was not questioned, my lord.
so why was it not
It
given?
is only the cruelty. And the-
Cruelty in keeping the cattle at your place?
No, cruelty regarding the another set of cattle, my lord, which were seized by the police in another place at Rani, my lord. First of all, your lordship may, I place your lordship kind attention to the FIR, my lord, which is at page number 3, my lord.
Page number?
36, my lord, and exact 3. May I read?
36, yes.
With reference to the subject cited above, I have the honor to report that on 2/11/2025, at about 1:10 p.m., information was received from a reliable source that 3 vehicles carrying cattle were proceeding towards Meghalaya via Jaipur, Rani. Accordingly, a general diary entry was made by Rani OP DD number so-and-so dated so-and-so. An operation led by myself along with the staff of Rani OP was launched in and around the Rani Jaipur area under Rani OP jurisdiction. During the operation, 3 vehicles bearing registration numbers so-and-so were intercepted at Rani Jaipur. Prior to the arrival of the police team, the drivers of the vehicles and 1 handyman had uploaded the cattle in a nearby jungle area and attempted to move them towards Meghalaya on foot. However, all 3 drivers and 1 handyman along with their vehicles were successfully apprehended. Subsequently, a search operation was carried out in the jungle area near the Assam-Meghalaya border in the presence of the apprehended drivers and the handyman. During the search, a total of 11 cattle were recovered, which were identified and indicated by the apprehended drivers and the handyman themselves. However, they could not produce any valid documents when asked for. Altogether, 11 cattle were recovered from the jungle area and were seized along with the 3 vehicles bearing registration number so-and-so in the presence of witnesses. It is strongly suspected that the cattle were stolen by the apprehended persons and they are involved in the interest illegal trade and transportation of cattle, thereby causing cruelty to animals. I have nothing to do with this FIR, nor of the cattle which are seized belongs to me, neither the vehicle belongs to me. Suddenly, what happened, my lord? If this FIR was lodged before Polasbury Police Station 2/11/2025. On 4/11/2025, the police raided my residence and arrested me and 111 number of cattle has been seized from my shed, my lord. And accordingly, I was produced before the learned court below on 4/11/2025. My lord, kindly have a look at page.
Where is the Caesar list?
Can you have a look at 44, page number 44? This is the order. Herein, I could not have the Caesar list, but herein the article which was seized from my resident has been mentioned, my lord.
This is the impugn order.
This is not the impugn order. By this order, I was produced before the learned court below and the learned court below sent me to official custody, my lord. 45 page number reflected the articles which are seized from my
45.
45. The seized article height MR number so-and-so are 111 numbers of cattle. These are cash amount rupees. 1 black color Scorpio wearing 3 numbers of checkbook, photocopy of the seized cattle. Other articles, regarding the other articles, I have already get the Chimma Maya. And thereafter, my lord, as I was arrested, I filed a bail petition before this honorable court, and this honorable court granted me bail, wherein we specifically stated that prima facie told that the applicant had both the cows by legal means, my lord, which is at page number 50. This is the observation
No,
of,
those observations will not matter.
and this is not also disputed, my lord.
Will show me the impugn order.
Impugn order is page number 98.
What is the operative portion?
It is started from, my lord, 99 paragraph 2, my lord. May I read, my lord?
Acha, no, those two incidents were stated to be connected. Because the first incident where it was carried by vehicle and then it was unloaded and it was found in the jungle area was also by this owner. Those cattle also belongs to this owner.
Does not belong.
Otherwise, in the judge, in the order it is
Order is
stated.
there. But the thing is that on that kettles, I have not filed any Jimma petition. That does not belong to me. And that incident was happened in Rani, my lord. And the kettle for which I have seeking Jimma is from my home at Goroimari, my lord.
Goroi Mari. Where is
Goroimari.
that Goroi Mari?
Goroimari is Kamrup Rural, my lord. It is no.
But you have not annexed the Caesar list. How do I say that these two incidents are separate?
Then, my lord, you will also may fix it in another date. I will, for an additional affidavit, I will bring it. But, when I
Because no,
With the
you,
same,
otherwise, how can I say that this has no,
No.
had it, if the cattle were taken from your place
my lord,
and there was no cruelty as such, then the case is made out, of course, it cannot be done. But if those cattle are also meant by
cruelty,
you, which was
subjected to cruelty law.
taken by you,
Hmm.
which were seized in Rani, then of course, something is more to what you say. Okay, you file something, show that these two incidents are different.
so far, this kettle is concerned, my lord, that.
Case record has also come.
Yes, record, yes, no. Study is available.
It is very clear from the rejection order that these
Ah.
incidents same nothing. Because
Whether
as
the
clearly
PRC
stated-
case is also same.
Oh, and because the petitioner is also the same, Akram Ali.
No, no, in the.
He is also
but,
Akram.
my name is not there in the apartment.
That is a
But
different
I
thing.
don't know, I was there, it's on the same case, man.
Oh, same case.
Same case.
So you cannot say that these two cases
Lawsuit.
are different.
No, I am not saying that two cases are different. I am saying that.
You said,
No, no,
you said in the beginning that I have got no connection with this case.
I have no connection with the cattle, with the seized from this area, madam.
No, you have connection now, it seems. You are taking, you either take one stand that I have no connection, those cattle were not mine. I have nothing to do with that. My cattle were taken from my home.
The allegation is that I was, the incident was involved, my lord, and I am the owner of the earlier cattle society, my lord, in Run.
Oh.
But my,
You are trying to mislead this court.
then my lord may fix it on,
No,
Wednesday,
I'll not
for an
take it,
additional
take
affidavit.
up this matter. You be fair to this court. You should not be like this. No, I have no connection. These are different.
I may be wrong in explaining my.
No,
I may be wrong in explaining.
as prayed for by learned counsel, list this matter on 16th of September.
16, my lord. Actually, I may be wrong in expressing my.
No, you are not wrong. We all understood correctly, whatever you said.
16, my lord.
16. Do whatever you want. Wait. What is this?
This is my senior is engaged in another court, therefore,
Ah.
permission to provide a method for the time given.
After some time. Hmm.
Okay, this is 528, against, order that is 24/4/2026, passing criminal appeal number 33 of 2024. But before I go to the influence order, okay,
Hmm.
the background I'd like to bring you, lordship. What has happened, lordship? There is a DB case going on. In that DB case, lordship, I have filed my assets and liability. Lordship will kindly,
You're for the husband?
I am for the husband. Lordship will kindly come to my assets and liabilities. That is there in annexure 4, page 64. And
Okay, today it has come up for the first time or what? No.
yes, yes, lordship, for the first time.
No, there is one order. Miss Niharika on the
That
On
I was,
adjournment.
uh-huh.
So let new notice be issued today.
I am.
You have challenged the order
Yes, lordship. Lordship,
24/4.
I would pray for a stay because why I'm saying lordship,
Hmm.
lordship may kindly see.
So how much, what was the maintenance amount
Maintenance amount was 14,000 that was awarded
under DV?
under DB.
14,000
That I have challenged because I have no income. Not a
and only wife or child.
wife and child. So
Mhm.
that I have challenged and the entire impugned order of the affiliate court lordship will kindly find. There is no discussion why this 14,000 is required to be paid. And what is more painful, lordship will kindly see, lordship. They filed a petition under 340 after I filed an application of my assets and liabilities.
Hmm.
that 340 petition was not a part of the appeal.
Hmm.
Appellate court, Lordship may kindly come to page number 125, Lordship, that is disturbing us. Lord. Appellate court directed
Hmm.
that this 340 petition be expeditiously.
Three
disposed-
forty. That
Yes.
means something is done during the course.
Yes, they are saying that we have given a false evidence, which we are saying we have never.
Hmm.
So it is up to them to prove that we have given a false evidence.
Hmm.
Now, this 340 was never a part of the appeal. It was never discussed. But the appellate court, what appellate court did, appellate court made a direction that this 340 petition be disposed of within 3 months. So I am praying that this order being perverse, Lordship, the impugned order may kindly be stayed, Lordship.
In the same maintenance order, this order was made.
So in the same maintenance order, there is no reflection of 340.
Acha.
In the appellate
This
court's
is
order-
given in what order?
in the appellate court's order, the impugned order,
In the appellate order.
in the appellate order.
By the first court, nothing was there. They could not mend it. Mend করবে নইলে এপিনে তো একো হোৱা নাই সেইপিনে ক'ত হৈছে maybe their mics okay হেৰি কৰে বেলেগ বেলেগ কৰি দিয়াচোন okay in the appellate order right in the first court order there was no
There is no reflection regarding 340 petition.
acha 340 petition was filed when
It was filed during pendency of this, all the litigation that was going on. We have made the hearing. 3 times we have made the hearing.
no they say that the false evidence or whatever some
Actually, what has happened, Lordship, let me clarify, Lordship. They initially filed a case before Golaghat,
mm,
the lady,
mm,
for 125.
mm,
In that Golaghat case, we have filed an assets and liabilities.
mm,
6 months, 7 months back,
mm,
before initiation of the DV Act.
mm.
Subsequently, while this 125 was pending, they filed another DV case. When we say that we have already filed a maintenance case out there, and again you have filed a DV case, they have withdrawn that one. Now what they are trying to say,
that can be done
that can be done. Now what they are trying to say, that my statement of assets in Golaghat and my statements of assets before this court are two different.
Mm.
But my circumstance at that point of time was entirely different. At that point of time, I was doing some job. When my job, I was removed from the job. That means the company failed.
mm.
So the job, my job went.
Of course there can be difference
There can be difference. 340, we have already argued. I am personally the counsel out there, Lordship. We have argued 3-4 times, but they are not coming. Now, this court has passed an order that this should be done within 3 months. So my submission before Lordship, this 340 was never a part of the entire appeal that was filed.
so 340 was only on the consideration that your asset and liability affidavit was different
Huh.
before the family court and different before the
Before the
and-
Golaghat court
uh-huh.
and different before the magistrates court in Gauhati.
Mm.
This is the only factor. Nothing more than that. So I would say, Lordship, that there is perversity, and therefore, because why? Because the learned appellate court has traveled beyond the issues that was required to be decided. Issues.
Okay,
not
without
decided-
so paragraph 45 you are relying on you are pressing
Yes, Lordship.
without expressing any opinion on a marriage of said this court deems it appropriate to observe that such application ought not to remain pending indefinitely and requires pay. Therefore, the trial court shall make an endeavor dispose of false disclosure. Yes. The disposal of shall not relegate to parties. And this shall not be allowed. And this is part of this is the appellate order
Actually, what has happened, Lordship?
where you have challenged the maintenance.
Two appeal has been filed.
Hmm.
We have filed an appeal challenging that 14,000 is too much for us. They have filed an appeal for enhancement. And both the appeal were taken together and both the appeal has been dismissed. Enhancement part also dismissed because the court said that there is no perversity in the order finding 14,000.
Mm.
And 14,000 also dismissed. Our one also dismissed, but there is no discussion as to why I am required to pay 14,000. What is my income, whether I am capable or not. Because I have been out and out saying that now I am dependent upon my father. My father has a small shop at Nahargatia.
And what about your wife? Is she working?
She is not working. She's a housewife, but she is educated. She's M.Com. And they're having a lot of assets lot. They're having assets,
Acha, so you want stay only to that aspect, 340.
340. I want the stay for the entire lordship. The lordship can kindly look into it. For the
No, no,
entire-
that is cannot be because 14,000 you have to pay. Did you pay something before filing the appeal?
They are not coming, lordship. I'm ready to make the payment, but 14,000 I cannot pay. I can pay 5 to 7,000 I can pay. But I am going with the money every day. They are not turning up now. They are absent. Regularly they are absent.
Deposit it before the court then.
Their court is not acceptable, lordship. We tried our level.
Okay, heard Mr. A. Bhattacharya. Something. What problem is it? For the petitioner. And, oh, wait. Is state a party? No.
No, no.
By the petition filed under section 520 ENSS 2023, the petitioner has challenged the common judgment and order dated 24/4/2026 passed by the Court of Additional District and Session Judge number 5, Kamrup M at Gauhati, criminal appeal number 33 of 2024, by which the petitioner's appeal was dismissed and the interim maintenance, it was against interim maintenance and the interim maintenance order passed by the court of JMFC 4, Kamrup M, in DV case number 206 of 2023 was upheld. Full stop. Mr. Bhattacharya, learned counsel for the petitioner. Nalayan, right? Upheld. Full stop. Issue notice. Petitioner to take steps for service of notice upon respondent. Upon sole respondent by speed post with AD or by usual process. The interim maintenance is done. Interim maintenance of rupees 14,000 per month. 14,000 per month to the wife and the child. You are there in this matter? No. Okay. Okay. So, Miss Hogal, do you want the records? Do you want the records or not?
Scan copy may kindly be put.
Scan copy. Scan copy of the TCR be called for from the court of. So you have to have both the records. Scan copy of the TCR be called for from the court of District and Session Judge number 5, Additional District and Session Judge number 5, Kamrup, in criminal, scan copy of the TCR in connection with criminal appeal number 33 of 2024. Pending in the, this is disposed of.
This is before.
By the past, disposed of by the court of Additional District and Session Judge number 5, Kamrup M. The scan copy of the TCR from the JMFC 4, Kamrup M. That is pending. DV case,
Yes.
that is pending. Call for Iman in connection with DV case number 206 of 2023, pending before the said court, we also call for. Mr. Bhattacharya, learned counsel for the petitioner, however, submits that you have also challenged the 14,000 this thing.
Yes,
Right.
this is the right payment. I challenge the entire judgment.
Submits that by the appellate court, submits that the appellate court by its order dated 24/4/2026 had not only upheld the maintenance to be paid to the respondents by the petitioner to the tune of rupees 14,000 per month, had also observed that the application filed by the respondent under section 340 CRPC to be disposed of within a period of 3 months. Full stop. He submits that the petitioner is alleged to have what do you say, 195? What are the words that is actually what? There's no CRPC, no? Oh, 340 of CRPC? 340 of CRPC is the procedure to be followed under 195. CRPC can do that. That is if you give some wrong information during the
But Lordship, that is
proceedings.
yes. That is to prove, I'm given wrong information. That is for the honorable court to look into, it's a court to look
Ah.
into, not by the private petition.
Where is the complaint in writing? This is the complaint in writing. This observation will be considered
Yes, yes.
as a complaint in writing by the court, right?
They have already filed a complaint, they have not filed any complaint, they simply filed a petition.
Huh.
And we have objected to that. The petition has been heard out a number of times.
So, what did I say?
Alleged to have
Alleged to have committed perjury during the court proceedings and an application was filed by the respondent wife under section 340 of the CRPC for instituting the case against him. He, however, submits that the allegation made against the petitioner is that he had filed an affidavit disclosing his asset and liabilities before the family court.
No, not for the court.
Before 125 proceeding, you said?
That was in Bularan. I think magistrate. That was.
During 125 proceeding,
Last
had
time-
disclosed the asset and, during the proceeding instituted by the wife of the petitioner under section 125 of the CRPC. কেনেকে আৰম্ভ কৰিছিল? The allegation against the petitioner is that he had filed an affidavit, a certain liability,
during the proceeding.
and that thereafter he had filed the subsequent affidavit showing his asset and liability during the pendency of the DV case before the court of JNFC 4 Kamrup M. However, he also submits that on being pointed out by the petitioner, that case was already instituted under section 125 CRPC when the case was subsequently instituted under the DV Act. The petitioner, the respondent wife, had withdrawn the application filed under section 125 CRPC.
I don't know whether they have withdrawn our pointing or not, but they have withdrawn.
Okay, full stop. That is your submission, I'm saying. Full stop. Then he as such submits that there is no misconduct on the part of the petitioner in view of the fact that when he filed the affidavit before during the proceeding under 125, his position was different. And when he filed the application, showing his asset and liability before the JMFC during during the proceeding under the DV Act, his position had altered. As such, there was no misconduct or any wrong information given by the petitioner during the proceedings. On consideration of his submissions, this court, on consideration of the submissions, more so in view of the fact that the application under 125 was withdrawn, and also due to the fact under section 125 CRPC was withdrawn by the respondent wife, and also due to the fact that position of the husband had changed with time, since 6 months had elapsed from the date of filing the application under 125 CRPC. This court in the interim finds it fit to stay the finding of the appellate court with regard to the proceedings under section 340 of the CRPC. Only with regard to, was it initiated?
No, it's not been initiated, but under process.
With regard to the proceedings being initiated or continued under under section 340 of the CRPC till the next returnable date. List this matter after 2 weeks on a date to be fixed by the registry.
2 weeks.
2 weeks.
So
Yeah.
let me request that.
Okay. List this matter after 4 weeks on a date to be fixed by the registry.
Item 7 and item 9.
Yes, Mr. Ahmed?
Yes, came not to right, there was issue. Was taking trial not to rising out of negotiable instrument. Is defaulted.
Okay, you go and appear. Where is the order sheet?
Page 54 is the AGM order. On that day, he filed an application along with legal document that was rejected because the alia also defaulted. That is an accurate fact.
When was the first NBW issued?
That page 54.
Earlier he appeared.
Earlier,
Subsequently,
it was recalled by the trial court itself. But on 15th of 2026, he filed an application along with medical documents. He was suffering from diarrhea. And that was not considered because our earlier conduct was there. That may not be a ground. Because one man may suffer from medical emergency law. Page 54.
On 44, he was also absent, Lordship.
huh?
Page 44.
This was the earlier occasion.
Lordship.
53 is the last order. Prior to that order, he was represented.
Complainant is absent to issue BWA. Then 44 you said. Absent without step, BWA only. Where is NBWA?
Page 54 is the earlier date was on 22/4/2026. That your lordship will find page 6.
NBWA in terms of the complainant is steps for what? What is page 48?
Also for appearing. Terms of-
So complainant was directed
You
to take
can-
steps regarding MBWL.
But when was the NBWA first issued? These are all, oh, acha. What about the earlier orders
Earlier.
That was the MBWL before.
by the same court
That's it.
on his appearance?
But
That's
it,
page 53.
Where is that recalling?
Page 53 lordship that I will see that will make.
Acha, it's reflected there. 53.
He was present there, he submitted his willing to settle the case, and he was granted only 15 days time. Fixing the case on 15/5/26. Down below your lordship will get that 50, and that is the appeal order. That the appeal order was.
But one thing I want to point out, Lordship, paragraph one,
Wait,
two,
wait,
three.
the accused has neither deposited the amount nor is present. Instead is engaged in remain for further time. The counsel has strongly objected by stating that there has been delay. I wanted to regard review. But see, he was, NBW was issued, he
Lordship.
defaulted again. And then he came and said that he will not pay, he will pay. Then again, he is taking grounds that he cannot pay, he is ill and all. So he will keep continuing this conduct, and then again I will tell him to appear, he will appear. He will again say, yes, we will settle. Then again he will abscond.
You made one statement that your lordship can pay 55 continuation of that order. Already 20,000 was directed to pay, you already paid. That also handed over to the complaint. And only on that order dated 15/5/26, on that very day he was medically ill. So on that day could have considered a week cost of, but that has not been done.
But this is complainant shall take necessary issuance of NBWs. Okay, heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. K. Das, learned APP for the state. By this application filed under section 528 of the BNSS, yes, NSS, read with section 442 of the said act, the petitioner has challenged the order dated 15/5/2026, as well as the subsequent orders passed by the learned subdivisional judicial magistrate within bracket M, Bilasipara, in CR NI case number 427 of 2022, by which non-bailable warrant of arrest has been issued against the petitioner for his non-appearance in the said case. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner has presented himself in the initial stage, and thereafter, due to genuine reasons, he could not present himself, and as a result of which NBWA was issued. But when the petitioner appeared later before the court, he was arrested, but the petitioner was arrested on the strength of the said NBWA and was produced, and that the petitioner and the complainant agreed that the matter would be settled and the petitioner would pay the entire amount to the complainant. Full stop. There was an agreement between them, right? Verbal. Acha, it will leave all of that idea that the petitioner had promised to pay the complainant the entire amount which he had taken from him. Full stop. On 15/5/2026, paid to him, and as such, the learned court had recalled the NBWA issued at the first instance. Full stop. The Mr. Ahmed submits that on 15/5/2026, submits that on 22/4/2026, 15 days adjournment was granted on the ground that the petitioner would pay the amount to the complainant within the same. And that adjournment was given as a last opportunity. However, on 15/5/2026, the court observed that in spite of clear directions that the petitioner would pay the amount to the complainant accused, complainant, the petitioner had neither paid the amount nor was present before the court on the said date. Full stop. It was also observed that the advocate appearing for the petitioner had filed an application for adjournment of the matter on the ground that the petitioner was suffering from some ailment. However, the court observed that the petitioner was intentionally delaying the matter and issued NBWA again for the second time against the petitioner and had fixed 29/6/2026 for production and appearance of the petitioner. However, on the subsequent dates, the petitioner again absented himself and fresh NBWA was issued against him. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner had already paid an amount of rupees 20,000 to the court first, which was handed over to the applicant, to the complainant, and that he had all intentions to pay the remaining amount to the petitioner, to the complainant. As such, he submits that the petitioner would appear positively on the next date fixed before the court. Mr. K.K. Das, learned APP for the state, submits that the petitioner has been delaying the disposal of the matter by absenting himself repeatedly from the very first day itself, and that he was, on the first instance, arrested and brought before the court, and now again he is absenting himself. On consideration of the submissions made by the learned counsels, more so due to the fact that the petitioner had made part payment to the complainant, and that he intends to pay the remaining amount to the complainant. This court directs the petitioner to appear before the, when is the next date? 37 is gone.
You will appear within 15.
Within 15 days from the date of the order before the Court of Subdivisional Judicial Magistrate, M. Bilasipara, without fail. Full stop. The petitioner, however, if the petitioner does not appear within the stipulated period, till then, till the petitioner appears before the said court, the NBWA issued against the petitioner be kept in abeyance. However, if the petitioner does not appear before the court within the stipulated period of time, the order passed by the Court of Subdivisional Judicial Magistrate on 15/5/2026, what is that? 15/5/2026 would get revived along with the subsequent orders. Petition is disposed of.
Item 7, after the November share,
Hmm.
will be taken away 2 laws.
Okay, at 2 Monday. But this court is rising, I think, at 3:30, so you come early. Yes. Item number?
Number 7.
7, yes. What happened, Directorate of Enforcement? Root officer. Door number.
This case, I think the order is for us, maybe to do the petition of law. Yeah, what happened?
Let the notice go today.
It's simple, this case is affecting pan India. This case is affecting pan India.
Mm.
we did not find the prosecution sanction. There is an fight is also there. Learned board, we know, has to vote the parliament. The government servant along with the wife also. And there also, 47 years, learned board has fine. In this offering.
Acha, no, what have you challenged? You have challenged the
Order.
what order?
Challenge the order, because in this case, learned board, you know, has opined that the prosecution sanction even later on is a part of the investigation. Which means that it is not a part, it is not a matter to be investigated. So he.
You had given prosecution sanction after cognizance or what?
Yes, can give it lots of.
During the
But yeah, lots of balance, you don't have to find that it is not, it's a part of the investigation. So you have to find, you have to be in the later part also. So that is in the light of the previous judgment also. It may not be correct also. So I mean, it's simple prayer also, the problem cannot be affected. What is going to be there? Even the operation of this order may not be a precedent of other cases. That may be, that order may.
that we will consider during final.
This order may not be precedent for other cases. That is, that I am.
This is an order passed by the which court? Special judge.
Special, but can also we have to.
This will not be considered as a precedent.
Can also is in our cases of it. Why also we pick up the prosecution sanction in every part also knows is yes.
But the requirement is that it should be before cognizance. Cognizance cannot be taken
Oh, yes, cognizance-
without the
but there
prosecution sanction.
Yes, cognizance cannot be taken, yes, that's what I agree. Yeah. Our contention is that.
But in case it is not known whether prosecution sanction is at all required, if it is not in discharge and all,
Yeah, no.
whether 197 will be applicable here.
197 will be applicable. Yes, here our allegation is not in the case of official position. They are saying our contention is that prosecution sanction may not be required. If required, also it can be taken in the trial.
Yes, during the trial.
Very well. So there also, we keeping it, it's just.
Where is the impugn order?
Impugn order is in page number 34.
34. Where is the operative portion?
Also, one more perversity also, I have given the original sanction order to the honorable special judge. I am having the prosecution sanction during the period. Later, operating based on 40, the IU is at liberty to forward the prosecution sanction order complying section 44(1), 46 something like that. So originally is with the court.
Okay, let the notice go. We will consider on the next date. Heard Mr. P. Sharma, learned counsel for the learned standing counsel,
Retainer counsel.
learned retainer counsel.
One that can, if lawsuit can incorporate that part of, that makes, this order may not be a precedent.
This is special judges order are not precedent to other proceedings, not required.
In other cases, while we are filing for the prosecution sanction, in that case, it is affecting also. In other.
You have to follow the law. A special judge has to follow the law. Even in other cases, this will not be considered. Mr. P. Sharma, learned counsel for the petitioner, by this application filed under 528, 438. By this application filed under 438 and 442, read with section 528 of the BNSS 2023 and Article 227 of the Constitution of India, the petitioner has challenged the order dated 9/7/2026 passed by the learned special judge within bracket PMLA, Assam, Gauhati, in special PMLA case number 20 of 2024, arising out of ECIR / GWZO -1/26 2021. Full stop. Issue notice to the respondent. To the respondents. Petitioner to take steps for service of notice upon respondent number 1 and 2 by speed post with AD or by usual process. Scan copy.
Case is over also.
Case is over. Okay. কি করলো? With AD or by usual process. Call for the trial court records in connection with the aforesaid case. Where is that finding? You said during the trial, IO is at liberty to forward the prosecution sanction order.
It's already been forwarded. This is a perverse order.
Acha.
It's already been forwarded. It is in the record of it. That time for 10 minutes. Now, the prosecution sanction is in the record.
Mm.
Then another trial court find that we have to forward the prosecution. Right? This is in the record.
IO is at liberty to forward the prosecution sanction order, complying so and so, and thereafter further process of this case will be started.
Page note 37, ma'am. Page note 37.
Yes. What? 37, which part?
There are 6 logic. The present, it is, the prosecution section order, it is original. It is original is not there. Against the to General Committee Azavika has been paid for the court today directly by learned people. But it was not a two people.
Directly by the learned special PP for ED.
But here's the records will reveal that it was filed by the IO. But here's it's written my name was that is not been contacted in the deliberation. It was filed by the IO. But here written my
Acha, was this case finally disposed of?
Yes, Lord. Even in this case, what is happening, Lord? Operation, here we have seen it.
Why? The last part you see, further it would not be proper to proceed with this case concerning Nasrat so and so, in spite of non-compliance of procedural aspects, without granting of hearing. This is precognizant stage.
No, Lord, we have already, the problem is that we have got this time, let me take 1 minute. We have, the case was prior DNS as well. In that case, Onokali Azurika and his wife is being cognizance was taken. Our contention is that the property which is being is not in his official position. If needed.
Property is a disproportionate asset.
Yes, this
Then?
it's not disproportionate. Here it is not the income which is generated. It's not because of his official position. That was our contention.
So PC Act was invoked.
PC Act was invoked, but here in PNL we are not on that. That his official position was not in. So we have not taken that is a prosecution sanction. Later on, what had happened here, we for the sake of clarity, we gave the prosecution sanction to the public given that option.
What was he? How? In what capacity he was working? He was what?
He was ICP. I think.
And wife?
Like, he has been suspended.
And wife?
Wife, not housewife. And
so prosecution sanction only in respect of PW1, petitioner 1, respondent 1.
But here in learned trial court, both the cases.
It's okay, we will see, there's nothing. And it will not be considered as precedent. These are totally illegal. Okay, you take steps. Right. And then list this matter. List this matter on 17th of September 2026. Oh, yes. Yes, Mr. Bora, you are waiting for which matter? Pran Bora? Bail. Okay, there are few more criminal petitions, motion matters.
51.
Okay.
Supplementary motion.
I think second half. You come after half an hour's time. Okay. I'll come back within. Uh-huh.
The former principal. She was there from 2011, 26.
So she has challenged the charge sheet and the other case.
Yeah. 26, 2011 and in 25, 2018. In that point of time, after she got that office money transferred. FIR were not in. Still find the first FIR at page 28.
28. She was the erstwhile principal of? Retired?
No, she's now presently, she's posted in another department.
Achha.
But I think she's an extension because she's only got 15 days. This is the first FIR.
Misappropriation of money.
Exactly. But there is no allegation against her, man. She is not neither in madam. 5/1/2019, the first FIR. Information regarding use of money hospital and society security for the hospital situation and reviewing by exception of hospital filing the FIR. This to inform
Already the accounts of the hospital, medical society, Silchar Medical College Hospital, Silchar. This the huge amount of money. During the period of the in terms of cash collection, cash disbursement and bank deposit, cash paying carrying MRD collection and collection of various agents. There is why then in the same period, the gross community has been audited, the diet and other materials. And also distribution of diet funds between the Silchar Medical College and hospital Silchar. After the time of defection, we decided that the company higher authority to direct verbally, not in a time accordingly.
So some anomaly in the diet, in the food that needs to be provided to the patients.
The cash for disbursement and bank deposit, that's an anomaly.
But whether principal will be liable for all this?
Now, there is another affair, there is the member secretary's name, that is a case
Okay.
31.
Here, nobody is charged with anything. Only that an in-house inquiry was done and anomalies were found.
I'll show the inquiry report now from the report also.
Ah,
Then it's particularly the second affair, because
Hmm.
both the affairs have been clubbed with the charge sheet, and one charge sheet is
Hmm.
page 31.
31 is same FIR, fifth,
31. The other one will this page 33.
33.
The officer in charge of the police station.
What is her name?
Her name is
Shilpi Rani Verma. This is against A.H. Busho.
Position ex-superintendent
Ah.
and ex-member secretary of the hospital management system.
Hmm.
Now, the hospital management society with the main person is the member secretary.
Ah.
Then the documents of the inquiry internal report.
Achha, I'll just go through this enquiry report of inspection
Inspection of
of the account hospital management society for so and so. During this period, she was the principal.
She was the principal.
Submitted by the director, I do hereby lodge this first and against Busho. So and so for anomaly is doing that in favor. Sorry. But investigation and needful steps. Okay, then.
Page 56.
So this is mostly against Busho.
Position.
Hmm.
And page 56 is the report.
Hmm. In-house committee report,
If that was finance inspection report. She's referred in the
56.
56.
Hmm. Yes. Shilpi Rani Bormon.
She is the principal chief superintendent.
Hmm.
Therefore, she is the chairman, otherwise of the hospital management society.
Hmm.
But the member secretary is one Bush, Dr. Bush.
Busho. Okay.
Then, what you see here is under various heads, things to be discussed.
Hmm.
Neither of these, the petitioner is named, but the member secretary of the hospital is named. For example, page 57, cash book.
Hmm.
The hospital management society, Silchar Medical College Hospital, has 3 numbers of cash books for the period under inspection without any opening and closing balance and signature of video written the member secretary. So medical college. So the member secretary is Bush.
Hmm.
His name is there. Hospital, cash book on 31st March was not closed. So the cash book for the period 2015, 16, 16, 17, 17. At the terms of reference of the inspection are of no use in terms of maintenance of cash book as far as Rule 95 FR. Therefore, proper financial position accounts have not been faced out. This is basically when we got a non-maintenance of cash book. Then we got money receipts and collection fee. Next paragraph.
Wait, one proper financial position of the accounts could not be traced out.
Fine.
Moreover, the cash book has not been closed. Okay, then money receipt.
Money receipts for collection and fees.
Hmm.
Receipt books along with other printing materials of HNS, hospital management society, are printed by the member secretary
Ah.
without taking any resolution to the governing body.
Hmm.
Seal quotations are invited to short tender notice by member secretary, and accordingly the L1 form is selected as the approved fund. However, no record regarding tender committee and minutes and recommendation.
Well, why do they need some other outsourcing what? They have not issued tender and all.
No.
For what? Supply of food
No, this supply, this is with regard to the printing materials.
or printing materials?
Books,
Okay.
Money receipts and printing.
Mm-hmm.
Then when a violation of sanctioning power,
Hmm.
the hospital management society.
But she is the head of the governing body. She is the director.
She is the chairman of the governing body.
Ah.
But here it's no resolution was in fact taken. So
Where?
member secretary on his own.
Hmm.
Then the hospital management society SNCH purchases various articles for running at the medical college. So Rule 15 of the scheme for dereliction of hospital autonomy. Emergency, the member secretary may incur cost of 10,000 for the medical college hospitals. During random checking of vouchers, it has appeared the member secretary has incurred more than 10,000 on several occasions, some instances of violations of sanctioning power are detained.
Hmm.
So it's again against the member secretary.
Everything against Bosho only,
Ma'am,
but how come she was implicated?
exactly, ma'am, the chart, caution not of the chart sheet.
Besides, many cases, the payment to single firm has been split into several parts to avoid sanction of higher authority.
Yes.
So there they need sanction of the higher authority. That was not taken.
Now, what should we see, madam?
Cash payment?
Again, same, madam.
Ah.
Authority sanctions were not taken, my lord. And my lord, whatever was done with the, my lord, if there is an indication, it is going to be member secretary.
Hmm.
Then, my lord, should be the observations at page 60, last of the conclusion.
Hmm.
Well, it has directed lodging of FIR against one Papu Ravidas, was the cashier.
Mm-hmm.
It has directed lodging of FIR
Hmm.
against one Papu Ravidas. Well, lodging will see page, one last
Hmm.
sign.
Hmm. HMS is what?
The hospital
Oh.
management.
Authority.
Recover the defalcation amount of rupees 28 lakhs from the delinquent personnel and file FIR against it. Now, before the prior page, madam,
Hmm.
page 60.
Hmm.
This is Papu Ravidas, madam, against whom the FIR is directed to law.
Where? I'm not getting it, Papu. Acha, Papu Robidas.
Yeah.
He is what?
Statement E, madam, is the cashier.
Cashier.
Does it appears, the page 60, does it appears, that is not correct.
Hmm.
In a single counter, is found the huge defalcation of deposit in interest fund. So it can be ruled, it can't be ruled out of having such a defalcation of fund from other central cash counters. This is highly irregular, and HMS authority should immediately recover the defalcation amount of 28 lakhs so and so from the delinquent person and file a FIR against him.
Hmm.
Government may also take appropriate against the concerned officials for lack of supervision and negligence of things.
There, I think she will come.
There which she may come, but not in the criminal case. First of all, is the charge sheet. The charge sheet is totally vague, by the way.
Okay.
Nothing has been indicated how she is, what role she is played.
Only that she was arraigned as accused.
And it is
Where is that charge sheet?
page.
Oh, yes, yes. During investigation, amalgamation is done. Then
Yeah. Now you can see the prosecution. Page,
this is the nothing much.
nothing. Nothing else.
First, an order for amalgamation of both cases and directed to so and so. Then what are these names? Bhabutosh Roy, Ashutosh so and so? These are what? Witnesses? Witnesses. So address sent up for trial is Aninda Busho, Bidyut Burman, Premananda Singha, Papu Robidas. Where is 5? Only 4.
Only four.
Then she is not there.
Cognizance taken has been-
Oh yes, on bail or
Possible bail. Because
Okay.
during bail also, it was recorded that there was no impunity between against her.
ex-principal,
Ex-principal.
current chief superintendent. What? Ex-principal after that, what is this?
Which paragraph was it?
No, this on bail or recognizance. No, in the first page of the charge sheet itself,
Yes.
where name of the petitioner finds place.
Here, Dr. Shilpirani Verma,
Ah,
ex-principal cum chief superintendent.
come. Oh, chief superintendent of so and so. Bibutus, so many people are involved.
Bhabata Shukla Vaidya, then Kollon Bhattacharya.
Hmm.
Then
So nothing, no materials against her. I mean, in the body of the petition, body of the charge sheet.
and my lord, the charge sheet, my lord, this is the only page for the charge sheet, my lord, must contain, my lord, how, what specific, my lord, overt action is done, my lord. And my lord, this could be very specific as to, my lord,
So, yes, that is the subtle position, but then it's not here.
not there.
What are the Caesar? These any some statements?
The entire charge sheet, my lord, that copy also.
So, a cognizance and all were taken.
Taken.
Where is that?
My lord, we had in fact filed an application, my lord, for, my lord,
What is this judgment that you have annexed?
that is, my lord, with regard to, my lord, no sanction was taken. So we had taken the plea that no sanction was taken, that was rejected.
Why not in official duty?
It has been held, my lord, it is not, my lord, whatever was done, it was not in official basis, that's not the ground taken.
So, no sanction required.
That's also one of the ground, my lord, that sanction is required in this case.
Huh.
Because it's, my lord, the allegations are such, my lord,
Hmm.
the part and parcel of the, my lord, is connected with the official duties, my lord. If at all-
So, have you challenged this order?
So that's why we have, my lord, got this copy.
Here, it's included.
We started watching the entire, my lord, charge sheet, my lord, and taking of cognizance.
So what do you say, Mr. KK does? Otherwise, no specific allegation against her,
But
even in inquiry report.
one point, Lordship, I want to, though her name is not there, as if in the search sheet,
Vision.
Lordship, as she is the super Silpi Das, she is the chief superintendent of SMC.
She should have supervised, or she should have found out herself.
Yes, Lord. Yes, this one allegation,
That is there.
one allegation is there, Lordship. If I look into the carefully, Lordship, in page 57,
57.
57, Lordship.
Hmm. Yes.
May I read, Lordship?
Wait.
Violation,
Huh.
57, Lordship.
Huh.
Violation of sanctioning power. The HMS SMCH Lordship authority. See, that is, she is also the authority because she is the chief superintendent of SMCH Lordship. Authority purchases various
So the HMS, that is
It's SMCH.
Management Society.
Hospital Management Society. Is she a member?
She is a chief superintendent.
She is chief superintendent,
Chairman. Otherwise, she is the chairman.
chairman of the governing body.
Governing body.
But this is HMS.
SMCH Lordship.
Oh,
It's-
SMCH, but bodies will
HMS
be
is-
different with different members.
This is what my learned friend is trying to indicate. This can be adverse and negligence, my lord.
Mm.
But it cannot be an offense, my lord, or criminal offense, my lord. Therefore, my lord, the report says, my lord, that with regard to other officials, you may, my lord, draw up a case of negligence.
No, first of all, make me clear, she is the chief superintendent.
Chief-
What?
Chief superintendent, my lord, principal come chief superintendent, and by default, my lord, she becomes the chairman of the executive committee of the society.
Executive committee of the society.
Hospital.
And HMS is a different society.
Society.
Society. So she is the chief
Chief
superintendent.
superintendent.
Hospital Management Society.
Management
So
society.
authority,
Part of the society.
There is no denial, ma'am.
So
What I'm
every
trying to
de-
indicate, ma'am, is that this can adversely case of negligence, ma'am.
okay,
No,
authority
Lordship.
purchases
No, I have
various-
other points also, Lordship.
various articles for running the medical college as per 15 scheme for delegation of hospital autonomy, such as for emergency purpose, member secretary. This is otherwise Bosho.
Yes, ma'am.
Member secretary may incur cost up to so and so, but during random checking of vouchers, it appears member secretary has incurred more than so and so in several occasions. Violation of sanctioning power by, but everything is against member secretary.
Well, one more thing. I'll just
But
point out.
everything is decided by all the things, Lordship. She is the chief. She has to be approved. Everything has to be approved by her also, Lordship. It is not that
Whether that
everything.
vicarious responsibility will come. Now we cannot, saddle all the responsibilities on our honorable chief minister. There are all heads of departments.
But
They
it
will
has to be,
consider.
but at last it has to go to this chief superintendent, Lordship.
Hmm.
And she has to approve. She has
She
to
has
approve.
to approve.
She has to approve. And she has to verify everything, Lordship. Otherwise she cannot sign.
Yes,
Otherwise there is no value of signing, Lordship.
It's humanly impossible to see each and everything for a principal. That is why departments are
But-
made.
My lord, page
But-
52, my lord, of the delegation of scheme, my lord.
Hmm.
Page 52.
Hmm.
Para 18, my lord. The clause 18, brother.
Hmm.
This is, my lord, the delegation of, my lord, authority, my lord, with regard to how this hospital management society is to be run, my lord. This is issued by the family welfare department, my lord. Now, page 52, my lord, legal procedures. The member secretary shall be responsible person in respect of all legal correspondences and matter of dispute.
Hmm.
So it is the member secretary, my lord, who is the person who is to look after all this, my lord.
The principal as such, she cannot
Exactly,
be.
ma'am. Though she is by default, my lord, by virtue of her post, she is the chairman.
Hmm.
The member secretary, my lord, who is primarily responsible for every activity of the society. Therefore, my lord, her role in the society is very limited. And here the allegations are basically either approval was not taken from her, my lord, or my lord, spendings were made or cash payments were made without, these are all, my lord, other people, my lord. For example, Gopal Ravi.
Acha, if during trial, Mr. Das, if during trial something comes out against her, then there are procedures.
Lordship.
Judge will take recourse to all those 311, 319, whatever,
Lordship.
right? So, as of now, I don't see her responsibility, her
But
misconduct.
Lordship, in quashing, the prima facie has to be established. It is not that Lordship, merits of the
But
case has to
she-
be given.
Who are the petitioner only?
Lordship,
The investigation has ended, charge sheet is submitted.
Lordship,
But who are the petitioner? There is nothing. Even charge sheet, you see,
Lordship.
no material, no averment against her. Right. So as of now, let her be away from the criminal case. Later on, if something comes out, she can always be implicated. But this is harassment to her.
And this to me, the charge sheet contains nothing, ma'am. Not even the iota of a material. ma'am.
Charge sheet, at least it should not be in 2 lines. Okay. Heard Mr. M. Datta, learned senior counsel, assisted by Mr. D. Malakar. D. Malakar, learned counsel for the petitioner, and Mr. K.K. Das, learned APP for the state. By this application, filed under section 528 of BNSS 2023, the petitioner has prayed for quashing of the PRC case number 1871 of 2020, as well as the charge sheet dated 29/7/2020. The case of the petitioner is that case of the petitioner is that she is the principal come chief superintendent of Silchar Medical College during the appropriate time, that is during the relevant time, that is from
15 to 18.
2000.
15 to 18.
Some date is also
You were there from 11.
Huh.
11 time is 15 to 18. That's all.
from 2015 to 2018. And that an FIR was lodged on 5th of January 2018
And second-
by the superintendent, Silchar Medical College and Hospital, Silchar, Assam, stating in before the officer in charge, Silchar Sadar PS, stating inter alia that audit during the audit done with respect to the during the audit done with regard to the accounts of the Hospital Management Society, Silchar Medical College, it came to the notice that huge amount of money has been misappropriated during the said period in terms of cash collection, comma, cash disbursement, as well as bank deposits. Full stop. It was further alleged in the said FIR that an in-house inquiry was conducted and gross anomaly was detected with regard to purchasing of food and other materials, and also distribution of food amongst the patients of Silchar Medical College and Hospital, Silchar. On finding out the said anomaly, the higher authority of the said hospital decided to lodge the ejahar, and the ejahar was lodged as such, and the ejahar was lodged accordingly. The police, on receipt of the ejahar, registered the case as Silchar Police Station case number 40 of 2019 under section 420/409/34 of IPC. Full stop. Para. It is the further case of the petitioner that subsequent to the said FIR, subsequent to the said ejahar, another FIR, another ejahar was lodged on, what is the page?
17 to 19, 833.
Another ejahar was lodged on 17th April 2019. By 19, she is no longer there in the hospital.
No,
By the new incumbent in the post of principal cum chief superintendent of Silchar Medical College and Hospital, Silchar, stating inter alia that stating in inter alia that during the period 2015-16 to 2017-2018, a report was submitted by the Director of Financial Inspections, Assam, And in the said report, it was revealed that the then superintendent, Silchar Medical College and Hospital, namely Dr. A.S. Bosho, was involved in gross financial irregularities and anomalies. Full stop. On receipt of the said Ejahar, another Silchar PS case was registered as case number. Another case was registered, Bulikwa. Another case was registered as Silchar PS case number 1267 of 2019 under section 420/409 of the IPC. The full stop. The police conducted the investigation in respect of both the cases and by amalgamating the same, finally submitted the charge sheet on 29/7/2020 by arraying 7 number of accused persons and charging them under section 420/409, section 34 of the IPC. The learned counsel, Mr. Datta, the learned senior counsel for the petitioner, submits that in both the first information report, there is no content against the petitioner who was working during that period as principal cum chief superintendent of SMCH. In fact, he submits that in fact in the second Ejahar, the allegations were against the, he was what? Superintendent.
Member secretary, superintendent come member secretary.
A superintendent come member secretary of SMCH, namely Dr. Anindo Sundar Busho. He, however, submits that during investigation, the name of the petitioner was included by the investigating officer, and she was arrayed as an accused in the charge sheet. He further submits that no allegation was made against the petitioner, neither in the FIR as stated above, nor in the charge sheet. Full stop. The learned counsel had also submitted the inquiry report, wherein, where is that report that you have?
56.
Inquiry report, wherein there is no iota of allegations made against the present petitioner. He submits that at best, no, he submits that there was a single line in the said inquiry report, where it is, where it should be under the responsibility. I said,
No, that's not the report, madam.
Ah.
That is in the middle of the scheme of delegation of hospital economy. That is at page, starts at page 35 and is at page 51.
Acha, in the inquiry report, there is nothing.
Nothing. The scheme of delegation.
Acha, where is that? 40?
Page 35, it starts at page 51.
51. This is not the report. This is scheme for delegation.
Well, this is how the hospital management society functions.
Acha.
This is the scheme, madam. Page 52. Membership secretary should be responsible. 18, madam. Legal decision.
No, not this. There was a averment in the, I think in the inquiry, where it is said that 2 words was put, where it is said, at best, the principal will be liable. That is where.
That logic is finding out at page 60, madam.
60.
60.
Yes.
Or 61 also, madam.
This is a part of inquiry.
Pardon.
He submits that there is one single line in the inquiry report which says that appropriate action should be taken against concerned officials for their lack of supervision / negligence in duty. He, however, by placing the scheme of delegation of hospital autonomy has placed, no, he, however, by placing, no, so and so had submitted that under the said scheme, the member secretary is made the responsible person in respect of all legal correspondences and matter of the society. Full stop. He as such submits that there is no misconduct on the part of the petitioner in the anomalies that were found, she being the principal and chief superintendent of the hospital. No proceeding should be initiated against her. On the other hand, Mr. K.K. Das, learned APP for the state, submits
Lordship, I wanted to point out two points. Lordship.
submits that the petitioner, being the principal and
Lordship.
the chief superintendent of the hospital, is in overall supervision,
In the supervision of the
is in overall supervision of the entire hospital.
Lordship. And moreover, Lordship,
And
section.
every matter should be looked by her in smooth functioning of the said hospital.
Moreover, Lordship, section 409
Hmm.
and 34 is also attracted
Hmm.
in section, in Sarcite. So 409 is offense against the officials.
Misappropriation.
No, Lordship.
Breach of trust.
Criminal breach of trust, 409 is there and section 34 is also there. And moreover, her.
To show section 34 is even more tougher.
Lordship,
You see, common intention is very difficult to prove.
Lordship.
Of course, that will be considered during the trial.
In
Why
my
should she
submission
be?
only, my Lordship, it may
He
be.
further submits that apart from the cheating,
Lordship.
the criminal breach of trust, as well as common intention provided under section 409 and section 34 of the IPC, respectively, were also charged by the investigating officer. Charged in the present case.
Lordship, criminal breach of trust by government servant, 409.
By government service. Full stop. He also submits that the aspect of prosecution sanction was also rejected. The aspect of obtaining prosecution sanction in respect of, that is, right? It was rejected. I thought maybe I had seen some other case. Okay, but the aspect of obtaining prosecution sanction in respect of the petitioner was also rejected by the learned session judge on the finding that the said misconduct cannot be in discharge of official duty. Full stop. I've heard the learned counsels and I've carefully gone through the records. It is specifically stated in the FIR. It is specifically stated in the first FIR that an in-house inquiry was conducted and gross anomaly was detected with regard to certain functions that were undertaken in the hospital. And on a bare perusal of the in-house inquiry report, it is seen that no allegations were made against the petitioner. Where is the report?
Page 56.
56, right? In the said report, the Enquiry was also conducted against the petitioner, as she was arrayed as incumbent number 1 in the same, and the period that was considered was from 5th of September to, from 1st of April 2015 to 31st of March 2018. And when the inquiry was conducted, the petitioner was continuing as the principal cum chief superintendent as well as chairman of the hospital. And she was functioning in the said capacity since 1st of September 2011. Full stop. During the said inquiry, the financial anomalies were considered with respect to different subjects. And in each of these subjects, it was nowhere stated that the petitioner is involved with the anomalies that was detected. Full stop. Other officials from the Silchar Medical College and Hospital were found to have involved themselves in anomalies, but not the petitioner. And the anomalies was to the extent of misappropriation, or no, defalcation or what?
Defalcation of funds will be by Ravidas. And
Now, other officials have already stated, no, involves a misappropriation of an amount of rupees 28 lakhs 35,745, and the same was directed to be recovered from the delinquent personals. Full stop. In the in the copy of the charge sheet, in the charge sheet submitted on 29/7/2020, similarly, no allegation were made against the principal, that is the principal come chief superintendent come chairman of the hospital, that is the petitioner. Full stop. In the charge sheet, the investigating officer has simply arrayed the petitioner as an accused person without there being any materials to substantiate the inclusion. Full stop. It is also seen in the instant case that where is the cognizance order? It is also noticed that cognizance were also taken against the petitioner and others by the learned court below. In view of the findings mentioned above, it is therefore, this court therefore deems it fit to quash the, in view of the said findings mentioned above, the charge sheet dated, no, charge sheet, being charge sheet number, what is this number? 386. 386, dated 29/7/2020, is quashed, qua the, QUA, qua the petitioner. Full stop. The subsequent orders passed in the PRC case number 1871 of 2020 is also quashed, qua the petitioner. However, it is stated that if during the trial, any materials are found against the petitioner, the learned court would take proper recourse to law. Petition is disposed of. हाँ, क्योंकि नहीं quash किया ना तो अभी तो छोटा सा ये petition बोले एक ना है bail second half. अच्छा 330 ये तो bench नहीं है. अच्छा खबर लीजिए तो 330 में DB है क्या? 330 में हम लोग डिसाइड किया था थर्सडे को बैठेगा. फिर भी किसी को पूछ के नहीं तो I will start bail in the second half. Okay, what is this matter, Mr. Ahmed?
In this case, the petitioner along with 14 other facing a criminal case. Okay, that case was instituted in the year 2012.
हाँ.
Since then, the case is pending. And during pendency of the case, filed one application before the trial court seeking permission to obtain passport to perform form. And that was not kept in abeyance by the trial court, and therefore he approached this honorable court by filing a the WPC notice that his application was not considered, which violates his right under Article 21. And this honorable court directed the petitioner to file a fresh application with direction to the trial court to dispose of the said application by considering the relevant law. And he again filed the application to obtain passport also and to issue LOC in favor of it. As that was rejected. Against that order, I will before your lordship. Just one thing here, lordship, from the order also I will present your lordship, that the trial court took the view that if I grant the NOC, he will go abroad and will not return. Obtaining passport and traveling abroad. So these are two different. So if the NOC is issued, I will get the passport. Subsequently, if I want to go abroad, I will again have to obtain the permission of the concerned court.
So visa, you have to take the visa again.
These are two aspects. That is not reflected in the order. And
So where is the order?
page 76.
Okay, the matter can be remanded back.
Already it was grounded and only on the ground, lordship may kindly see page 77. That will proceed.
This is the order you have impugned.
Yeah, page 76.
Content will once start to read from the beginning. Prayer of the petitioner. Samimuddin is the petitioner here. Samimuddin to issue no objection in granting limited passport to him by the passport in the used in sessions case number so and so. His passport application was rejected by passport, therefore to obtain NOC to reapply for his passport, he approached this court, but the petition was kept in abeyance by this court. In that view of the matter, Honorable High Court, in that under had pleased to direct him to approach this court with a fresh application for issuance of NOC to grant him. And the old pending case, in the appearance due to absconding of some of the accused persons, and the case is very sensational. He is not absconding, right?
He's not absconding. Even
Where
if
is
he has
he?
also not said that.
Other accused persons are absconding. Where is the case?
There is nothing adverse against him.
Wait 1 second. It is what Okay, so this is the order you have challenged. So you want basically no objection certificate from the court.
Any condition may be put that I will surrender my passport to the court, and whenever I want to go abroad, I will obtain that from the court and travel permission also. Then only I will travel. But
This is a reasonable prayer, Mr. Das.
that is supported by order.
See, the case has been going on since 2012.
Well,
And then he wants to perform Hajj. To let him go, come back. If he dies in the meantime, finish.
But only the thing
Or harsh condition to be put. He will, first of all, no objection certificate will be given, passport will be issued, visa he'll have to again apply. Then he will go. He will come back again, deposit the passport to the court.
Then after obtaining the passport, I will deposit to the court. Whenever I want to go, I will take the permission from the court and obtain the
Okay.
passport.
only one thing, Lordship, in my objection, what I want to try to put my point forward, Lordship. Here the learned trial court has considered two things, Lordship. Nature of the offense,
Mm.
that is 25, Lordship.
Arms Act,
Arms
I've
Act.
seen Arms Act,
And-
murder case is also there,
Yes,
302.
And in the submission, what have the learned APP has stated that, Lordship, on the ground, it is all pending case of 220, which is still in the stage of appearance.
Accused person absconding.
Yes,
That is
Lordship.
why I asked
Out
whether
of-
he is absconding.
Out of 17, Lordship, only 7 are appearing. The rest of the 10s are,
The matter was not filed and the,
it is.
Background of the case is that initially case was filed, investigation was completed, charge was filed. Then informant came before this honorable court with dissatisfied with the investigation. Again, that this honorable court
Further.
directed for further investigation. When further investigation was directed, the accused persons came before this honorable court saying that further investigation is directed, so charge sheet is not there. Accordingly, we are entitled for default pay. So this honorable court granted default pay. Then again, informant came before this honorable court that the default bail cannot be granted. It is continuation of that investigation. So this honorable court cancelled the bail application. The accused persons went to Supreme Court. Supreme Court said that whenever even if you grant bail under section 167(2), then also you cannot review that order unless conditions are violated. So that petition was also pending there, and the records were here. Also. That's
so that amounted to
So
delay.
therefore,
Okay, okay. Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. K. K. Das, learned APP for the state, by this application filed under section 528, read with section 438 of the BNSS 2023, comma, the petitioner has challenged the order dated 27/5/2025, passed by the learned additional district and session judge, within bracket FTC, Sri Bhumi, by which the prayer of the petitioner for issuance of NOC. No. Prayer of the petitioner for giving NOC for giving NOC was rejected. Giving NOC for the purpose of obtaining the passport was rejected. Full stop. The case of the petitioner is that he was made an accused person and the sessions case being sessions case number 182 of 2012 under section 120B/302 IPC, read with section 25 within bracket A-B, capital B, bracket close, again bracket open, small a, bracket close, /27 of the Arms Act was initiated against him and other accused persons. And 14 other. It's okay, others, full stop. During the pendency of the said trial, the petitioner had applied for issuance of passport to him on 13, passport to him, but the same was rejected by the passport authority on 13/12/2023. Full stop. Thereafter, the petitioner approached the Court of Additional District and Session Judge FTC Sri Bhumi for giving him the no objection certificate so that he can reapply for his passport. But the said application was kept in abeyance by the said court. Full stop. Subsequently, being aggrieved, he approached his Honorable Gauhati High Court by filing a writ petition, being WPC number 2097 of 2025. And this court, by order dated 23/4/2025, had directed the petitioner to file a fresh application for issuance of NOC to him for the limited purpose to perform his Hajj. Full stop. As such, the petitioner filed an application before the Court of Additional District and Session Judge FTC Sri Bhumi. Full stop. It is the further case of the petitioner that during the subsequent to the filing of the application. No. It is the further case of the petitioner that he filed a fresh application before the said court. No. Agor line to ki boli golo? I forgot. No. Sri Bhumi. And the said court, after hearing the objection raised by the learned APP, that the case was long pending case and the case has not proceeded because of the other accused having absconded themselves, rejected the said application by order dated 27/5/2025. Full stop. The learned court, while rejecting the said application, had also observed the findings given by this court in writ petition number 2097 of 2025. Full stop. The main ground of rejection by the said court was that the nature of the offense was grave and that some of the accused persons were absconding. Full stop. Mr. A. Ahmed, learned counsel for the petitioner, submits that the learned court had not considered the subsequent exercise that has to be taken once the passport is issued. He submits that after the passport is issued, visa has to be allowed. What visa allowed? Visa issued. Visa needs to be issued by the appropriate authority. And in the same, the specific purpose is stipulated. He submits that the issuance of passport would not mean that the person would abscond by traveling to other countries. Full stop. Mr. K.K. Das, learned APP for the state, however, submits that the case could not be proceeded, which was instituted in the year 2012 due to absence of some of the accused persons, and that the case involved killing of a deceased. Full stop.
Arms Act is also.
Along with the offenses under the Arms Act. I have heard the counsels and I have gone through the records. Achha, this pendency of case is a condition precedent, right? It can be a bar for issuance of the passport under the Passport Act. No, show me the Passport Act. There is a bar, I think.
6-2M.
6-2M. Passport Act is in the Passport Act.
That is not the absolute bar, that is the Supreme Court decision.
Ouch. No, where is what provision you said?
6-2M.
Mila? Oh. Is it quoted here? Where?
Paragraph 21 of the Dynasty.
Six to F.
Page, paragraph 7.
No, I'm taking the act.
That is quoted in 7.2.
6-2F, yes. So refusal of passport. So 6-2F is what? That proceeding in respect of an offense alleged to have been committed by the applicant are pending before a hearing. Other provision of person shall refuse to issue a passport or travel document for visiting any foreign country under clause in and no other on any one or more following grounds and on no other ground, namely so and so. So any rider to this, nothing. If any case is pending, then passport will not be issued.
But there is not a subsequent notification of Government of India is there that I have enclosed in my petition also. That court can grant lordship, that your lordship will find page 63. That rider is given on page 63, the notification, it is part of that, rule.
Where?
Page 63. In my petition also, I have enclosed that notification.
Where is that page?
63.
Where is that? 63, what is the relevant part?
This memorandum, so initially one notification was there, lordship, DSR 57E/7E,
Mm,
date 25/8/1993.
mm.
And there was, these directions were there. Subsequently, it was been amended in the year 2019. That is the office memorandum of 2019. That relevant part your lordship from paragraph 5 onward. So even after obtaining NOC, some other formalities are there that has to be conducted by the passport authority. They have to conduct the verification.
Oh, there has to be a again undertaking.
Yeah.
In all respect, and should mention all preliminary undertaking will have a note. Okay, full stop. The key kolo last order? Of course, full stop. Although under the Passport Act 1967, there is a under the passport, there is a provision under section 6 of the said act. More so, more specifically, under section 6(2)(f), wherein it is provided that if any case is pending against the applicant with regard to an offense alleged to have been committed, comma, before a criminal court in India, the passport authority shall refuse to issue the passport or travel document for visiting any foreign country. Full stop. However, the learned counsel for the petitioner, Mr. A. Ahmed, had placed one notification dated 10th of October 2019, issued by the Government of India, by which it was provided that if the applicant submits a no objection certificate from a court of law in India, and the applicant gives an undertaking and all informations are placed before the before the appropriate authority, the issuance of passport cannot be refused. Mr. Counsel has also submitted a judgment rendered by the Honorable Supreme Court of India in Mahesh Kumar Agarwal versus Union of India, reported in 2025 SCC Online, SC 2887. Which paragraph?
Paragraph 21 and 20.
By which the apex court had held that the person involved in some criminal proceeding can seek renewal of the passport, but he has to submit the passport immediately before the court, right? Before the court.
Obtaining passport and traveling are two different.
To add to this, safeguards and immediate denial of.
But nowadays, renewal and giving fresh passport are same. Full stop. In view of the same, therefore, it seems that there is no bar in issuing the passport to a person who faces criminal proceedings. Full stop. In the impugned order dated 27 5 2025, the aspect of bar to issue a passport to a person who faces a criminal proceeding is not considered. Neither that was an issue for rejection of the application by the applicant. The application of the applicant was rejected only on the ground that the case was grave in nature and the case has not proceeded for long. It will not be out of context to mention herein that after obtaining a passport, a person to travel to other countries should seek a visa, which is again allowed to the person after a thorough inquiry. Full stop. Further, the notification dated, there is no new notification, right, after April? Further, the notification. Hello? Further, where did I keep? Further, it is next. Further, the notification.
Notification also mentioned in that paragraph 4.9.
Judgment of Supreme Court. Acha, where is the notification? Page number?
Page 63.
Further, in the notification dated 10th of October 2019, it is specifically provided that an applicant, by submitting a no objection certificate from a court of law and by giving an undertaking as well as complete information with regard to the pending cases, is allowed to obtain the passport and to travel beyond the boundaries of the country. In view of the same, the court, full stop now, full stop. Further, the finding of the learned court that the case is of grave nature, but it is a well settled principle of law. Cases of a grave nature is fatal. No. Cases of a grave nature cannot be a consideration, since it is a settled position of law that unless an accused person is convicted, he is considered to be an innocent. Full stop. The further finding of the learned court that the case had not proceeded because other accused person have absconded can also be not a consideration, since the petitioner has not absconded and has appeared before the trial court in respect of the said case. In view of the same, therefore, the Learned Court of Additional District and Session Judge FTC Sribhumi is directed to issue the no objection certificate to the petitioner for his submission before the appropriate authority for issuance, for the purpose of issuance of the passport to him. Full stop. It is further directed that the petitioner, after obtaining the passport, will submit it before the said court. And when he obtains the visa to travel to other countries, obtains his visa to perform his Hajj, the same may be given back to him, given back to the petitioner. And after he comes back from the Hajj, he should again deposit the passport to the said court in case the case is not disposed of.
For getting the passport, if he wants to travel at all, that's the order. Because otherwise.
Full stop. The petitioner is also directed to submit an appropriate application before the said court before he travels beyond the boundaries of the country. With this observation, the petition is disposed of. Oh, yes. As such, the order dated 27/5 to 2025 passed by the Court of Sri Bhumi's Additional District and Session Judge, FTC Sri Bhumi, is set aside and quashed. Yes,
Ma'am,
Mr. Bora, I couldn't take. I'll take up.
No, Mala, at 2 o'clock, I have some personal difficulties, Milord. If your lordship kindly take up the matter at 2 o'clock, Milord, I'll be grateful, Milord, because of.
Two.
Milord.
Right at 2. Okay. At 2 o'clock,
My lord knows this case.
Acha.
This is of 2011 case. My lord wanted to dispose this much earlier. And I have taken times on 2-3 occasions by saying that I didn't have the number of petitioner and
Acha.
respondents. And during these months, my lord,
Huh.
I have worked very hard to find out her number and I am now in contact of petitioner, my
Okay,
lord.
okay, we will take it up. What is the item number you said?
You 45, my lord.
45.
Yes, my lord.
Okay, okay. I'll try to take it up. I'll take it.
Yes, my lord. My lord, if it is not being, then at 3 o'clock may take.
Oh, okay, okay, okay.
At 3 o'clock.
Immediately after I finish the bail matters, I'll take it up.
Yes, my
Okay.
lord. Yes, ma'am.
Yes, yes.
Lordship, item number 10, Lordship, I was informed that it will be taken up at 2. So I left for another court, but it was in between, it was taken up. So I'm appearing for respondent number 2. My name may kindly be,
Yes, yes. This was disposed of or what?
yes, disposed
Okay,
of.
item number 10. Oh, Azad Ahmed's case. That passport.
Passport.
Okay, okay. I'll record your name. I'll record it now. Yeah, record. In item number 10.
Item 10.
Okay. Okay. I'll record your name. Any submissions you
Wait,
want
wait.
to put there? Any submission?
At present, it is for the state.
Uh-huh. Okay.
Make clear, lordship.
Yes.
I sorry to make a mention for listing tomorrow. My approach the registry, but they say some difficulty to list in the supplementary list, my lord. And
But
tomorrow is
what
the,
is the urgency?
my lord, tomorrow is the date for evidence, my lord. I am challenging the order of framing charge, lordship. Charge was framed under 489C, my lord. 2 fake currency notes were recovered from my possession, my lord. On that basis, my lord,
What is recovered?
489C, my lord. 2 fake currency note of rupees 500, my
Fake
lord.
currency.
Only two, my lord.
Ajay, you take time there on the ground that you have challenged the search house framing.
Lord, tomorrow is the date.
You adjourn, you take an adjournment there. Okay?
Oh, listen.
Yes? No, she wants to mention something. What?
I want, Lordship, kindly adjourn the matter, item number 47. My senior is not well.
47? You didn't tell it in the morning. What happened?
Oh, he's not well now.
47?
Yes, Lordship.
Okay, on the prayer made by the learned counsel for the petitioner. Petitioner, list this matter on?
Any day, Lordship.
List this matter on 17th of September.
Nice.
Yes, Mr. Bora.
Wait.
Which is your matter? What item you said?
Malad, I am behind the bar, my lord.
Huh.
Today is the 77 days
Huh.
and allegations against me under section, my lord, 316, my lord,
Huh.
5. There is criminal breach of trust by
Government
agent
servant.
bankers.
Oh.
The period of detention is 90 days and now we have 77 days. Now, if you're watching, I was a, my lord, sub postmaster in the Mohana Ghat under the Borbora, my lord, my lord,
Yes, there is there, Mr.
German.
Okay.
And at that point of time, there is a misappropriation of the public money to the tune of about 50 lakhs.
Mm.
Well, at that point of time, one Noyendas was under me who's doing the computers. And in 2023, at page, annexure 1 at page 15, Milord,
Mm.
I lodged a complaint before the Milord, superintendent of police
Mm.
stating all these things, that
Mm.
what has happened. Along with this,
I have given a list of the person from where the money has been misappropriated
Hmm.
by one Noyan Das. my lord. Now, on the basis of which, my lord,
Hmm.
now I being the supposed to be the head of this thing, then there's a, my lord, the department has said that as you are the head of the institution, you are liable to help so and so. Accordingly, you pay us the money of 10 lakhs. That page 99, I have refunded the money of 10 lakhs. My lord, your lordship will find at page 19, my lord.
Hmm.
And I,
Hmm.
19, my lord, to the superintendent of post with reference to the above, I have the honor to submit that I have already deposited so and so as detailed so and so, so and so, so and so. In this regard, sir, I beg to refer my application dated so and so, wherein I have narrated broadly my financial concern and once again beg with folded hands for culmination of the suspension so that I lead a normal life and do with dignity and render my senses my departmented, and for such action I shall even so and so. My lord, on the basis of which that has been revoked and I have been posted at Lokhimpur. Now, while it there, after about 3 years, that is a 26, my lord, page 20, there is an affair which has been lost by the post
Against
office.
you.
My lord, arrested on the basis of, my lord, reporting of fraud cases detected.
Where,
on,
which page?
that is at page 20, my lord.
20. This is an FIR against you.
My lord, not only me, that against many other person, my lord, who has, my lord, with reference to the above subject above, this may kindly be treated as a formal intimation for fraud case detected in Mohanaghat sub, which I have earlier informed, my lord, and I have paid this money to also functioning under a Dibrugarh head office. The case was brought to the light of the month of August 2000 during the reconciliation of the post office so and so saving certificate at Mohanaghat sub post office. During the course of verification and departmental inquiry conducted thereafter, a sum of rupees so and so 20 lakhs, so, 15 lakhs so and so found defrauded and recovery of 10, my lord, correct? This which have been recovered from me, my lord, which have 10 lakhs 84,035 has been made from the identified offenders so far. The Kamal Sakya that the then sub postmaster of Mohanaghat SO, presently working as PRP North Lakhimpur head post office, has been identified as a principal offender along with following co-offenders. So these are the co-offenders, milords. So and so, so and so. Basically, these are the basic allegations against me along with me, milord. And my lord, I already been.
So this 15 lakh 28,000 is more, I mean, apart from the 10 lakh that he has returned.
No, 15 lakhs, what it says, you know, kindly see, a sum of 15 lakhs, 18,000 so and so have found defrauded and left recovery of 10 lakhs and thereafter and a recovery of been flowing the identified offenders.
That means
From me.
only 5 lakhs is
No,
yet
10
to be-
lakhs. Your lordship will kindly see at page 19, which
No,
I
no,
have.
10 lakh he has returned. So
for the-
15 lakhs in total. So 5 lakhs was not taken from anyone.
No, no, my lord. And rest others will not. What mine is that they have others have opposed this honorable court by OFF 438, my lord. And they have been granted interim bail and submitted pending, my lord. I am, my lord, in jail for 77 days, my lord. Now, my lord, whether my custodial detention is necessary for the purpose of investigation or not, your lordship has to look into, my lord.
Yes. So yes, the fraud was actually of a distant time. It was
23.
detected in 23. And then 10 lakh was taken from him. And now again, after so many years, 3 years, they again have conducted an inquiry.
My lord.
And then they found 15 lakh.
My suspension was revoked, my lord, after I pay, my lord. Then I have a posted, then again, formal FIR has been lost and I have been arrested, my lord. My lord, I am not on that, my lord. My, say, 77 days I am there, my lord. Whether
Did you admit that 10 lakh defrauding was done by you?
No, my lord, I have not, what it has been said from the DPO, what my instruction is there, that you pay the amount and we'll recover that
From the hearing.
then I will, that was the thing, that is because of what, my lord, I pay this one. My lord, now it is a matter of, my lord, so a bail is concerned, my liberty is concerned, my lord. I am not on that, my lord, 77 days I am there in my judicial custody, my lord.
Now, investigation is almost complete, my lord. The whether my
So he only had actually initiated the entire case.
Yes.
He had given the complaint that this fraud has taken place. And then now he is forsook.
Yes.
Money
No,
was also taken from him.
Oh, well, my
He
lord,
cannot be stated to that smart that he was the criminal and then he is.
yes.
So what does the case diary say?
Istari says, my lord, against him, my lord, there are so many, my lord, incriminating materials, man, because he forged the signature of my lord account holders, and it is my lord siphoned to some other accounts, some of his relatives. That is there, my lord. And my lord, in 2020, it is my lord FIR filed by the petitioner, my lord. There is everything is there, my lord. That under his guidance, some subordinate employees has done. So, my lord, he cannot escape from his responsibility, my lord.
He what? He said that I had instructed them to do.
Yes, my lord. In
No,
2020, kindly have a look at.
I worked as so and so with
Yes.
heavy workload, accommodating office, law and duty, so and so
Yes.
had computer knowledge and helped me. He also helped me in manual paper, all
Yes.
computer okay.
Yes.
Recently, I am informed by department some irregular transaction was made
Hmm.
during that tenure. Then I could know that Sri Naran Duty hacked official user and password and committed forgery in transferring money from various accounts to his own family members and cheated the party. He is so expert that he misused ID, committing fraud, account of his wife. So he had leveled every
Yeah,
allegation
everything
on not
to Naranjati Das. So Naranjati Das, but
Yes,
Naranjati Das is subordinate officer.
such type of forgery can be done only by an experienced cyber. No, he had not implicated himself. He said that he is okay. He is the computer person.
Yes.
And he did that. Okay. Heard Mr. P. Bora.
My lord, kindly on length of detention, my lord. Length of detention. Otherwise, my lord, on merit, my lord, there is some.
Okay.
Today is 77 days, my lord.
I'll write your objection. Heard Mr. P. Bora, learned senior counsel, assisted by Miss K. Bhattacharya, learned counsel for the petitioner, and Mr. B. Bonkim Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Dibrugarh Police Station case number 40 of 2026, registered under section 316, within
316
bracket 5 of
Right.
the BNS 2023. The FIR in connection with which the petitioner was arrested was lodged on.
11/6/2026.
No, where is that?
That is the first page, page 2, below. I have stated 11.
No, where is that FIR?
Oh, FIR that is at page below, 20.
20, yes.
Page 20, the FIR.
Left.
Annexus 3,
In connection with, he was arrested, was lodged on 12 of February 2026 by 2026. It was lodged by whom?
Prasanna
Yes,
Kolita,
lodged by one.
Prasanna Kolita,
Prasanna Kolita,
Inspector of Post,
Dibrugarh
Dibrugarh
Subdivision,
Subdivision,
Dibrugarh, stating inter alia that in the year 2023, a case of defraud was detected. At Mohanaghat Sub Post Office. Full stop. It was alleged that verification and inquiry was conducted and a sum of rupees 15,28,596 was found to be misappropriated. And out of the same, 10 lakhs 84,035 has been recovered from the identified offender, that is the petitioner. Full stop. It was further alleged that one Kamal Soikia, the then sub-postmaster, Mohanaghat, was identified as the principal offender along with other co-offenders. And therein, 4 of co-offenders were named. Full stop. The learned senior counsel appearing for the petitioner submits that initially it was the petitioner who had informed about the misappropriation of money in Mohanaghat sub post office while he was working as the SD what?
As sub post officer,
As sub post officer
postmaster.
Post.
or as sub postmaster. And the said information was given on 12/10/2023. And that the petitioner was put under suspension. And for revoking his suspension, he, although was not involved in the offense, gave rupees 10,84,035. Full stop. He as such submits that it was not, he was no way involved in the said offense. Mr. B. Sharma, learned APP for the state, however, submits that there are statements made by the independent witnesses that that while the petitioner was working as the sub postmaster, his juniors involved themselves in misappropriating the said amount of money. Full stop. Upon consideration of the submissions made by the learned counsels, and more so in view of the long detention of the petitioner, and also with regard to the fact that it was the petitioner who had first intimated the police authorities about the said offense, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount, same date enough. To the satisfaction of
Chief Judicial Magistrate.
CJM, Dibrugarh.
Dibrugarh.
Under the following conditions. Okay, he will appear before the court. Charge sheet is not there, right?
No.
He will appear before the investigating officer as whenever he is called. Arrest, influence, temper, hamper. He will not leave his place of residence without the permission of the investigating officer. Petition is disposed of.
I'm obliged.
Yes. Case date is there. Oh, actually, okay.
Last time
Hmm.
called for
Mhm.
scan copy.
Yes, where is the FIR, Miss Sultana?
Annexure 1B, my lord,
Page
page number 13.
13. 13
my
is the
lord.
forwarding report.
Yes, forwarding report, my lord. Here, background of the case here, my lord.
Okay, I'll just reading it. Actually, I said it.
I am going through the 6-4 background of the.
He did not die, right? He had suffered.
Later
injury.
he was died.
He died in the hospital.
He's
in the
still in the hospital. No.
No, madam.
How many days he was there? What are the
And
injuries?
15 months, my lord.
Huh?
He is in the custody in 15 months, my lord. And trial is going on.
Hmm.
Earlier bail petition was approached to the session case number 9925 in the Court of Session Judge Jorhat, and it was rejected on 29/1/26.
Where is that order?
Order is
Got it, I've
annexure
got
3
it.
in page number 22.
No reasons as such. Okay. What are the materials?
Material, my lord, there are 9 witnesses in the search sheet, my lord. And out of the 9 witnesses, my lord, 5 have already been examined, my lord. Now, my lord, PW5, my lord, sees the.
Trial is going on.
Trial is going on, my lord.
Oh,
PW5 is the eyewitness, my lord. So she is implicated, my lord.
the
And-
informant. No.
No, she is not informant, my lord. She witnessed the incident, my lord.
So 5 is yet to be examined.
Five is yet
Eyewitness.
to be examined, my lord. 5 were examined out of 9.
So eyewitnesses were not examined.
Eyewitness is one of the eyewitness, my lord. Other informant is examined, my lord. Then victim wife is also examined, my lord.
Eyewitness was not examined.
The other witnesses are pending, my lord.
He has been inside for
15 months, my lord. At the time of filing, 14 months is over, my lord.
15 months.
Yes, ma'am.
And what about injury on that person?
He used, my lord, this one, the catapult, my lord.
Catapult?
Yes.
That we hit
That-
the birds.
Yes, my lord.
Yes, my lord.
I
He
mean,
hit
what is
him.
the injury?
In the head, my lord.
Head. What, grievous, simple?
No, that is not mentioned, my lord, in the
Injury report is not there.
postmortem report is there, my lord, in the scan copy, my lord. He
Achha,
died,
sir.
my lord, as a result of, my lord, head.
Oh, he
injury.
died?
Yes, my lord, he died, my lord.
Oh, that is not there in this. Oh, he
In the
died.
charge sheet it
He
is
died.
mentioned, my lord.
How many accused? Only one. Only this one.
Only one, man.
Concern.
Accused.
Witness.
Witness examined 5, my lord.
Witnesses.
Accused is only, he is the only accused person, man.
My lord, there is no any criminal intention, my lord. Actually,
But he hit from the backside. And after so many hours of discussion with the informant's brother, with the deceased.
Yes, my lord.
No, yes,
The
informant's
accused-
brother.
The victim went to the accused house, my lord,
Ah,
to consult about
he-
their business transaction with the brother of the accused person.
yes. So it went to the house of Sujit Gogoi.
Yes.
Okay, and discussed with Sujit Gogoi about work.
Mm.
In the meantime, younger brother of Sujit Gogoi, Rajiv Gogoi, dealt an blow on from the backside with a catepa.
Mm.
Catapult. No,
Catapult.
catepa and catapult are different, I
Same,
think.
same, man.
Same.
Same.
With a catepa.
We call it catepa, my lord, but here it is
Actually,
meant of
That means he hit with a stone or
Yes,
what?
Yes, stone, man.
Actually,
Stone.
catepa is used for to deprive the crows or
Or
birds from
catapult.
catapult. Yes.
It's
Actually-
English, it is called catapult.
Catapult.
But the fact remains you had hit him by the stone by using a catapult.
Stone
And
is
then
used, small stone is
who was
used.
the eyewitness here?
My lord, PW5, my lord.
He is Sujit Gogoi.
No, Sujit Bina Gogoi, my lord.
Bina Gogoi.
It is
Was she
available in
there?
the scan
Bin-
copy of the record, my lord.
Bina Gogoi is her wife of whom?
No, she is not the wife of the informant, man.
But then there were only 3-4 persons when the incident took place.
That, my lord, her statement may be produced, my lord.
Rajiv Gogoi. Okay, heard Mr. B.R.A. Sultana, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Morioni PS case number 53 of 2025, registered under section 109 slash within bracket 1 slash 117 within bracket 2 of BNS 2023. 109 is what? Culpable homicide.
109, but initially, my lord, it was registered under section 109, my
Culpable
lord.
homicide
109
not
is what?
amounting to murder.
Attempt to murder.
Attempt to murder. Later on, 103 was added.
Added, man.
This murder not amounting to murder actually.
Right to negate.
103 was added or not?
It is added, my lord.
But in forwarding report also, it's not there.
My lord, Lordship may peruse page number 20, my lord.
Hmm. 103.
Page number 20, my lord, down part.
Okay, huh, so and so. The copy of the FIR is not annexed here. The prosecution story is that on 6/4/2025, when the complainant's elder brother went to the house of one Sujit Gogoi, and were discussing about work, the younger brother of Sujit Gogoi, namely Rajiv Gogoi, the petitioner, hit the deceased, that is brother of the informant, from the backside with a catapult, CATAPULT, with a catapult. Full stop. It was further alleged that as a result of the said hit, the injured was taken to the hospital, and that, when did she die? Any idea? And that during the treatment, he expired. Ms. B.R.A. Sultana, learned counsel for the petitioner, submits that the petitioner was arrested on
27/4/25.
27/4/2025, and that it is almost 15 months that the petitioner has been inside the jail. She submits that although the trial is going on, but 5 more witnesses are yet to be examined. Four. 4 more witnesses are yet to be examined. She as such prays for bail on the ground of long incarceration. Mr. R.J. Borua, learned APP for the state, however, on perusal of the trial court records, submits that there is an eyewitness in the instant case, and the said eyewitness is yet to be examined.
No, examine is PW5, my lord.
Fine,
One is
examine.
examine as PW5, my lord.
What did she say?
Other, my lord, that is in the scan copy of the record, my lord.
I saw one day.
She has also proved her 183 statement, my lord, wherein her statement recorded, my lord, after the incident. Scan copy of the scan.
No, he submits that there is an eyewitness in the instant case, and the same was examined as PW number 5.
Sujit Gogoi is yet to be examined.
No, she is not an eyewitness. She heard.
No, my lord, but her statement, it was, her
Next,
statement was
the
put to
accused
her.
again threw another stone with the help of the awaited Amarjyoti Gogoi.
Her statement also exhibited, my lord, as an exhibit 3, my lord.
After few days of the incident. Acha, okay. No, this is contradicted. Her statement is full of contradiction. She
But,
did
my lord,
not.
She has proved, my lord, exhibit 3, my lord. Exhibit 3, her.
Exhibit 3 is a 164 statement that at best it will corroborate, and it has not corroborated. She had not said that I have seen.
But still, my lord, one witness is yet to be examined, my lord, Sujit Gogoi, my lord.
Huh?
Sujit Gogoi is not yet examined, my lord.
He is also an eyewitness.
My lord, as per the search sheet, my lord.
Full stop. Eyewitness. He submits that there are eyewitnesses in the case. And that one of them was examined and the other one is yet to be examined. Full stop. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that the alleged eyewitness who was examined as a PW number 5 had did not state before the trial court that she had seen the incident. This court, along with the fact that the petitioner has been inside for 15 months, this court deems it fit that petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the session judge. To the satisfaction of?
Yes, session judge.
Session judge what?
Session judge Jorhat.
Satisfaction of? Session Judge Jorhat. Under the following condition. The petitioner will appear before the court on each and every date or baki. Huh? Petition is disposed of.
May please, your lordship.
Yes.
This is regular bail application.
Case diary is there.
Case diary is not there, lordship.
My lord, in this case, my lord, case diary not received, my lord.
Are you oh no, BA.
Lordship, from the last 2 occasions, case diary was called for, but the.
I'll give him a short date,
My lord,
otherwise
in
case
this
diary
case,
is
my lord,
called.
I don't know what 25 searches submitted, my lord.
Oh, charge sheet submitted?
Yes, ma'am.
Okay, you try it there. If you don't get, come there, come here. Okay? Heard Mr.
Yehuda.
J.
Yehuda.
A. Huda, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Mr. Borua submits that the charge sheet in the instant case has been laid. White charge sheet number
223/2026, dated 28/2026.
As such, the learned counsel appearing for the petitioner submits that he be permitted to move the appropriate application before the concerned court. Prayer is allowed. Matter is closed.
Item 26 and 2. 26 and 2.
Case diary is received in respect of 26. Item number 2 is connected.
Forensic report was called for in the last application.
Acha.
Petitioner,
Acha,
two
what happened?
petitioner before lordship, they are in custody for last 52 days. Madam.
Acha, 26 I'll take up first.
Yes,
26 is BA. How many are there? Two.
two.
FSL report is here.
But FSL report is pending, my lord. Otherwise, my lord, there are sufficient materials, my lord. This is related to, my lord, FICN, my lord, fake Indian currency note, my lord.
Yes, madam.
And it is recovered from their possession, both the accused person's possession, my lord.
Madam, other.
So let me
petitioner,
complete,
madam,
please. Let me complete.
But FSL has not been received.
FSL is not received.
FSL to what extent? To what effect?
FSL, my lord, that whether the currency notes are, my lord, actually, my lord, fake or
Fake
not.
or not?
That, because it is, my lord, from the prosecution side, my lord, it is fake currency, my lord, but it has to be ascertained by the FSL report, my lord.
Without the same, can it be taken up?
madam, only, my lord, they are in custody for 52 days, my lord.
Mm.
Lordship was granted to the other bill, accused, my lord, on. In fact, on 28/7.
Interim.
No, they were in custody, they have been released on bail. Altogether, 10% were arrested. 4 of them, they were enlarged on bail by the magistrate, my lord. Lordship was granted to 4%, my lord.
Mm.
2 are in inside, my lord, now.
My lord,
Yes,
regarding, my
custody-
lord, other accused person, my lord, madam,
May
are-
complete. My lord, 52 days in custody, my lord. In my respectful submission, that investigation might have been completed by now, my lord.
investigation is not completed, my lord, because, my lord, from the other accused, lordship has granted bail, my lord. But there may not be any
That is
recovery, my
on
lord, from
record.
their position. my
That is on record.
But
Acha, in these
as far
cases,
as
recoveries were not
No.
there from their
No,
houses. In your case also.
Yes, no, my lord. From the house of these 2 petitioners, there is alleged to have been recovery. my lord.
So here, of course, there was no recovery on
there is
that
no
aspect.
recovery, that is my submission, my lord. So my submission, lordship will fix a short date, my lord, we'll
Yes.
call for the FSL report, my lord.
My-
Heard Mr. P. Hajarika, learned
My lord,
counsel.
regarding the item number 2, my lord, what I beg to submit, my lord. This case diary was forwarded to us, my lord, on 6th of August this month, my lord.
Mm.
This case diary forwarded.
Let me
And
submit
since then, my lord, it is lying before this honorable court, my lord.
Mm.
Now, my lord, this accused person, he was arrested on 7th of August, my lord. So there is nothing in this record, my lord, as per his, why this accused person was arrested, my lord. For this, my lord, we require to, my lord, update the case diary, my lord. So lordship may fix both the cases together, my lord. Just after 10 days, my lord. We are just
Acha,
staying for 10 days.
Express 26, okay, right? Heard Mr. P. Hajarika, learned counsel for the petitioners, and Mr. R.J. Borua, learned APP for the state. Mr. Borua submits that although the FSL report was called for by this court, but then the same is not available, and as such has prayed for some time. To place the same, prayer is allowed. List this matter on 3rd of
Just after 10 days, my lord, we are praying, my lord.
10 days.
Yes.
8th of September, Tuesday, Mr. Hajarika, 8th of September 2026. Okay, BA reh gaya. And what about item 2?
Yes, Lordship, can I peruse Lordship, this is the FR on page 17, Lordship.
This
Yeah,
has come
Lordship.
up for the first time.
Yes, Lordship, for the first time.
Money recovered from his place.
Let me submit, Lordship.
Acha.
Here,
That
Lordship,
means
can
yes.
you see the, as per FR, Lordship, can you peruse the FR first,
Mm.
Lordship?
Mm. Where is the affair?
Paragraphs, Lordship, page 17, Lordship.
Acha, acha. What is the
Some
name?
persons were named
Rally.
in the FR. In association with them, some other persons were named in the FR, Lordship. They were arrested, Lordship, recovered specific from one person, Abdul Razak, Lordship.
Acha, wait. Reliable information was received that Abdul Razak, you are there.
No,
Your name
I'm
is-
not named in the FR, Lordship.
Not named at all.
No.
Fake Indian currency note were operating a well-organized, active nexus with the following persons. You are not there in the following persons also.
Lordship, can you say, here, Lordship, case was registered on 7/7/2026, Lordship.
Mm.
There is in the FIR, Lordship, nothing is mentioned about this present petitioner, Lordship.
Okay, I'll
In-
just read it. Wait, it is
Yes.
further the above mentioned accused person had an involvement in the they are already they are allegedly manipulating fake Indian currency What are the names of this? Abdul
Uh,
Razak. Okay, Abdul Razak though.
Yes.
No, according his case. Abdul Razak money was recovered. And the other person is Motibur.
Yes.
Oh. So okay. From them.
I am is
Suspect-
Sukur Ali, Lordship.
Uh-huh. Where in presence of the description of so and so. Searches were also done residents of remaining accused person have no for concealed and removed if it I have excused the commission of problem offense relating to manufacture possession and Okay, your name is not there then?
Yes, then kindly come to the forwarding report, Lordship,
Mm.
that is on page 19. Lordship.
Yes.
He was arrested on 7/8/2026.
Mm.
After 1 month of this arrest of the first FR named person. Lordship.
So 7, 8. On
Yes.
what basis? Some statement of co-accused?
Yes,
what?
Lordship, that on page 20, Lordship, ground of arrest is there, Lordship. Paragraph, page 20, paragraph number 4.
Huh.
After 1 month of the incident,
We
Lordship,
recovered
this
it
27,000 has recovered from this present petitioner, Lordship.
No, where is your name?
Name is not there, Lordship.
No, this is your forwarding report.
Yes, Lordship.
What is
But
the,
he say he's, can you
from
come,
his possession?
from his position?
In circulating FICN amount to cheat and deceiving persons as genuine and so and so. But in
That
your case also FSL
Lordship,
report will-
calculation,
And not
my
only
part
that,
is not there, Lordship.
27,000 was recovered from you.
Yes, Lordship, 27, Lordship, case was registered under organized crime, Lordship,
Mm.
as well as section 180 BNS, Lordship. Can you peruse the 180 section, what 180 BNS says, Lordship,
180?
of the BNS, Lordship?
What's the best? BNS. BNS. What were you? 180.
Yes, Lordship, 180.
The case is registered under 180.
The, other section is there. So far, against this petitioner, Lordship, at best 180. But 180 will not be applicable in this case also, Lordship. Can you peruse the-
Whoever has in his possession any forged or counterfeit so and so having reason to believe forced. But money was found from him.
Intent to- Lordship, what depends, whoever has in possession any forged or counterfeited coin, stamp and currency note or banknote, knowing or having reason to believe that same to be a forged or counterfeited and, Lordship, and intended to use the same genuine. Where is that part, Lordship?
No, but
is
that
not
part is there. He
But-
is
but I have
circulating.
not intent to use, Lordship. That money was recovered, Lordship. The allegation is on 1st July, Lordship, 7 July. Subsequently, he was arrested on 7th August, Lordship. Now, had it been in the group of that, Lordship, affair named person, you would definitely, Lordship, conceal this money, Lordship. Had it been in his knowledge, because some of the
If
is
he will
organization.
never be arrested, it will never be known to the
But,
police.
Lordship, subsequently, it's a make.
But see, this is suspected to be FICN. So let the
That was
report come.
in possession, mere possession, Lordship, only once it will applicable against this petitioner, Lordship. There is
He-
statutory
he
period
involved in
60 days, Lordship.
Circulating the
That
FICN
part is
amount.
not there, Lordship. Circulating part is not the
No,
intent
it
to
is there in item in paragraph number 5.
during the,
No, the accused person, that means he
accused person is arrested for involving in the
circulating.
cheat, what is that, lordship, cheated part, lordship? Whether person has any complaint against this petitioner, lordship?
So
that is
those are
there.
not there, but then you have been circulating that
That
amount.
was not there. Money is with this petitioner, lordship. How it can be circulated, lordship?
Oh, it's
Had it been
written,
his
he's
knowledge,
involved
lordship, because it was only mere possession of the fake currency, lordship. It was not used, lordship. It was
I'm not
used.
understanding when it is written that it is in, he is circulating, so it is being used.
Circulating means it is kept, it is found in his house, lordship. If it is
For
assumed that
what
it's an
purpose?
FIR, lordship.
Are he
Had it
just,
been- lordship,
I'm not,
mere-
maybe I'm not able to understand, or you. During investigation, a total of 27,000 suspected to be FICN were recovered from his possession.
Yes,
Fine,
lordship.
only
That-
possession.
Yes, lordship.
Second, it comes, the accused person is arrested for involving in circulating the FICN amount.
Lordship, that is how, lordship, it is come to his position. Kindly peruse, lordship, paragraph 4 in my petition, page 5, lordship.
That is your pleading. You
Yes,
can
Lord.
have hundreds
Because
of
the
cases.
person who knows it, lordship, he has given, he has put that amount, lordship, in the bag of this petitioner, lordship. That I have
That is
stated,
for the, that is,
particular person name I have given along with all the address, lordship. He is the mastermind, lordship. He in the group of that person, lordship.
that, then in that case, okay, let the updated case diary come. Right.
Short date because, lordship, 20
No,
days, 60
already-
days is.
But already fixed on my lord on 8th of September, my lord. So both the matter may be taken up together, my lord, on 8th.
Mere position, lordship, it's doesn't.
Again, you are harping on mere possession. He is arrested because of circulating.
That,
Circulating means what? He is using, he is giving it to the public.
but it was not in the FIR, lordship, against him, lordship.
Later on, it was found out.
Later on, it
During investigation, it was found out.
was, lordship.
There are gang of persons. So you cannot say that it is only possession. He is using also. According to the grounds of arrest. Now, those may be incorrect.
But using part is not, because that amount. is-
Circulating means what?
Definitely he intend to use, lordship. But,
Circulating means he's giving to the people.
but it was not, lordship, given to anyone, lordship. It is found in his house, lordship.
He said that it is circulating. He's involved in circulating.
That is the statement of the IO, lordship. Because it under
We are
police
in the
custody,
statements
lordship.
of IO only now. Trial has not started, that we
Yes,
go to the court statement.
One thing, lordship, I appreciate, had it been involved, lordship, you would have definitely consider that amount when the other person was arrested on the day of FIR, lordship. Probably-
Money is a dangerous thing.
Yeah.
They will, they cannot stop from using it. Okay, heard Mr. B. Chaudhary, learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Mr. Borua submits that the case diary has been retained in connection with the in the connection with the present case, wherein so many accused are involved long back. And the allegation against the petitioner does not find mention
My lord.
in the said case diary. As such, he submits that he be permitted to get the updated case diary.
My lord.
Full stop. Prayer is allowed. List this matter on
889, my lord.
8th
Along
of
with-
September,
along with BA number 2085, my lord.
along with, okay,
BA number.
8th of September 2026. There is a further prayer that the instant application be listed along with BA number
My lord, 2085, 2026.
2085 of
2020.
2026. Full stop. List accordingly.
Obliged.
27, my lord, case diary was called for not received, my lord.
27
Two
years.
dozen cases was called for, and today is my 63 days, my lord.
Today is how many days?
63 days, my lord,
63.
my lord.
90 days is the offense.
Yes, that is there, my lord, but all the articles have been recovered, my lord.
Since the case diary is already called, heard Mr.
Yes, sir, Ahmed.
H.R. Ahmed, learned counsel for the petitioner, and Mr. R.J. Borua. Mr. Borua submits that the case diary has not been received and has prayed for another date to place the same prayer is allowed. List this matter on. Two
Madam.
times it had not come. List this
On-
matter on
On 7, my lord.
7th of September 2026.
Obliged.
May I please, Lordship? My lord, this is regular bail application, my lord.
Case diary there.
Petitioner-
diary is same, my lord.
Petitioner number 1 is the husband, petitioner number 2 is the father-in-law of the deceased, my lord.
Acha,
The FIR is at page number 9. So far, the FIR, my lord, there is no any dowry demand, no torture.
Umar Farooq is the, and
Husband, my lord.
Rahim Badsha is father of,
Father-in-law, my lord.
father-in-law of Umar Farooq.
Deceased. Yes, my lord. Rohim Badsha is the father-in-law of the deceased and Omar Farooq is the husband of the deceased.
Where is the FIR?
Page number 9, my lord.
She died.
My lord, she died. She has committed suicide, my lord.
What about Kulsum Nessa? No bail.
No, my lord.
No bail application filed for Kulsum.
Yes, my lord.
The mother of the petitioner number 1
My lord.
was not arrested.
No, no, my lord.
Okay, what is the, what are the
My lord,
materials?
we have received the case diary, my lord. But since the case is, my lord, registered under section 103 of the BNS, my lord. So, my lord, the postmortem report is important, my lord. But in this, my lord, case, my lord, postmortem report is yet to be collected, my lord. So, the
Mhm.
may I submit, my lord, some time may be granted, my lord, so that we can obtain the postmortem report, my lord.
What did the witnesses say?
Witnesses said, my lord, there are some physical and mental torture, my lord. They have heard also.
On the
my
day of
lord.
occurrence, nobody has heard, seen anything.
My lord, nobody has seen, my lord, because, my lord, the incident in the morning, my lord, she was found hanging, my lord. But there are some mental and, my lord, physical torture is there, my lord. This is-
Okay,
FIR
heard
also
Mr.
silent.
A. Paramik,
Can I
learned
pay for
counsel.
petitioner number 2, my lord?
Huh?
Both the case, my lord, both the bail application may be both the
Nothing
petitioners.
said in the FIR.
My lord.
Only that he was married,
My
that she
lord.
was found dead.
That-
So we need some more materials. We cannot say. So okay, heard Mr.
So,
A.
my lord, I am
Paramik.
paying for your petition number 2 for the father-in-law, my lord. To bail.
We'll give you a short date. We get the FSI, get the postmortem report. Mr. Borua,
My lord, yes, my lord.
when can you get it? As early as possible.
Yes, my lord. This is from my lord, Nogarbara PS, my lord. So, my lord,
Third,
we'll fix it on 7, my lord, 7.
7, so many
This
cases.
is so my lord.
Third, try it on
Next Thursday, my
next
lord.
Thursday, third.
My lord.
My third then.
Or you get contact the people with telephone.
My-
By telephone. Otherwise, writing and all those will take time.
My lord.
Heard Mr. A. Paramik, learned counsel appearing for the petitioner, and Mr. R.J. Borua. Mr. Borua submits that although he has received the case diary, but the postmortem report is not with him. He has such prays to place the same. Prayer is allowed. List this matter on 3rd of September 2023.
Halim.
On which date Mr. Borua would place the postmortem report.
My lord.
Halim.
May I please, Lordship? This is regular bail application, Lordship. Here in this case, Lordship, the present petitioner is a driver of a truck, Lordship. And-
Case diary is here.
Case diary not received.
And Lordship, for a moment, Lordship, there is nothing, a driver, Lordship, kindly for a moment.
But then see, bail application, case diary is called. Now, leaving everything aside, I'll give you
Lordship,
bail.
at
That's
the-
not
Lordship,
done.
And some betel nut is, bag has been stolen by,
It's okay, we
hijacked
will
by
give-
someone, Lordship, and already been recovered on the same day, Lordship.
No, you should have got that bail on the very first day itself. Case diary is called. Let me see.
I'm 30 days in custody, driver, Lordship, but
When can
otherwise,
you place it, Mr.?
betel nut is recovered from the other person.
My lord, on third, my
There
lord.
is nothing.
Third, next Thursday. Heard Mr. M. Hawk,
F.
learned counsel F, right? F. Hawk, learned counsel for the petitioner, and Mr. R.J. Borua. Mr. R.J. Borua submits that the case diary has not been received. And as such, prays for a date to place the same prayer is allowed. List this matter on 3rd of September 2026. Case diary is there.
Case diary received. my lord.
It is there. It
It is received, my lord.
is.
May I please, Your Lordship? Here in the petition number 1. Petition number 1, he is running a dam, Your Lordship. At
One
two-
second. Where is the FIR? There are two petitioners, Amar Ali and Sofiq Ali. Where
Yes,
is
13
petition?
Your Lordship.
Hmm?
Yes, 13.
Page 13?
Yes.
One second, I'll read it myself. Okay, then,
Herein the allegation is only regarding theft of power cable and 7 lights here.
mm,
And
in the
second part-
bridges.
Yes. And second part of the allegation is that the miscreant entered into the premises of the informant and caused damage to some device here. Only this much is the allegation. But based upon this allegation, the shop of the petition number 1 was charged, and thereafter 4 kg wire was recovered from the shop of the petitioner, which is approximate value was 2,000 rupees.
Was it stolen from that bridge, construction site?
No. The petitioner, he is the owner of dam, your lordship.
So those were for,
Useless, your lordship, wire was recovered from the shop.
then,
And for it, your lordship, this 2 person behind the bar for 20 days.
what about petition number 2?
He works in the shop of the petitioner number 1.
Shop of petitioner number. Yes, any materials?
My lord, during my lord investigation, my lord, on the basis of secret information, my lord, they came to know that, my lord, there are some stolen properties are they are in the, my lord, this is what it's called, my lord, dam, my lord, of this petitioners, my lord. Then, my lord, they were interrogated, my lord, and materials also recovered. Then, my lord, petitioner number 1 said that, my lord, petitioner number 2 purchased those materials, my lord, from a person, my lord, whom he does not know, my lord, who is the person, my lord. So that is why, my lord, the materials were recovered and seized, my lord, and petitioner were arrested, my lord. But they could not.
Whether those materials are the materials which were
That is
stolen?
why, that is the one, it is connected, man. That is why it is seized, it was seized, man.
Can you make out that these are the wires which were taken from there? Unless there are specific, some
That is the
specification.
statement they have given, my lord.
Petitioner 1 said that petitioner number 2 purchased it and brought it to his shop.
Petitioner number 2, my lord, he is the employee, my lord. So he purchased the materials from the, my lord, some unknown
Some other
person.
person.
Petitioner number 1, he is the, my lord, owner of the, my lord, dam, my lord. So he said, I do not know, but he has purchased the materials, my lord. And the person there doesn't know who is he, my lord.
Okay. Heard, Mr.
A.M. Khan.
A.M. Khan, learned counsel for the petitioner, and Mr. B.J. R.J. Bora. By this application, the petitioners, who are 2 in numbers, have prayed for bail in connection with Bhorolumuk PS case number 126 of 2026, registered under section 305 within bracket small a / 317 within bracket 4 of the BNS 2023. The FIR in connection with which the petitioners were arrested was lodged on 6th of August 2026 by the admin in charge of SPS Construction India Private Limited, stating inter alia that theft had occurred at his construction site premises near the West Rotary, Bhutnat side, and the main bridge. Full stop. It was stated that on 4th of August 2026, in the evening, during a routine patrol, the on-duty security guards discovered security guards and site staff, SITE, site staff discovered that cables and lights were stolen. And it is also alleged that on the same day, the thieves trespassed into the site and damaged sensor devices and stole cables. Full stop. Mr. Learned Counsel for Petitioners submits that the petitioner number 1 owns a damp, a DAMP, damp, and petitioner number 2 is working as an employee in the said damp. Full stop. He submits that the police went to his damp and recovered certain wires, cables, recovered certain cables. And on suspicion that petitioners are involved in the stealing, had arrested them. On suspicion, the police, no? Or the police had arrested them, and that the petitioners were inside the jail for how many days?
20 days.
For 20 days. Full stop. Mr. R.J. Borua, learned APP for the state, on perusal of the case diary submits that on a secret information, the police came to know that cables were kept in the godown of the petitioner number 1. And on searching the same, damp, right? Not to go down, damp of petitioner number 1. And on searching the same, cables were recovered. Full stop. He further submits that petitioner number 1 stated that petitioner number 2 had purchased the cables, but from whom petitioner number 2 had purchased is not known. On submission, on consideration of the submissions made by the learned counsels, more so in view of the fact that no specific materials were found against the petitioners showing their complicity in the offense, this court deems it fit to enlarge the petitioners on bail on furnishing of a bail bond of rupees 20,000, each with 1 local surety, each to the satisfaction of CJM Kamrup Metro under the following conditions. They will appear before the investigating officer as and when called. Petition is disposed of.
Article 31 and 52.
The case diary was called for, my lord, not received, my lord,
Not received.
not received, my lord.
In both, both.
My case is fresh.
But then still same case diary will do.
Yes, Lordship.
Acha, anyways, what is this? This is item 31. 31, no case diary.
No case diary, my lord.
Okay, right. Heard Miss
J Singh for Lordship.
J. Chauffi,
J Singh for Lordship, appearing on
J.
behalf of
Singh
M.
for-
Biswas.
learned counsel for the petitioner, and Mr. R.J. Borua, learned APP for the state. Mr. Borua submits that case diary has not been received and has waited for some time to place the same. Prayer is allowed. List this matter on
Lordship, a short date may be given.
My lord, on 8th of September, my lord.
8th of September, 2026. Next week, there are 2 days holidays. And then item 52. Okay, 52. BA by 1 person,
2%, Lordship.
2 person.
Lordship, the FIR is at page number 11, Lordship.
Let the case diary come, counsel.
But Lordship, the section. The
Because
FIR
doesn't-
that is not attracted. Lordship. The section
Same
is-
will be in respect of the other
Yes,
accused.
other accused, Lordship.
So
That's-
they have not got bail, for them, we are awaiting
but
case
the-
diary.
But the Lordship, the section.
What will her client tell her? The other persons have got bail without the case diary and you could not. Wait, till on 8 we will hear. Okay, heard Mr. DJ Boro,
Yes,
learned counsel for the petitioner, and Miss RJ Borua. Mr. Oh, this is an application. Oh. This is an application by which the petitioners have prayed for bail in connection with Hatigaon PS case number 153 of 2026, registered under section 316(2), 318(4), 3192 61 2 of BNS 2023. Call for the case diary. List this matter on 8. 8 of September.
Where in this case, Lordship, the petitioner was arrested on 14/5/2000.
And copy of the trial court records. We have seen. Borua, you have seen?
Yes.
Okay.
Lordship, as on today, Lordship, 105 days, as on today, Lordship. And
Uh-huh.
yes, as on
Where
today,
is the
Lordship,
FIR? Ghograbar PS case number.
FIR will find page 14, Lordship,
Page?
page 14. The relevant page 18, Lordship.
Mm. Yes. I'll read it. Wait.
Lordship.
Who are you? What is the name?
Ritesh
Ritesh Kumar. There is something more to the story. Why will somebody just attack the other persons inside the vehicle?
Lordship.
So,
Lordship.
who are you?
yeah,
Your
yeah,
names are not there.
Lordship, in this case, Lordship, there is a violation of section 36, 47 and 48 of BNSS, Lordship.
36.
Lordship.
The arrest memo.
Arrest memo and 47 also, Lordship, 47, 48. In the record, Lordship, there is no 48 notice, Lordship.
47, 48. Grounds of arrest not given.
Lordship.
Acha, whatever. How are you in the I mean, you were identified.
Lordship, I have stated in paragraph 5, Lordship. Lordship, may kindly peruse the paragraph 5, Lordship, of my petition, page 4, Lordship.
Wait. The accused were apprehended red-handed.
Red-handed.
Oh, while attempting to flee into the jungle adjacent to the crime scene.
I have stated in my petition, Lordship.
There was only one person. There has to be some more persons.
Lordship, yes. One person already got bail, Lordship.
How many accused persons are there? And again, they say that both accused are residents of other state.
Jharkhand, Lordship. In the FIR, Lordship, there is no name of the accused, Lordship, but in the forwarding report,
Acha, apart from 36, 47, 48, what are the materials, Mr. Borua?
My lord, Lordship, here the informant, my lord, he is a judicial officer, my lord.
Hmm?
Informant is a judicial officer, my lord.
Sure.
He was returning from his official work, my lord. Then this accused person, my lord, they are from Jharkhand, my lord. They obstructed his car, my lord. His car was stopped, my lord. Then the informant was asked to open his door, my lord. Then when the door was opened, my lord, they, my lord, sit inside the car, my lord. Then they have started assaulting him, my lord. Then, my lord, at that point of time, my lord, the informant, my lord, he made some human crime, my lord. Two persons stopped, my lord. And when they came towards the car of the, my lord, informant, my lord, the accused person, my lord, they fled away, my lord. Thereafter, my lord, they were arrested, my lord.
Oh, those are
Now, my lord, yes. Now, my lord, there are some eyewitnesses, my lord, who has implicated the accused person, my lord. And their statement also recorded under section 183 of the BNSS, my lord. So now, my lord, this case is pending at this appearance stage, my lord, because two accused persons, they got bail, my lord. So they have not appeared, my lord, but the cognizance has been taken, my lord.
Two accused persons got bail. There were so many.
There are, my lord, around, my lord, 7 to 8%, my lord. 7 to 8%, my lord. On 11/8/2026, cognizance taken, my lord.
Hmm.
And the next date is fixed on 2/9/2026, my lord.
Hmm. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/2026. 2/9/20 So now he has challenged on arrest. Where is the arrest memo?
Lordship, Lordship, it is in the record, Lordship. I could not annex because Lordship due to non-availability. It is there, Lordship, in the record. I have.
Even grounds of arrest you have not.
No, Lordship.
It was not even given.
No, Lordship. Only WT.
What do you
message
say
is
on
there.
arrest?
Regarding, my lord,
WT message is there.
regarding, my lord, arrest memo, my lord, it is there, my arrest memo is there, my lord. Regarding, since they are, my lord, from Jharkhand, my lord. So WT message was sent, my lord.
No, as far as arrest memo, there has to be signatures of independent witnesses.
Witness, my lord, yes. my lord.
Witnesses' signatures are there.
Signature
Signature is not there, my lord,
Not
but
there.
in this regard, my lord, I beg to place one, my lord, order, the judgment of this honorable court, my lord. That is, my lord, there are some cases, my lord, this dispute was arises, my lord, because some court of this honorable court had took some view, my lord, and other court took some view, my lord, regarding 36, 47, and 14 notice, my lord. Then the matter was referred to, my lord, honorable chief justice of this honorable court, my lord. And that, my lord, that lordship will find, my lord, there's a BA number 1239
So
2000.
the larger bench judgment has come.
Yes, my lord.
What did it say?
1239, my lord. It says, my lord, lordship may kindly peruse, my lord.
Give me that.
1239. Lordship may peruse, my lord, from paragraph, page number, so paragraph number 17 onwards, my lord. Paragraph 17 onwards.
The author of the judgment is not reflected. 17.
Page number, paragraph number 17, my lord. In our understanding, the mandatory character of a statutory requirement and the legal consequence of its breach are two distinct matters. Merely for the reason that the statute commands that a particular procedure shall be followed, it does not necessarily follow that every failure to follow such procedure renders the entire action void for all purposes. The consequence has to be gathered from the statute, the nature and object of the provision, and where the constitutional protection is involved, the nature and effect of the rights infringed, my lord. Thereafter, my lord, Dorsime peruse, my lord. Page, paragraph number 23, my lord. The DK Basu was relied on, my lord. The DK Basu Supra, my lord, undoubtedly requires strict compliance with the safeguards involved therein, but it cannot be understood as lying down an inflexible proposition that a breach of any individual safeguard, irrespective of its nature and effect, automatically nullifies the arrest and confers an indefeasible right to be released. The consequence of this may include judicial scrutiny, departmental action, contempt proceeding, and for appropriate cases, compensation. However, Section 36B(1) and Section 48 impose distinct obligation and serve different purposes. My lord, I will not take your lordship to each and every paragraph, my lord. Then paragraph 28, 29, and 30, my lord.
I cannot understand this. What 36 is a different provision. 47, 48 cannot be.
36 is the arrest memo, my lord, that is served, my lord. Just after, my lord, he was declared, my lord, arrested, my lord.
And grounds of arrest are different.
Grounds of arrest, my lord, this is one for the 47 is for the accused person, my lord. 48, my lord, for the, my lord, family members, my lord. Now, as far as the 48, my lord, concerned, my lord, that was sent through, my lord, WT message, my lord. So WT message is very much there, my lord, in the
WT message is actually not the proper way. The police here has to send the information to the concerned police station where the relative stays.
That is
And
how-
then that police station has to go and serve them.
That is why, my lord, from Gograppa police station, my lord, WT message has been forwarded to the concerned police station, my lord.
Then-
Where this accused person, then, my lord, whether it is served or not, that is not clear from the record.
That has to be clear.
No, that, my lord, for that purpose, my lord, some instruction may be required, my lord. Because otherwise, my lord, in this judgment, my lord, of this honorable court, my
But
lord,
here,
it can be observed on the-
section
my lord.
36 and section 48 was read in juxtaposition. But,
Order, oh, wait. So that it is 12 8. Now, my lord, in this case, my lord, basically, my lord, he has to show prejudice, my lord. He has to show prejudice, my lord, due to, my lord, non-serving of the, my lord, 36, 47, and 14 notice, my lord.
So ultimately, what does
prejudice.
this judgment say?
But ultimately, my lord, that is the.
Section
last
36
paragraph
is mandatory
Yeah,
and
37, my lord, yes.
36 is mandatory and the police officers
affecting arrest are-
Affecting are bound to follow all safeguards. So if
Yes,
there are no
ma'am.
signatures, then your arrest memo is
Yes,
is
then-
not valid. Failure in complying with procedural safeguards, valid, huh?
Other
Prohibition
attending
attractive.
absences.
Now three, my lord. However, such failure by itself and in isolation does not automatically render the arrest void and ab initio or non-res, my lord. And four, my lord, the court examining the legality of arrest ought to consider the totality of the circumstances, including whether the arrest was otherwise authorized by law, whether the grounds of arrest were communicated, whether the relatives or friends were informed as required, whether the arrestee were produced before the magistrate within the prescribed time, and whether prejudice or abuse has resulted from such omission in framing of arrest memo, my lord. Now, my lord, there are another submission, my lord.
Hmm.
This accused person, my lord, he preferred in, my lord, bail application, my lord, before the trial court, my lord, on 9/6/2026, my lord.
Ah.
Before the trial court, my lord, he preferred in bail application, my lord. That is very much in the record, my lord.
Rejected.
In this bail application, it is definitely, my lord, it is rejected. That is why they have come. my lord. But in this bail application, my lord, he has not taken all this ground, my lord. The 36, 47, and 48 notice were not serviced, not served. my
He
lord.
can always
there.
take this before High Court.
But my lord, in Sunam Raghuvanshi case, my lord, that the honorable apex court has hold, my lord.
Oh.
In Sunam Raghuvanshi case, my lord, paragraph number 8, my lord. If lordship permit, my lord, may I read, my lord?
Tell me three answers, whether 36 is followed, whether there are signatures of the counter signature of the.
My lord, counter signature is not there, my lord. But for that, my lord, he has to show the prejudice, my lord. What prejudice has caused to him, my lord. That is why, my lord, I am referring to the, my lord, the division bench of this honorable court, my lord. While these matters, bail matters were, my lord, referred.
Yeah, you bring some other judgment that even if the signatures are not there, if they cannot show prejudice, then I have not gone through such decision.
Lordship, I have stated it.
This isn't generally they are saying.
Lordship.
He
Yes.
has to be produced
My
within
lord, that is,
24
my lord,
hours.
my humble submission, my lord, 36, 47, 48, they are mandatory, my lord. But if, my lord, it is not, my lord, suppose there are some, my lord, it is not followed, my lord. If 36, provision of 36 is not followed, or 47 is not served, my lord, then what will be the, my lord, consequences? my lord?
Then
That has been answered by the
But this-
division bench of this honorable court, my lord. Because,
the
my lord,
division bench cannot override Supreme Court.
yeah, Supreme Court, my lord, that
In
is why.
Supreme Court decision, it is stated, in moment it is not there, he has to be released forthwith.
Yes, my lord, but under what circumstances, my lord, it was not there, my lord. Here, my learned friend is submitting, my lord, 14 notices.
But there are no ifs and buts. There are no riders
Then, my lord,
here.
sometime maybe.
As far as the decisions of Prabir Purkaster,
It is there.
those things, Vihan Kumar, those are there.
Rajesh also there.
You cannot.
Lordship, there is paragraph 9, Lordship, page 8.
Achha, where
I
are
have
these,
specifically stated that all.
from the records, have you found out grounds of arrest
Yes, ground of arrest, my lord, yeah.
Not
that
given to him?
36 is given to him, my lord, but the signature of the witness is not
And
there.
47?
47 is served, my lord, 40 is, my lord, it was sent to WT
After
message.
that, it is not.
Since he is from Jharkhand, my lord. So it is not possible, my lord, to, my lord, inform directly because he has not provided any phone number, my lord.
Okay, heard Mr. Ayu Chaudhary, learned counsel for the petitioners. Petitioners, there are two.
One petition.
Oh, the petitioner and Mr. R.J. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Gograpar PS case number 44 of 2026, registered under section 61(2), small a within bracket, 126(2), 117(2), 109(1) /3096, as well as section 62 of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged on 13/5/2026 by one Nitesh Kumar, stating inter alia that when he was going towards Gograpar by driving his vehicle, another car followed him and obstructed his moving vehicle for quite some time. Another car followed him and by blocking his way, compelled him to stop his car on the national highway. Full stop. Thereafter, he stated that the moment he stopped his car, the unknown persons coming out of the other car knocked at his door window and asked him about the road to Gauhati. And when he confronted the said persons, the unknown persons came inside his vehicle and assaulted him. Full stop. He then stated that he somehow got out of the car and upon shouting for help, few passerbys stopped and then the miscreants left the place of occurrence. Mr. Chaudhary, learned counsel for the petitioner, has taken 3 grounds for releasing the petitioner on bail. He submits that procedures under section 36 was of the BNSS was not followed, as well as procedures under section 47 and 48 of the BNSS. He submits that although the arrest memo was issued to the petitioner, but there was no signature of the some locality people, right?
Family member.
There was no signature, although Herikolu, no. Arrest memo was issued to the petitioner, but the same was not attested by any witness. Full stop. He further submits that although grounds of arrest were given to the petitioner, but the grounds of arrest which should be given to the relative of the petitioner under section 48 of the BNSS was not served upon them. Full stop. Mr. R.J. Borua, learned APP for the state, on perusal of the case diary submits, on perusal of the scan copy of the TCR, submits that there are witnesses who had seen the petitioners assaulting the submitted on the facts of the case, submitted on the facts of the case that there are witnesses who had assaulted the petitioner by getting inside his car. Full stop. As far as violation of section 36 BNSS is concerned, he submits that the same is a procedure and no, you said this is mandatory.
Then it is a procedural matter, and since no prejudice has been caused to him.
Oh, yes.
So, items can be paragraph-
Same has been the procedure and violation of the same has not caused any prejudice to the petitioner. He also submits that grounds of arrest under section 47 of BNSS was given to the petitioner, but the grounds of arrest meant to be given to the relatives of the petitioner, the same was processed by way of sending the same through WT masses to the concerned police station at Jharkhand, since the petitioner was from Jharkhand. Full stop.
In my another
However-
ground, my lord, he has also filed in the bail application, my lord, before a trial court, wherein he has not taken all this ground, my lord.
No,
full
lordship, it is
stop.
there, lordship, in the order, right?
He further submits
I can show lord.
that he could not find in the records as to what happened after the WT message was sent to the concerned police station. Full stop. He further submits that the petitioner has moved a bail application before the concerned court.
Not a
What
trial-
is that court?
Not a trial court, my lord,
Before the learned trial court.
on 9/6
But in the
2020.
said application, none of these grounds were taken by the petitioner.
Lordship, it is there.
To which the petitioner replied that those grounds were present when the application was filed before the trial court. Full stop. Upon consideration of the submissions made by the counsels, this court finds as follows. Just show me that arrest memo.
Yes, it is in
Has
the,
it
I have
marked it?
put a flag mark, my
Oh,
lord.
it's flag mark it.
No, follows. The arrest memo that was given to the petitioner in compliance of section 36 of the BNSS. In the arrest memo itself, grounds of arrest. Arrest memo is not this.
Arrest memo
As
36.
per 35, we have written. 35 is not arrest memo. 35 is what? Thirty-five is when police may arrest without warrant. This is what 35 they are referring.
My lord, if lordship kindly hand over the, my lord, can.
They have written it arrest memo. Just show me the arrest memo from here. Thirty-six. Rob, I'm arrest memo. I'm not saw. You found it. And grounds of arrest, have you marked it?
Yes, grounds of arrest is also there.
No, this one, I've seen this one. But this is, it contains grounds of arrest also, 46, 47, 36 all together. Or what?
My lord, that only the defect I have found, my lord, the signature is not there, my lord. That's what my learned friend is submitting, my lord.
Grounds of arrest. Again, grounds of arrest. This is what? To the relatives. No, this is arrest memo. Under 36. I think this, the one, not the one that you have shown. This is the arrest memo. Arrest memo of so many persons, right?
Lord.
What is your name?
Ritesh Kumar.
Huh?
Ritesh Kumar.
Ritesh Kumar.
Yes.
Sunil Kumar Paswan. Forty-eight is Munmun Begum. This is Navizul Haq.
Not
47.
there, Lord. So the only WT message is there.
No, 47 is this. 47 is this.
47 in English, Lord.
Huh?
In English language, Lord.
Now you don't say you don't understand English. Everyone understands English. Then WT message, this is 48. There likha. It will be Ritesh Kumar. In as follows. This court finds as follows. With regard to the arrest memo issued under section 36 of the BNSS, this court finds that the same has been given to the petitioner, but the signature, but the attestation witness column is also there. They should have taken one witness. The attestation by one witness who can be a member of the family of the person arrested or a respected member of the locality was not seen. Although the counter signature by the person arrested was there. Full stop. As such, it is seen that the mandatory provision of section 36 is not followed in the instant case. Full stop. With regard to the other legal point, to the effect that that grounds of arrest under section 47 of the BNSS this court finds that the same was given to the petitioner and all the necessary particulars of the case are incorporated therein. However, the submission of the learned counsel that the same was in English language does not hold good, since the petitioner has put his signature in English language in his arrest memo, as well as in the grounds of arrest. As far as the other point is concerned, that the relatives of the petitioner were not apprised of the arrest made of the petitioner by giving the notice incorporating the grounds of arrest to the relatives of the petitioner. কি করলো কোসম? Third to? Third or প্রথমবার কোসম? As far as the notice under section 48, এনেকে লিখি দিয়াচোন. As far as the notice under section 48 is concerned, the same is seen in the records of the case. But the same reflects that the officer in charge of Ghagrapar police station has intimated that petitioner was arrested in connection with the said case and that he has the right to be defended by a lawyer was intimated to the officer in charge of Barhi Jharkhand, BARHI, Barhi Jharkhand, by way of a WT message. But the further requirement that relatives of the accused person has to be apprised of the grounds of arrest is not reflected in the same. As such, there appears a violation of section 48 of the BNSS. Acha, the 36 speaks of another condition, that the informant has to be said that you have the right to inform to the relatives. That was given.
No, not.
But in view of the same, the petitioner is directed to be released on bail on furnishing of a bail bond of rupees so and so 28 over 1 surety to the satisfaction of.
Sureties, my lord, because he's from Jharkhand, my lord. Let there be two sureties, my lord. Because he's from Jharkhand, my lord.
One local surety or two local sureties, whether he'll be able.
No, let there be two surety, my lord. Out of them, one may be from the local, my lord.
Local, I said, no? With two sureties, one local, one has to be local.
My lord.
To the satisfaction of
CGM Nalbari.
CGM Nalbari. Under the following conditions, petition is disposed of. I know, but. Yes. বাহিৰৰ মানুহ হলে কি বুলি কম যদি পলাই যায়? He will appear before the investigating officer as and when called for to থাকিবই. On failure of such, the bail will be cancelled. Yes, what is this? Item?
33 my lord, charge sheet file.
33 charge sheet file?
My lord.
Good.
I am on
Okay.
interim, Your Lordship. I am on interim.
I'll extend the interim bail order. In that meantime, you go and file. Third, Miss.
M. Zomanpui. I'll write down my name.
Okay, difficult to pronounce. Learned counsel for the petitioner and Mr. Bonkim Sharma, learned APP for the state. Mr. Sharma submits that the charge sheet in the instant case has been laid by charge sheet number.
I charge sheet number, my lord, 102/2026, dated 21/7/2026.
Paisa. As such, the learned counsel submits that she be permitted to move the appropriate application before the concerned court. It is further noticed that the petitioner, one petitioner, right?
Yes.
Our petitioner was enlarged on interim pre-arrest bail by order dated 12/5/2026. For the ends of, full stop, for the ends of justice, the said order dated 25/2026 be extended for another 15 days time so as to enable the petitioner to move the appropriate application as stated above. Petition is closed.
34.
34, my lord. May I please, Lordship? Lordship, in this case, Lordship, the FIR was registered under section 306 of the Indian Penal Code. And the Lordship now, the police filed the charge sheet. Now, Lordship, that it is.
So although TCR has been received, but
Mr.
case
My lord,
diary
it
is
is,
not there.
my lord.
Case diary was not there on the earlier
Yes, my
occasion.
lord. So, my lord, kindly if that updation.
Acha, purported suicide note pertaining to the present case is also not available. Hence, call for the case diary. No, I think the case diary has come. That was on the last occasion.
Yes, Lord.
Let me see. Have you checked whether case diary has come or not?
No, Lord.
And
Why?
we are, and another thing, my lord,
Still copy of TCR has been received.
we are,
Yet whether case diary is there or not.
Yes, Lord.
Is it the duty of the court to check everything? You have to come see the last order and see whether it is followed.
Yes, Lord.
See whether case diary is there or whether suicide note is also there or not.
Yes, Lord.
35.
Yes, AB.
Please, your lord.
Hmm.
Sir, perhaps case diary has.
Case diary not
yes, my lord, it is charge-sheeted, my lord.
or charge sheeted. You go there.
Otherwise, this person has recently been diagnosed with most likely what appears to be cancer, my lord.
Hmm.
But in any case, if charge sheet is submitted, we'll just go in.
No, interim also not there, right?
No, it was not there.
Okay, heard Mr. S. Nawaz, learned counsel for the petitioner, and Mr. B. Bankim Sharma, learned APP for the state. Mr. Sharma submits that the case diary, that the charge sheet in connection with the instant case has been laid by charge sheet number
197, dated, my lord, 11/8/2026.
11/8/26.
My lord,
197 of 26.
my lord.
197/26 dated 11/8/26. As such, the learned counsel appearing for the petitioner submits that he be permitted to move the appropriate application before the concerned court. Prayer is allowed, and the petition is closed.
Details.
36, D. Borua. Yes, D. Borua.
36, my lord, case diary, received, my lord, it is, case
It's
diary.
already on interim. Was his statement recorded?
Statement recorded, my lord, he appeared.
Lady.
Late.
Okay, let it be
Yeah.
made absolute. Heard Mr. D. Bora, learned counsel for the petitioner. D. Borua? I know your name. Yeah, I had heard Mr. D. Bora, learned counsel for the petitioner, and also Mr. Bankim Sharma for the state. By this application, the petitioner has prayed for bail in connection with Dibrugarh PS case number 40 of 2026, registered under section 316, subsection 5 of BNS 2023. Where is the FIR?
FIR lordship will find at page 17, my lord, and relevant portion as page 21.
My lord, same FIR on the item number 61, my lord.
There also one is on interim bail. 61.
61, my lord, the P. Bora's case, my lord.
Oh, Pram Bora's case.
Yes.
What was done there?
Allowed, my lord. He is on, my lord, behind the bar, my lord.
Okay.
And now, my lord, it is AB.
Where is the FIR you said?
Lordship at 21.
Page
21.
21. And the first information report in connection with which the petitioner is apprehending arrest was lodged on 12th of February 2026 by the inspector of post. Oh, that post.
Yes, my lord.
Oh, same facts. Inspector of Post, Dibrugarh Subdivision, stating inter alia that in his case, he was the sub-post, what?
Yes, yes. Sub postmaster, my lord.
Sub-postmaster, and now she is Hitali Soikia.
One of the, my lord.
Oh, her name is here.
Yes.
His name was nowhere there. Okay. Herik dia, ki kolo? So and so stating inter alia that an amount of rupees 15,28,596 was misappropriated. during reconciliation of saving, misappropriated from the Mohanaghat Sub Post Office. Full stop. In the said FIR, the name of the petitioner finds place, who was working as SPM is what?
Sub postmaster.
Or who was working as the sub postmaster of Tengaghat,
And Mohanaghat postmaster. And now she,
Tengaghat, SO is what?
SO is the sub post office.
Sub post office.
Sub.
Tengaghat Sub Post Office. It is seen that the petitioner was enlarged on interim pre-arrest bail by order dated 13/8/2026 with the condition that she should appear before the IO within a period of 7 days from the date of the order and that her statement should be recorded. Mr. B. Sharma, learned APP, submits that the petitioner has appeared before the investigating officer and her statement was recorded. As such, it is seen that the petitioner is cooperating with the investigation of the case. And in view of the same, this court deems it fit to make the order dated 13/8/2026 absolute with the further condition that the petitioner should follow all the requisite conditions given in the said interim bail order without fail.
Obliged.
Petition is disposed of.
Lordship, suicide note is not found there. on the
Achha,
record,
not
Lordship.
there.
No, no,
And what
Lordship.
about Harry?
Lordship, the CD was not a.
Case
CD.
diary?
No, Lordship.
Okay, then it has to come. Okay.
Lordship, this is the second time, Lordship. Lordship, kindly
Yes, I
just sort a
understand.
Lordship.
Yes, I
Because
am.
Lordship, the trial is pending and the Lordship, the Chief Judicial Magistrate has issued a summon and the Lordship, he has no jurisdiction to grant the bail. So
Okay,
Lordship,
we will
at
fix
least
a short
kindly be
date.
allowed to appear.
No,
before.
no, we'll fix a short date because TCR has been received, case diary was
Yes,
not
yes.
there. I cannot surpass everything and give a bail
Yes,
order,
Lordship.
right? Heard Mr.
Yes, Deori.
S. Deori, learned counsel for the petitioner, and Mr. B. Sharma. Although by the last order, the case diary was called for and along with the suicide note present in the said case. However, when the matter is called up today, neither the case diary nor the suicide note was found with the records of the case. The registry is as such directed. Oh, no, like, full stop. It is therefore seen that although the trial court records have been received, but the same contained only the records pertaining to the trial courts, records pertaining to the trial court orders. But this case diary, which was submitted by the police before the court, has not been received. As such, the registry is directed to requisition the case diary along with the suicide note from the trial court in connection with which case? In connection with
Lordship, PRC case number 716/20.
PRC case number
716/24.
716 of 2024.
Obliged.
List this matter on 10th of September.
Yes, sir. Obliged.
Item 37.
After example, we have not received the case diary, madam.
Case diary is not received, lordship, subsequent lordship, the informant and finally didn't saying.
No, this is a pre-arrest bail, right? Call for the case, only one occasion.
And then just one thing, lordship, I'm pointing out.
Huh?
Now the informant has appeared and finally FTP stating that he has lost this FIR with misunderstanding. Lordship, I am praying that only some protection may be given and my statement may be recorded, lordship, that may.
So
come with-
settlement,
Yes.
what, some husband-wife issue?
No, there was a consensus, lordship, relation,
Oh.
allegation is rare. But it's in the FIR itself stated that it was a consensus party, page 7.
But case diary has already been called, requisition has
Yes.
gone.
Considering,
So entire bail application cannot be allowed.
but I'm not praying for that, only for interim, because considering the affidavit filed by the victim.
Heard Mr. M. Khan, learned counsel for the petitioner, and Mr. K.R. Patgeri, learned counsel, oh, and Mr. B. Sharma, learned APP for the state, and K.R. Patgeri, learned counsel for respondent number 2. Whether respondent number 2 is, they are not even responded.
No, but informant APR also.
How can informant appear? She was not made a party.
Secret APR also. As an informant worship APR.
Whether it is a POXO matter.
No, no.
Then
So informant lordship, they have a liberty lordship, they can appear lordship without even a party lordship. That's already, yeah.
under section 300, where? What is the enabling provision? That informant can appear? Section 300. 300, what? Purpose. Look into. You are looking at me, not required. You look into the book.
So,
What is the 301, I think? He will act under, of course, under the direction of the public prosecutor. And with the permission, submit written or arguments. So without the court's permission, you have filed your objection. You take it back. This is not the procedure. This was the first time or what?
second type.
This is not the way. You will file your applications.
Considering the affidavit lordship.
No, let the case diary come.
That only.
Heard Mr. M. Khan, learned
I will
counsel
appear
for.
before the IO lordship and get recorded my statement lordship. That will come. Otherwise, it is a FIR lordship is a consensus. If you
Oh,
lost.
yes, I can give you bail, but the
Yes,
fact is.
Already CG is called for.
But case diary is called, let
Call.
case diary come. So and so, Kaba. Mr. Bonkim Sharma submits that the case diary has not been received and has prayed for some time to place the same. Prayer is allowed. Further, it is seen that the informant where is what is the informant's name? Puljan Begum. Puljan. However, it is also seen that the instant case is not a case under the POXO Act, but the case is registered under section 329 4 as well as 64 of BNS 2023. Full stop. In the instant bail application, the informant is not made a party, neither it was required. However, it is seen that the informant, without being made a party and without any permission from this court, has filed his affidavit in opposition in the instant case, which is not as per law. As such, the learned counsel appearing for the informant may take back the affidavit filed in the instant case. List this matter. When can you bring the case diary?
Well, at 11th of
Okay,
September.
list this matter on 11th of September 2026.
Some spot date lordship.
Is a informant has filed in violation of section 301 of CRPC will litigate, which is in violation of section 301 of the CRPC. Okay, you place it. Then
Item. May I please your lordship? Case diary was called for last occasion.
his diary is there.
But my lord, case diary not there, my lord. And my lord, it is some time, my lord, requested, my lord, by the IO.
Achha. Okay.
Hmm.
How much time?
My lord,
You place it by next week?
next week, my lord.
Submit to the UN.
Heard Mr. N, you, Anuddin.
Yes.
It was written you Uddin. Heard Mr. Anuddin, learned counsel appearing for the petitioner and Mr. Bankim Sharma. Mr. Sharma submits that a case diary has not been received and there is an intimation from the police officer to take some time in production of the same.
Actually, my lord, sorry, my lord. Actually, my lord, it was sent to the session court Goalpara.
As the case diary was sent to the Session Judge Gwalpara. Prayer is allowed. List this matter on
Then, my lord,
9th of September.
maybe, my lord.
9th of September 2026. On which date the learned counsel would place the case diary.
Yes.
Yes, 45.
My lord, in this case, I will not take so much of time, only 2 minutes of submission I will give.
No, more than 2 minutes. 2 minutes you cannot finish, don't say.
My lord, here,
Acha, you lost contact with the petitioner.
yes, my lord, that is the thing, my lord. Here, my lord, she has filed the case for enhancement of her maintenance, my lord. The maintenance amount was given as rupees 1,000 for her and 600 for her two minor sons. That
Way
means
back.
2002, yes, way back in the year 2009, my lord. So now she has come here before this honorable court for enhancement or maintenance. But
For enhancement under 127 before the trial court.
yeah, no, my lord, I am not now
Ah.
here on that purpose, my lord. I just want to dispose of this case today only, and I am leaving everything up to my lord only. The thing is that even if we don't enhance her maintenance, no problem, she is entitled to get the maintenance amount, my lord. And maintenance amount which I have calculated in terms of 2,200 only, that is 1,000 and 600 for a sons, 2,200.
You
at a
could
total.
contact her.
Yes, I have contacted him. And I have her phone number also, my lord. And now, my lord, from the year 2009 to till date, it is only 3,98,200 rupees only.
Acha, the arrears.
Yes, including without interest rate, this is the total amount, my lord. And another thing, my lord, here, she is still, they are still husband and wife. So, and the sons, they are studying now. They are in school, so they are in higher
They
secondary.
cannot be school, I think.
They
2008.
are
now.
higher secondary or
Ah.
college terms, because now they are of 20 or 21 years, my lord.
Hmm.
So my lord may simply pass an order like to give this amount
Arrear amount.
by the yes, by the area only, by the one month's period if it is given, and if respondent pays it's all right. If he cannot pay, and I'm sure he cannot pay, so in that case, my lord, this wife and her two sons may go to their own home, because they were not knowing even the right also that she's still a wife, and her
She is staying somewhere else.
somewhere else, my lord. And her sons are the sons of his father also. No? They are entitled to get all the protection for their future life, for education and everything. In that case, they may go to their parents' house, and she can go to her husband's house. And if they wanted to they want to reunite, they can do also that.
The husband had not remarried.
No. That is the good thing.
You're
ma'am.
sure?
Yes, 100% sure. Because I have talked with husband's relatives also, then they
He is agreeable to take her back.
my lord, he is a different type of person, but the family members, I have talked with them, they were talking very in a friendly way. They are still calling this petitioners Kurima. How is she like this? They know each other. They are in contact with
Okay.
each other.
So what is the what has been challenged here for enhancement?
For
But for enhancement, you have to go to the
no, my
concerned
lord,
court.
at this stage, my lord, I don't want enhancement also, because my lord, I have come to know that, my lord,
Hmm.
he under the pressure that he has to give the maintenance amount to
Hmm.
her wife, his wife. He has either he has left his job or he was being suspended in this way, my lord. So enhancement
Now
is not
this
possible.
this application has been filed by the wife, right?
Wife, my lord.
Learned man, she has challenged it, order dated so and so, directing the informant, second party to pay only rupees 1,000 to his wife. Achha, this is not enhancement. She wanted more.
Yes,
So she has challenged the judgment itself.
yes, my lord. Now
But instead of doing that, she could have filed an enhancement petition before the
Yes, my lord,
appellate
now,
court?
now at this stage, my lord, her mental condition and this, my lord, she called me, she's saying that I'm all full of rin and everything, my lord. If we can give some relief to her, because from last 16, 17 years, I don't know how she is going through, she is illiterate one. She is, I don't know how she is
Okay,
going.
I'll give you a short order, let's see.
Yes, my
Well,
lord.
heard Miss
SD Chaudhary.
SD Chaudhary, learned counsel for the petitioner. And, I mean.
No one is there,
Okay,
ma'am.
that's for the petitioner. What about service vagera is not done?
No, my lord, earlier he was in this Assam police, now he is not servicing.
He is retired.
I don't know because he is now 54, 55 only. He is not retired formally way also, my lord.
Acha.
Either he is suspended or something like this happened because I have contacted Borpeta police station here, there, everywhere, my lord. No, nowhere. I don't know what happened and I didn't enter much, my lord. So
Okay.
whatever is there, my lord, on that only.
The present application has been filed by the wife, namely Srimati Junali Kolita, challenging the judgment and order dated 21/12/2009, passed by the learned subdivisional judicial magistrate within bracket M, Bojali, Patsala, in MR case number 26 of 2009, by which the husband, namely Shri Bhushan Kolita, BHUSAN Kolita, was directed to pay an amount of rupees 1,000 to his wife, that is the petitioner, and rupees 600 each to his 2 children per month. Full stop. The petitioner had challenged the said judgment on the ground that the said amount directed to be paid to her was very less compared to the very less, which is difficult for her survival. Ms. Chaudhary, learned counsel for the petitioner, submits that the matter has been pending since 2001, 2011, 2011, and that the petitioner and the respondent have not divorced themselves, and they are still the husband and wife. She further states that children have also grown and maintaining their educational expenses, maintaining them as well as their educational expenses was getting very difficult on her part, on the part of the petitioner. Where is the, do you don't have the petition? Where is the imprimatur order?
Impugned order in, my lord, in second file it is.
Huh?
LCR, it is LCR.
No, 21/12 order, you must have annexed. 21/12 order. MR 26.
Yes, my lord.
MR 26 of 29. Date is not given. What is the date of this query? 21/12. No, first one is the order dated 24/8/2009. 2009.
Yes, my lord.
Where this is a 125 petition.
Yes, my lord.
And there, it will difficult, full stop. She as such submits that the area amount by calculating the said maintenance, that is 2,200 per month to be paid to the wife and the children by the respondent. Full stop. And she also submits that relatives of both the petitioner and respondent has expressed their opinion that petitioner and the husband may stay together. And as such, she prays that petitioner will go to the house of the husband for staying along with him.
My lord, one thing, my lord, here one order may be given to respondent, otherwise he will start chaos. Another.
It is your submission
Yes,
only,
yes.
okay. Hmm.
And to pay 3,98,200 arrear amount, total arrear amount, my lord. Till date, from 2009 to till date, my lord. That amount has to be paid. with
Before
the
this,
respondent.
before this sentence, your courses and maintenance should be given 2,200. There you write. The learned counsel submits that till date, the total amount would be how much?
3,98,200.
3,98,200. That is from the date of filing of the petition till date.
Has to be paid by the respondent within 1 month, my lord. That has to be given, my lord.
Yes, that I've said it will be given. This is subdivisional judicial 2112, right? 2009?
Yes, ma'am.
Yes. Para. On 21/12/2009, the Learned Court of Subdivisional Judicial Magistrate at Patsala, after hearing both the sides, and after considering the earning of the respondent who was working as who was
At that time, Assam police, he was like constable. I am not
who
sure.
was working with the Assam police had held that the respondent should pay rupees 1,000 to his wife and 600 each to his minor sons. And the said maintenance was given under section 125 of the CRPC. This order was passed in the year 2009, and subsequent thereto, the petitioner had not filed any petition for enhancement of the said amount. Full stop. She had only filed the instant application alleging that the amount directed to be paid to her was very less compared to the living standards of the petitioner. During the proceeding of the instant petition, this court, by order dated 16/2/2012, had observed that the counsel for the respondent had submitted that the respondent was not earning anything during the relevant time, that is during 2012, and that he could not pay the maintenance to the petitioner as directed by the learned SJJM Bojali. However, the reason as to why the respondent was not getting any salary could not be discerned, could not be submitted by the counsel appearing for the respondent. Some information was why he was not receiving salary. The police was directed to get to do an inquiry and get back to this court. Yeah, I have the honor, Swami Pala,
My lord,
Acha, this court, by the same order, had directed the superintendent of police Borpeta to get the instruction as to why the respondent was not getting his salary. And the superintendent of police Borpeta, by an instruction on 16/3/2012, had submitted before this court that the respondent remained absent in his duties since 26/1/2011, and that salary is also not drawn by him. It was also apprised that a departmental proceeding has been initiated against the respondent. He's not drawing salary, he's nothing, doing nothing.
my
How
lord,
can I
but
now
he
say?
has shop, my lord, he has a shop, he has landed
At
property.
best, you can do one thing, you both families have a discussion.
My lord, that is thing, my lord, that we will do, my lord. Only one thing, my lord, that respondent may be directed to pay this much of amount, my lord. This much, which was his duty to.
Direction is okay, that was directed by court also.
Yes,
It was
my lord,
never
only,
paid.
only this much direction is required, my lord. If suppose he, within 1 month, if he pays, if he not, then at least they can go to their house. Only 1 point, my lord. This 1 point will save all the 3 persons, my lord. Only 1 point. That,
No, whether it will be legally permissible for me to say that, because this is an application for challenging that order. Either I accept it or I refuse it.
yes, my lord, but they will.
Then of course,
My lord, she will not be getting anything, my lord. She will not be.
she was not getting for so many years.
My
Children
lord.
have grown.
My lord, she was not getting anything, my lord. She will not get any, she will shattered, my lord. Only one order, my lord, that respondent being a husband and being the father is entitled to give this much. Only this much amount, my lord, only this much order will save them, my lord. Only this much.
Full stop. Be that as it may. The order dated 21/12/2009 still subsist, and it is imperative upon the respondent to pay the amount. The respondent as such is directed to pay the arrear amount of rupees
3,98,200 only.
3,98,200 to his wife as well as to his children within a reasonable period of time.
Yes, ma'am.
I'll make corrections if it is required.
Yes, ma'am.
The petition is such, with the above observations, the petition is as such
Yes,
disposed of.
yes, my lord. I'll bless.
I'll think over what I can do.
Yes, my lord, this much is
Yes,
sufficient.
Mr. Day, what can be done? I mean, husband is not served, he is not coming. Nobody is aware what he is doing, how is it.
Even a bit.
And this matter is pending since 2011. So now she wants that, and they have not remarried also. So she wants to go back and all.
Even then, if an order is passed, my lord, to whom will it be served? Because he is otherwise missing. That is what
So,
appears.
but we can at best say that the respondent, if the wife goes to his house, you know his house.
Yes, it's now turned all jungle, my lord. He.
Where does his parents stay? You said you,
Now no one still now no one alive.
who
This
you
only
said
two brothers. This respondent, they are two brothers. One side that elder brother is staying, they are living happily. Other side this respondent, but respondent is not even living at his own house also. It's all turned jungle, my lord. Photograph is with me, my lord.
Then whom
Then
did you
he is
speak
staying
with?
somewhere else, my lord.
You said you spoke with his relatives and they were
Yes,
very.
this my lord, elder brothers,
Other
elder brothers family I've talked. So they don't have any problem. If suppose she goes to her own home also, my lord, there will be no problem. Only this much of order that he will be giving this much of amount, my lord, that is sufficient. At least on that plea, she can go back to her house because the children and the wife, they are not knowing their right. That
Acha,
they are
that much
still-
can be given that she is also she is also permitted to go to her in
Yes, my lord,
matrimonial
yes,
house.
she is because
And
she has all the right over her land, her house, and everything. If suppose for in future also, if suppose for the sake of her health condition or for her husband's health condition or for the education of her children, she may keep the land with herself or she may sell also, my lord, like this, my lord, because she is still the.
but she left her house and she is where? She is in her mother's house.
She wasn't, but now I know that she was in her mother's house, but now she is doing like others' household works and like
Acha,
this, my lord. Very poor condition,
So,
my lord.
what can be done? I mean, she can go to her matrimonial house.
Yes, she can go to her husband's house if husband wants to come to their house because there is no problem, but because they are still husband and wife and they are near about 54
Mediation vagera will not.
No, no, my lord, that will not work. Only thing is that if only in that pretext if she goes back.
So can we see that it's a revision period? Process powers are other way.
Mm.
Because we are beyond.
Beyond the prayers, what can I do?
Yes, my lord, only this much is sufficient that she will be, husband is liable to give.
Tell her to go to her matrimonial house and ask for the money.
Yes, yes, yes. Only this much, but
The
he
petition is disposed of. Nothing
Yes,
more. Okay.
nothing more. At least he is liable to give all these things to his, because he was avoiding everything, my lord, avoiding. He went somewhere.
Acha.
So that's
Okay.
obliged, my lord.
Yes.
Item 12.
May it please.
Yes.
Proceed.
Hmm.
Worship, here, page 21 is the FIR. One sub-inspector of police lodged the FIR saying that the petitioner number 1 got married with the minor
Regarding child marriage.
child marriage.
So you want quashing of this FIR?
Quashing of the petitioner number 1 is the husband, 2 is the wife. They are living very peaceful married life, my lord.
Petitioner number 2 is the wife.
2 is the wife.
But when she married, she was a minor.
Just 17 years, 3 months.
Minor.
And although case was registered under POCSO 6 and 7, subsequently a charge sheet has been filed under section 9 of PCM Act only section 9.
9 of Child Marriage Act.
And prohibition of child. POCSO
Okay.
is not there.
Okay, right. Heard Mr. M.R. Khondokar, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, preferred jointly by petitioner number 1 and 2, who are the husband and wife. They are married, husband and wife.
Married
Husband and wife.
with a child of 3
The
years.
petition, how did I start? By this application, filed by the petitioners, a prayer is made for quashing of the proceeding. Continued. White, PRC case number 239 of 2025, under section 9 of the Prohibition of Child Marriage Act, arising out of Mankachar PS case number 230 of 2024. Full stop. So, pending before the court of learned Chief Judicial Magistrate, South Salmara Mankachar, Assam. The case of the petitioners is that on 22/12/2024, one FIR was lodged before the officer in charge of Mankachar Police Station by the police personnel of the said police station, informing inter alia that petitioner number 1 Shahin Mia, petitioner number LS 1 had married a minor girl about 5 years back in violation of the provisions of Prohibition of Child Marriage Act. Full stop. It was also alleged that the petitioner number 1 had indulged in physical relationship with the said minor girl. Full stop. The minor girl is petitioner number 2 in the instant petition. It was also informed that the girl was given in marriage to the petitioner number 1 due to the poor family condition of the said girl. That is petitioner number 2. It was also alleged that marriage between the two was performed by the local Qazi, and out of the said wedlock, a male child was born who was 2 years on the date of lodging of the FIR. The learned counsel for the petitioner submits that when the FIR was lodged on 22/12/2024, petitioner number 2 was major. 5 years back, he was minor. Okay, was major. And both petitioner number 1 and 2 were married with a child. Full stop. He submits that on completion of the investigation, the police submitted charge sheet against petitioner number 1 and the case proceeded under section 9 of the Prohibition of Child Marriage Act, under section 9 of Prohibition of Child Marriage Act, full stop. He also submits that by order dated 8/7/2025, cognizance of the offense under the said section was also taken by the court. The learned counsel for the petitioner further submits that an affidavit was sworn by the petitioner number 2, wherein she stated that she was in love relationship with the petitioner number 1. And that when she was married, she was just below the age of 18 years. But when the FIR was lodged, she was much above the age of 18 years. She also stated in the said FIR, said affidavit, that a stranger, that is a third person, had lodged the first information report and a case was registered. And the said case was proceeded with. And as such, by the said affidavit, she had stated that the said the case be quashed by the Honorable Court. Full stop. Pair. It is a subtle position of law that if settlements are reached between the parties and it is seen that there will be no purpose in continuing with the trial, the same can be quashed for the ends of justice. In the instant case, it is seen that petitioner number 1 and 2 are both husband and wife now, and they are parents of a child. And petitioner number 2 had sworn in an affidavit stating that she is happily living with her husband. That is petitioner number 1. And that a stranger had lodged the FIR against her husband. In view of the same, this court finds it fit that the PRC case number 239 of 2025, pending before the Court of Learned Chief Judicial Magistrate, South Salmara, Mankachar, Assam, be quashed. Accordingly, the said case stands quashed, along with the orders passed therein, as well as the charge sheet that was submitted on. নহলে charge sheet to আগত কৰি দিয়া না. Accordingly, the charge sheet, where is the charge sheet?
My lord, dated 31/5/2025.
Accordingly, charge sheet dated 31/1/2025.
31/5.
No, 31/1,
31-1.
page 26. 31/1/2025. As well as the PRC case number, along with the subsequent orders be quashed. Petition is disposed of. Yes, Mr. Day, you have been waiting for so long now.
It's okay, my lord.
Yes.
No, this is a 528 application, my lord, for washing of a, my lord.
Cholamandalam.
Which-
Cholamandalam investment.
Yes,
Those,
here, my lord, the petitioners are all managers. So what had happened, my lord, the informant, he took a loan for purchase of a Bolero vehicle. And thereafter, my lord, it was amounting to, my lord, 6,59,000.
he took a loan from Cholamandalam, then
Thereafter, he again took a top-up loan, the additional loan on that vehicle.
additional loan he took.
Oh, yes, ma'am. Now he defaulted in making payment. Thereafter, my lord, he gave the vehicle for rent to a person, my lord. We sent notices to him. Thereafter, my lord, the vehicle was repossessed by our repossessed agency. The vehicle was repossessed by our agency, ma'am.
It was deposited to you. It was
No.
returned.
Since he did not make any payment, my lord, we issued a notice. Demand notice was sent. Ultimately, invoking the agreement, my lord, we took possession of the vehicle
Possession.
by our repossessed agency.
So taking possession is considered to be wrong, right? By
No.
Supreme Court?
Yes, in Anup Sharma says, my lord, since the, my lord, the vehicle belongs to the legal owner is the financier, no criminal offense is made out. That is 2001. I'll just
Okay.
clear that, my lord.
Then,
Now, what had happened, my lord, thereafter, he lodges an FIR. I'll just take you to before that. This voluminous because the fact, my lord, this statement of accounts have been annexed to that, my lord, as well as the agreement. The lordship will kindly come to page 145. This is of, my lord, 12th of February 2025, and 146, my lord. The total amount due is 5,81,291. Now, lordship will see, thereafter the vehicle was possessed at next page at 147.
this was the total amount of loan that he had
No, no,
taken.
that was, my lord, due, outstanding due.
Outstanding
He
due.
was, he failed to pay the installments. This was the outstanding.
Initial installments he paid.
No, he
He
did not pay
did not pay anything.
anything. Now, lordship, this thereafter, my lord, page, my lord, 147, lordship will see
So this amount of 5,81,000 is
was
with the interest and everything.
yes, my lord. The total amount was on a much higher extent, my lord. The total amount, my lord, so far the vehicle is concerned, first loan was 659,757. And the second loan, my lord, was 3,05,616.
First was 6 lakhs.
6,59,000.
10 lakhs.
Total
Then
around 10
5
lakhs.
lakhs?
Now, as on date, my lord, the outstanding EMIs.
No.
He was required to pay the EMIs. He defaulted in making payment. As on that date, my lord, as on 12 February 2025, the amount was 581 outstanding EMIs. Now, the vehicle was taken over possession on, my lord, 23/5/2022. Now, lordship, thereafter, my lord, she lodges an FIR. Prior to that, my lord, since, my lord, it was under the SC and ST, my lord, Prevention of Atrocities Act, there was a preliminary inquiry, which your lordship will find at page 151. I'll just read it out, my lord. The
Mhm.
facts should be very clear there.
Hmm.
During inquiry, it has, lordship has found it.
Hmm.
During inquiry, it has come to learn that the complainant has bought a Bolero pickup vehicle bearing destination number so-and-so in the year 2020, for which he has issued a car loan amounting to rupees so-and-so from Cholamandalam Investor so-and-so. Additionally, he had taken another top-up loan of rupees so-and-so in the year 2023, but the complainant has failed to pay his installment against both the loans, 13 numbers of installments against the car number so-and-so and 11 so-and-so. Due to non-payment of dues by the complainant, on 23/5/2025, some employees of the Cholamandalam Investment Finance Company, Dibrugarh, has forcefully restrained the vehicle bearing destination number so-and-so and snatched the key of the said vehicle from the driver Sinku Das at Lachit Nagar by so-and-so, and took away the vehicle without any prior intimation to the complainant and without any order of the competent court or authority, which is not in accordance with law. Further, it is to be mentioned that as per the complainant, the vehicle has been forcefully taken away from the possession of Mridul Hajorika, but during the course of inquiry, it was light that the said vehicle has been rented to by Mridul Hajorika, and he was engaged one Sinku Das as a driver. During inquiry, it was found that, as mentioned by the complainant in the affair, about demanding money of rupees 5 lakhs, which was misunderstood by him. Said Finance Limited asked to deposit approximately 5,000 at the branch for his remaining dues against the said loans for releasing the vehicle. During examination of the complainant, he stated that his driver wasn't assaulted by them during the incident. On the other hand, till now, there is no evidence has been found against the allegation mentioned in the affair. तुम दम लोगों को गाड़ी नहीं देना चाहिए, तुम लोग इस काम के लिए नहीं है. It also to be mentioned that the vehicle bearing destination number so-and-so has been produced by the Cholamandalam Investment Company at Dibrugarh and kept at PS campus for the interest of inquiry. Hence the inquiry. Now, Lordship will see the FIR at page 156. It's completely false, my lord, misleading FIR.
So you have prayed here for
For quashing of, yes. Now, Lordship, the funny thing is, my lord, no allegation against anyone in the FIR. Now, in terms of the direction by the police, my lord, whatever documents were required to be deposited, my lord, we had already furnished the same to the police authorities, my lord. Now, charge sheet, I'll just take you to a line before I go to the FIR, instead, my lord, at page 181. The case is under, my lord, section 126, that is, my lord, wrongful restraint. 189 that is unlawful assembly. 304 snatching. Now, Lordship will kindly see at page 181, the third paragraph, the call records, my lord. Call detail records.
Paragraph?
The page 181, last part, my lord, last fourth paragraph from bottom, my lord. The call detail record, this CDR.
Yes.
Lordship said, analysis indicate that relative proximity occurred between the complainant and Pranjal Kumar about 12:27, where the gap between the respective towers are approximately 900 meters. The offices was located near the place of occurrence. The technical data establishes that the complainant was separated from the accused person who were present in the scene. The distance between the complainant and so-and-so was 37. He's not a petitioner, was 37 kilometers. The complainant and the accused persons were not at the place of occurrence during the alleged offense. So, my lord, if I'm not at the place of occurrence, how do I snatch? How does it come to wrongful restraint or, my lord, unlawful assembly?
So how did you then repossess the vehicle?
So repossession was by an agency, my lord. The petitioners before lordship, they were never there. And that is what transpires from
They will never be there. They have their own persons who will do it.
Exactly.
So they went and got the vehicle.
Yes, my lord. The agency repossessed the vehicle. We do not deny.
The agency with whom they have an agreement,
Yes,
right?
there is an agreement.
So that agency has nothing to do with Cholamandalam.
No, my lord.
So they went and they possessed the vehicle.
I have no, there is my lord. What?
But then you will be responsible, you vicariously.
No, if that is so, my lord, I just refer to, my lord, this Anup Sharma's case, my lord. Lordship will be clear about.
Show me that this
Yes, yes.
repossessing
Yes, my lord,
is not wrong.
Court, numbers of decisions to that happen.
No, there are decisions, but I felt
My
at
lord,
one point
initially,
of time it was said.
but probably, my lord, that Prakash Kaur's case, ICICI Bank was 2007, my lord, 7 case.
This is 2012. What about
13.
recent cases?
The recent case, my lord, they all are being followed. Thereafter, there are cases also, my lord. Lordship will see, and this has not been overruled, my lord. Lordship will kindly come to paragraph 7. Number of decisions have been referred to. Then even otherwise, vicarious liability cannot be first in, my lord. Now, even wrongful restraint, my lord, if I am not there, how can they proceed against me, my lord?
No, admittedly, you are not there.
There.
Your agency people were there.
Yes, my lord, I'm not come for quashing of.
But they have come on your behalf. They went on your behalf and
Actually,
got the
if
vehicle.
that is so, my lord, we are employees of a company, my lord. The company is not a party.
Hmm.
The company is not an accused in the case. Now, whether the officers of the company can be prosecuted, my lord. Whether, my lord, vicarious liability can be fastened upon them.
Why not? They have gone
No.
on your behalf.
It is not in the individual capacity, my lord.
Acha, where is that?
Lordship will
Paragraph
kindly come
7.
to paragraph 7.
They hear some other cases referred.
Number of cases have been referred, my lord. Ultimately, the conclusion is at page paragraph 7.
Hmm.
In view of the above, the law can be summarized in an agreement of hire purchase. The purchaser remains merely a trustee.
Hey,
Bailey
where,
on behalf.
where? It starts with Charanjit Singh Chadha.
So, Lordship, sir, I was referring to SCC, my lord.
Oh, it's okay.
Yes, Lordship.
You are referring to
Paragraph
Anup Sharma.
Paragraph 8, my lord.
Paragraph 8.
8.
Okay, in view of the above, yes.
The law can be summarized that in an agreement of hire purchase, the purchaser remains merely a trustee bailior on behalf of the financier, financial institution, and ownership remains with the latter. Thus, the case is, if in case the vehicle is seized by the financier, no criminal action can be taken against him as he is depositing the goods owned by him.
Normally, it is not owner, it is hypothecated.
Exactly, my lord. The hypothetical agreement they here, my lord. I have annexed the hypothetical agreement, my lord. It says, my lord, in case of default, I can take recovery of the vehicle.
So it is said that no criminal action can be
Yes, my lord.
taken.
Since I am the legal owner, he is merely, my lord, because ultimately, if the amount, if the loan is not cleared, he cannot be the registered owner.
But why did I hear that this repossessing on the road is not
No,
proper?
that was probably that was ICSA versus Prakash Code. That was in 2007. 2007 to SCC page
Was it
711.
mentioned here?
No, my lord. Here, this is in a later footing, my lord. In fact, Charanjit Singh, Chaddas and all, there are a number of cases. I can place those cases, my lord.
So in that case, what was said?
Charanjit Singh, that Lord Prakash Code case was on a different footing, my lord. What had happened in that case, my lord, the vehicle was taken over possession. She lost an FIR. The police failed to register the FIR, my lord. She went to the High Court. The High Court directed the registration of a case, my lord. Thereafter, my lord, the ICICI Bank went to the Supreme Court. Supreme Court, my lord, laid down certain guidelines. That was in 2007. Thereafter, my lord, how the vehicle is required to be possessed, my lord, Lordship will remember, they used to call up the, my lord, these credit cards and all, at odd times and all. So, my lord, the Supreme Court directed that the guidelines be framed. There was ultimately the direction was given to the Reserve Bank, and the Reserve Bank framed guidelines. And this agency, my lord, these are subsequent thereto.
Acha, to what is to be done today? Notice?
The only thing, my lord, in fact, the proceeding has to be stayed, my lord, because Lordship will see when there is no allegation against us. FIR against us, Lordship takes the FIR for a time being. We are nowhere in the picture. The Lordship at page 156 is the FIR, my lord. It is, sir. My lord, specific, even, my lord, the trial court's order, my lord, the specific, what allegations are there, has to be specified. Nothing.
1 second. Upon making, act was carried out at the behest of manager of so-and-so and certain muscle men and one Ratul Das of women. The act was done without any court order or lawful authorization and amounts to criminal intimidation.
The FIR is out and out false, my lord. Lordship will see.
Okay.
There is an illegal demand also, and the report says it was in respect of the outstanding amount.
Okay, heard Mr. R. Day, learned counsel for the petitioners, and Mr. K. Das, learned APP for the state. By this application filed under section 528 of BNSS 2023, the petitioners have prayed for quashing of the FIR, which was registered as Dibrugarh Police Station case number 187 of 2025. Full stop. The petitioners have also challenged the charge sheet submitted in pursuant to the said FIR. A charge sheet submitted on completion of the investigation in pursuant to the said FIR, as well as the order dated 30/5/2026 passed in the PRC case number, as well as the proceedings of the PRC case number 354 of 2026, pending before the court of Judicial Magistrate First Class Dibrugarh Full stop. The petitioner have also challenged the order dated 30/5/2026. What is this order?
Well, taking
Issue
of cognizance,
summons.
cognizance order.
Cognizance. Okay. Order dated 35/2026 by which the said court had taken cognizance of the offense under section 126(2), 189(2), as well as 304 of BNS 2023. It is the case of the petitioner that that respondent,
Yes, please. The respondent number 2.
case of the petitioner that respondent number 2 had taken a loan from the petitioner's company, from the company namely Cholamandalam Finance and
Company name.
Cholamandalam Investments and
Investment.
Finance Company Limited, Dibrugarh branch, for purchase of a vehicle. That is what pickup van?
Bolero pickup.
Bolero pickup van. Full stop. It is also the case of the petitioner that respondent number 2 had taken a top-up loan after the first loan from the said company. Full stop. It is stated that the respondent number 2, after taking the loan and purchasing the vehicle, had not paid the installments to the petitioner's company from the very first month itself,
For 24 months, Milo. For 24 months, yes.
totaling to 24 months at the time when the said vehicle was repossessed. Full stop. The petitioners, unable to get the monthly installments from the respondent number 2, had repossessed the vehicle on 23/5/2025 through its agency and submitted the vehicle to the police station.
Yes, Milo.
They submitted to the police station.
Police team. In fact, on the next day, Milo, I was called, Milo, the vehicle was given and the vehicle is presently run by the informant itself. The respondent number.
Run by the,
Presently is in the hands of the informant, Milo, the respondent number 2.
why? Why?
Milo, the police directed us to produce the vehicle. We produced the vehicle, Milo, thereafter Jimma was given to the,
Oh, acha, acha.
and
Jimma
still,
was
Milo,
given.
without making payment, he's running the vehicle.
Full stop. Which was handed over to the police.
Police,
Which was handed over to the police by the petitioner's company.
by the petitioner.
By the petitioner's company. Full stop. Para. The petitioner submits that on 24/5/2025, after they had repossessed the vehicle, a FIR was lodged by respondent number 2, alleging inter alia that he is the owner of the Bolero pickup vehicle bearing registration number AS06BC 8339, and that on 23/5/2025, some unknown persons possibly and illegally stopped his vehicle at Lachit Nagar near Jim's Nation and without any lawful authority forcefully snatched the vehicle key from his driver, and that the driver, namely Mridul Hajorika, and assaulted him physically. Full stop. It was further alleged that at the behest of the manager of Cholamandalam, the company of which the petitioners are the employees,
Yes, Milo.
are the employees, some of the staff as well as some musclemen had repossessed the vehicle, had taken away the vehicle, taken away his vehicle from the driver. Full stop. On receiving the Ejahar, the police registered the case as Dibrugarh PS case number 187 of 2025. full stop. It is, para, issue notice, petitioner to take steps for issuance of notice upon respondent number 2 by speed post with AD or by usual process. State is a party.
Yes, madam.
Mr. K.K. Das, the learned APP, appears for respondent number 1. And as such, no formal notice is required to be served upon him. Full stop. Any records? No.
No, otherwise, my lord, everything is here.
No. Full stop. Further on noticing that the vehicle was, noticing that loan was acquired by respondent number 2 from the petitioner's company and a vehicle was purchased with which the vehicle was purchased, with which the vehicle was purchased, and non-paying of the installment to the petitioner's company. No, এনেকে লিখা, this non-paying of the installment by respondent number 2, and on the other hand, lodging of an ejahar against the petitioner's company. This court in the interim deems it fit that actually further investigation should not be
No, I'm
stayed.
saying, my lord, charge sheeted case, madam.
Oh, yes, yes. The PRC case. The
350
PRC case number
354.
354 of 2026 pending before the
GMFC.
Judicial Magistrate First Class Dibrugarh be stayed till the next returnable date. List this matter after 4 weeks on a date to be fixed by the registrar. Yes.
May it please, madam.
Hmm?
This petition filed against the, my lord, and order dated 27/7/2026, where my lord cognizance taken against me, my lord.
Cognizance is taken of the offense, not against you. What,
Yes, yes.
what happened?
On section 356(2), my lord, that
356(2) is what?
defamation, my lord.
Defamation.
Yes, my lord. My lord,
Show me the complaint.
yes, my lord. Complaint petition, my lord, start from page 14.
Hiranyo Kolita.
Yes, my lord. And
Abani.
Avani
Kolita.
Das Kolita, my lord, accused. Page 17 is, my lord, relevant portion, my lord.
Hmm?
Page 17, my lord.
Show
My
me
social,
the relevant portion. It's already
yes,
5.
madam. If, my lord, my social post is, my lord, seen, my lord, that
Ah.
is not specifically mentioned that.
Let
you know-
notice be issued today.
Yes, my lord, then kindly be state, my lord.
Why stay?
Yes, my lord, but my lord, as
This
per
cognizance is already taken.
again, my lord, as per my lord, they are my lord social post, my lord, my social post, my lord.
In the
That is-
social media.
Yes, my lord.
Where
That-
is that?
Yes, my lord, page 17.
Where is the relevant part?
Yes, my lord.
Accused was attending Lakshmi Puja.
That's
Which
it.
paragraph should I read?
Paragraph 6, my lord. My post, my lord, in Assamese, they নিজৰ স্বাৰ্থৰ বাবে এটা প্ৰতিভাগ দমাই ৰখাটো
Wait,
সমান
I'm
কৰা-
reading the English part also.
Yes, ma'am.
That the accused published some defamatory statements targeting the complainant in Facebook post of her account in the name of Bhavani Kolita Das. Forget about
Yes,
Facebook
ma'am.
and all.
That is, ma'am. In my Facebook.
Let notice go.
Yes, ma'am, kindly be state, my lord, that is, my lord. In my Facebook post, my lord, they have filed, my lord, defamation case.
In your accused
Yes,
Facebook
yes, ma'am.
post, complainant in Facebook post of her account.
Yes.
How can you post in somebody else's Facebook account? You
No,
can post.
That is my account, my lord. In my account, I have.
Complainant has post in your account.
No, no, no. Complainant not posted, my lord.
What? It was informed by the
Complainant thought that I have posted against him, my lord. That is the case, my lord.
Hmm.
But there is nothing any specific that I,
Accused is a lady.
yes, ma'am.
Accused published some defamatory statements targeting the complainant in Facebook post of her account in the name of Bhavani Kolita. Complainant immediately checked the Facebook and found that the accused published a post in public stating নিজৰ স্বাৰ্থৰ বাবে এটা
প্ৰতিভাগ দমাই ৰখাটোৰ সমান অপৰাধ কি হ'ব আৰু কিছুমান অনুষ্ঠান নিজৰ পৈতৃক সম্পত্তি বুলি ভাবি ব্যৱহাৰ কৰি থকাবোৰক দেখিও মাত নমতাবোৰতকৈ অন্ধ এজনেই শ্ৰেষ্ঠ চৰকাৰে যেতিয়া আমি ভঙা পতা কৰিব পাৰো এই সমাজৰ সাধাৰণ মুখা পিন্ধাবোৰ
What is this? This is on demolition.
Yes, that is yes.
Huh?
Yes, my lord, but there is no name was mentioned of Hiranya Kolita, my lord.
সাধাৰণ ক্ষমতাত ইমানেই অহংকাৰী হৈ উঠিছে
অ',
নিজকে
নিজকে
CM
CM
বুলি
ভাবিবলৈ
ভাবিবলৈ ল'লে
মহাশয় আপুনি কিমান পণ্ডিত আমি জানো নিজে কথাবোৰ গা পাতি লৈ আপুনি প্ৰমাণ কৰি দিছে আপুনি নিজৰ সম্পত্তি বুলি ভাবি সকলো মন মানি চলাইছিল ভাল লেভেল ফালিলে
these are on eviction.
no no my lord.
These contents are for directing to what?
This
ভাল level ফালিলে what? On
actually
to the context of to what context?
yes my lord actually what happened my lord there is a village in he is the as per my lord his contention my lord he is the secretary of Lakshmi Puja my lord.
Acha, who is the secretary?
Hiranya Kolita.
Complainant.
Yes, complainant.
He is the secretary of Lokhi Puja.
Then there is some cultural function is going on. She is not, my lord, happy with cultural function. Then post as per his allegation, my lord. Then this post was given by the Bhavani Das Kolita, my lord. Only
Bhavani Das Kolita.
yes.
Bhavani in the name of Bhavani Kolita.
Bhavani
What is the name of the accused?
Bhavani Das alias Bhavani Kolita Das.
Name of the accused is
Bhavani Das.
Bhavani.
Bhavani.
You are appearing for Bhavani.
Yes, yes.
Okay.
That type of post, my lord, there is nothing in it.
In reference to what context has she put these statements?
Yes, he said, my lord. I have posted that some in Facebook post, my lord. He said that he is, my lord, illegally done something wrong in Lakshmi Puja as a secretary, my lord. He thought that. I have
Acha.
posted.
But it is not the case.
Yes, my lord, there is nothing in it, against Hiranya Kolita.
What is Protibhag Domai? What is this? I cannot understand this
Yes, my
language.
lord, I have translated, my lord, English.
Where is that?
It is, my lord, page 26, my lord. Page 26, my lord.
So what happened? This cognizance and all were taken for this?
My lord, kindly
Forget
this
it.
procedure state
Okay,
my
heard Mr. M. Kolita, learned counsel for the petitioner, and state is a party.
yes, my lord.
And Mr. K.K. Das, learned APP representing respondent number 1. By this application filed under 528 of the BNSS 2023, the petitioner has challenged the cognizance order,
Yes.
has challenged the order dated 27/7/2026, passed by the learned judicial magistrate first class Baksa Musalpur in CR case number 126 of 2025, by which cognizance was taken against the petitioner for offense punishable under. The cognizance was taken for the offense under section 356 within bracket 2 of BNS 2023 against the petitioner. Full stop. The case of the petitioner is that a complaint case was filed by the complainant, namely Hiranya Kolita, before the Chief Judicial Magistrate Baksa Mushalpur, stating inter alia that while he was the secretary
Yes.
of Lakshmi Puja celebration,
Yes.
while he was the secretary of the committee
Secretary-
involved in
Yes.
Lakshmi Puja celebration, the accused person, that is the petitioner, accused petitioner, that is the petitioner, had posted an article in the social media alleging certain misdeeds by the complainant. Full stop. In pursuant to the said complaint petition, the learned court had recorded the initial depositions.
Yes, ma'am.
Initial depositions, and thereafter, by order dated. Where is the order?
Page 23, madam.
By order dated 27/7/2026, had taken cognizance of offences under section 356(2) of BNS against the petitioner. The learned counsel for the petitioner submits that there was no intention on her part to defame the complainant,
That is S1 number.
as she has put up in good faith the said statements in the social media. Issue notice to the respondent number 2, petitioner to take steps for service of notice upon respondent number 2 by speed post, speed AD or by usual process. Since it is provided under the law that in good faith, but this cannot be in good faith, the way,
No, my
the
lord,
words
is
that have
not
been
against,
written.
my lord, there should be, my lord, specific, my lord, that Hiranyakalita has done so and so. Nothing, my lord, in Facebook post, my lord.
However, it is noticed that without, even the name is not mentioned,
Yes,
right?
my lord. Let
He
me-
just thought,
Yes, my
Acha, it is noticed that without any name, without any name, the petitioner had given her own thought while writing those sentences in the social media. And as such, in the interim, this court finds it fit to stay the operation of the PRC case number. PRC or what?
No, my complaint case. CR.
Complaint case. Stay the further proceeding of CR case number 126 of 2025 till the next returnable date.
Obliged.
List this matter after 2 weeks on a date to be fixed by the registry. Yes, Mr. Borthakur, I've saw Borthakur somewhere. Shantanu Borthakur. Pune? Oh. Yes, yes. 15. Is this a motion matter?
Most of them
Yes.
have taken
Okay.
permission on that.
Yeah, I understand.
Yeah.
Because, I should take up the bail matters first, otherwise
No,
the
no,
case diary
it's
will
all right, it's all right.
have to be retained. Okay,
Thing is
then
that, my lord, 125 statistical proceeding, my lord.
125.
Yeah.
Let notice be issued.
My lord, the thing is that the petitioner's service is now under danger, my lord, because.
But then she was your wife, you have to pay 15,000 only.
No. I'll just take your lordship to the page, page 34. That may kindly be seen.
34.
Only that much. Now, whether she is my wife or not, that is also my lord, 34. It's a
Because
cross-examination of the.
after she appears, she has not obtained divorce from court with Nirmal Rai. So she had a first marriage.
She has a marriage, she has a husband and 2 daughters also, mine. Just the thing is that my client have some.
Only notice, let her appear, then we will see whether she is a wife or not,
My
then
service-
interim.
My
Her
service is
Mr.
in
B.
danger,
Sarkar.
my lord, service is in danger. For
What?
Till returnable date. I'm a constable in police department, Assam police, madam.
Why are your service in danger?
No, because
The
my.
maintenance
no,
will
ma'am,
not
because
make you.
your lordship will find the court, honorable court this day, as on day, has granted only 1,500 per month. That is not the case for me, my lord. The thing is that why the court has granted 1,500? Why not it is 2,000, 3,000, 4,000 or 5,000? Something is there that is to be examined, ma'am. That whether she is my wife or not. Now, this is the thing. If she is my,
You have another wife.
I'm a married man, ma'am. So if my lord, if I consider it to be a wife, my service will go.
So she came into your life after you married,
Yes, my lord.
during your subsistence of marriage.
Yes, ma'am. So this is the only ground that I have taken mention on the Tuesday, my lord, the matter to be taken yesterday. But yesterday, your lordship was not there.
Okay, heard Mr. B. Sinha, learned counsel for the petitioner. By this petition filed under section 528 of BNSS, the petitioner has challenged the judgment and order dated 5/2/2026 passed by the additional session judge Bilasi Para in criminal revision number 7 of 2025, by which the judgment and order passed by the judicial magistrate Bilasi Para 1 in miscase number 86 of 2019 under section 125 CRPC was upheld. Full stop. By the said judgment passed by the judicial magistrate Bilasi Para 1, a maintenance to an amount of rupees 1,500 was directed to be paid to the respondent
Yes, ma'am.
from the date of filing of the case.
Yes, ma'am.
The said direction was upheld by the appellate court
Yes.
by the order dated 5/2/2026,
Yes.
which is put to challenge by the petitioner by this petition. The main challenge of the petitioner in this case is that respondent is not his wife, and that the respondent was married with 2 children, and that she had neither divorced her first husband
Yes.
nor married the petitioner. Full stop. Issue notice. Petitioner to issue notice to the sole respondent. Petitioner to take steps for service of notice upon the respondent by speed post or with AD or by general process. In the interim, on the facts narrated above, this court deems it fit to stay the operation of the further proceeding of
Operation of improving.
Oh, this has been
Yes, madam. Yeah.
deems it fit to suspend the operations of the impugned order. No decree, right? Operation of the impugned order dated 5/2/2026.
Yes, ma'am.
As well as the first order.
Same thing, madam, if it is, state, then automatically that court below order will be stayed.
No, it will get revived. If I stay the first court order, then it will,
Then, madam, that's it. Yes.
as well as the order
As well as the order dated, trial.
5/2025. 5/2/2026 passed by the additional session judge Bilasipara. In criminal revision petition 7/2025, as well as order dated 30/5/2025 passed by the judicial magistrate Bilasipara 1. In Miss Case number 86/2019 till the next returnable date.
Obliged.
List this matter after 2 weeks on a date to be fixed by the registrar. Yes, Mr. Chaudhary, what do you have? Otherwise, it's already 5. Mr. Dekka, you're also there.
Thursday for motion hearing.
So what are the matters left or motion hearing no? Huh? This petition takes so long, I mean, I cannot even reach the hearing matters.
Our matters.
Matters can come up on Thursday if it's not.
Oh, there are more motion matters.
Yes,
You are in motion?
yes, we both are on the same case.
I'll finish the motions, okay. I thought admissions and all. Wow. 55. 55, Mr. Bora?
55.
The petitioner before Lordship is the Assistant General Manager of APDCL. Lordship, the petitioner being an employee of APDCL, he is serving in Rongya Electrical Circle. He along with the staff went to the premises of the complainant to inspect the unauthorized electricity connection and thereafter Lordship, a CR case has been filed alleging criminal trespass. That is the only case, Lordship. And now cognizance has already been taken under 447.
So where is the CR case? Just show me once.
Page number 9 starts from page number 19 to 22.
19 is in Assamese.
Yes, Lordship will find
Translation?
15 starts from 15 to 17.
Mhm.
The relevant para, your Lordship will find at page number 16.
Which one?
The brief fact of the case is that on 6/3/2024, the accused along with 8 other staff of the same department firstly entered the premises of the complaint without permission.
Acha, the accused person entered. But the accused was alone in the house and the accused was alone in the house. So this money was missing.
No, he says so, but an APDCL staff will not go to someone's premises to collect money.
But then they were paying the electricity bills regularly.
No, he was
And you could not find also any illegal connection.
using an charging an e-rickshaw after the sunset. Then therefore the APDCL staff had to go after the sunset.
He was charging an e-rickshaw.
E-rickshaw without any permission. Because for
He had electricity house in his house.
he cannot do so because for e-rickshaw also he has to take permission
Oh, acha.
because the load capacity will increase.
So that permission he did not have.
No,
So you went and checked.
yes,
And then, so complaint was filed against you.
yes, Lordship.
Let notice go.
Lordship, since he's an employee of APDCL, he has to appear at Bongaigaon every time.
But nothing of the e-rickshaw because he has not stated that, right? Okay, heard Mr. R. Bora, learned counsel for the petitioner. And RJ Bora is there.
No, it's a private complaint.
Okay, so and so. By this application filed under section 528 of BNSS 2023, the petitioner has challenged the proceedings initiated by CR case number 15 of 2024 pending before the court of learned subdivisional judicial magistrate Bongaigaon against the petitioner. Full stop. The petitioner has also challenged the impugned order dated the order dated 22/1/2026 passed by the learned SDJM Bongaigaon, by which cognizance was taken for offences under section 447 of the IPC against the petitioner. First, the case of the petitioner is that on information,
No,
where the petitioner is that how many petitioners here?
only one.
He
says
went
that-
along with a staff.
No, the other stuffs were not mentioned.
Case of the petitioner is that a complaint case was lodged by the complainant stating inter alia that he, along with other staff, entered the premises of the complainant without permission, without issuing any notice or without any search warrant. No, this is don't. The case of the petitioner is that the complaint that was lodged against him, that he and his staff entered the premises of the complainant without permission and without warrant, is a concocted allegation against him. In the said complaint, it was also stated that the petitioner, who was a employee of the
APDCL.
APDCL, went to check the unauthorized electricity connection in the house of the complainant, and that there was no unauthorized connection of the electricity. Full stop. The petitioner submits that the fact of the case has not been projected in the said complaint petition, to the effect that the complainant had an electronic rickshaw and he used to charge the batteries in the said house. And it is the case of, it is the claim of the, it is the requirement as stated by the petitioner, and it is the requirement that the necessary permission for charging the electronic rickshaw has to be taken from the APDCL. Issue notice. Issue notice, petitioner to take steps for service of notice upon the sole respondent with ADA to DDBA. In the interim, considering the facts and circumstances of the case, in the interim, this court deems it fit that further proceeding of CR case number 15 of 2024 be stayed along with it will cover the cognizance also, be stayed until the next returnable date. Petition list this matter after 3 weeks on a date to be fixed by the registry. Yes,
Item 56 to 58.
together. Okay.
And we
What happened here?
Page 35, very quickly, Your Lordship.
35.
35. That's the genesis, my lord. This is an FIR by a students' union alleging illegal stone mining. Page
In
30
Shillong or what?
No, in Uriam Ghat.
Uriam Ghat, okay.
Now, this is a border area between Assam and Nagaland. Now, at the bottom, your lordship finds there are 3 accused persons named and not named in the FIR.
Pawan Agarwala.
Pavan Agarwala, Champak Sarkar, and Jan Gogoi.
Hmm.
Now, the allegation basically is, your lordship finds in the second paragraph, a powerful stone
You were
mining.
here for quashing of the FIR.
Yes, and also a particular order, my lord.
Acha. And charge sheet is submitted?
No.
Acha. What is that order then?
No, my lord, if I may just quickly, in this FIR, I'm not named. Subsequently, at page 37, my name is also included, though no specific role is attributed to me.
This is another FIR, second FIR.
This is the second FIR, my lord. In fact, it's an undated application, and at serial number 10, your lordship finds the name of the petitioner, Rohtu Borua. So no specific role is assigned to me. Now, we approach this court and we bring it to the notice of the court that I'm merely a consignee who takes stone from a particular permitted quarry in Nagaland, and that Nagaland government has already issued permits in respect of that quarry. So those permits are annexed, my lord. And then all this goes through a valid channel. The Assam Forest Department also endorses it. The Golaghat Division also endorses it. So does the Nagaland government. Based on all this, my lord, I'm granted interim protection, which your lordship finds at page 105. Now, after this interim protection is granted, my lord, there is another barrage of affairs for which the other matters are pending. Similar allegations.
Wait, 105, what happened? Here interim order you have.
Yes.
Okay.
Now,
Staying the proceedings.
granting me pre-arrest bail. Now, thereafter, a few more FIRs are lodged, which is why the other matters are here. Similar allegations. Initially, the allegation was Forest Department is also colluding with me. Later on, Forest Department also lodges another FIR. I'm given interim protection in all the cases. Thereafter, my lord, what they do is they find a very ingenious method at page 109. The investigating officer approaches the judicial magistrate first class and they say that they want to add a few more sections. Now, what are these sections? These are sections
UAP.
10 and 40 of UAP. Now, the idea is very clear because
10 is terrorist.
Exactly,
member.
Totally absurd, Malad. The allegation is illegal stone mining. Then, Malad, they add 10 and 40 so as to do away with that requirement of bail, because your lordship is aware, once the UAPA is added, Malad, I'm not entitled to pre-arrest bail.
Oh, no pre-arrest bail.
No pre-arrest.
43?
43D.
43D, but no, there are conditions, but then you will be enlarged on bail.
Yeah.
Then?
So, Malad, first of all, if your lordship has page 109, this is passed by judicial magistrate first class.
So the sections are added?
Sections are added. Now, page 110, if your lordship has, this is the notification by the state government under section 22, making the special judge the concerned jurisdictional court. Now, after the special judge has been made the jurisdictional court, how does JMFC first allow permit addition of sections under the UAPA, my lord? That's a point of jurisdiction, my lord. And even otherwise, if your lordship goes...
Now it will go before the special judge once the UAP sections are added.
True.
But adding sections, I think JMFC will be able to.
My lord, in fact, there are judgments which have said that considering the scheme of NIA and UAPA, courts of any other courts can not even extend orders, entertain applications, etc. That's a clear judgment of the Supreme Court. Now, even otherwise, my lord, first of all, jurisdiction it doesn't have. It's JMFC. These are special statutes. These special judges, the jurisdictional court. Second, my lord, how does now they want to sort of deprive me of that benefit of pre-arrest bail, which is why these sections are added. But if your lordship sees the FIR doesn't say which terrorist organization I'm associated with. How am I even funding those terrorist organizations? Is it even a scheduled organization? Nothing is there, my lord. How do they all of a sudden bring in UAPA?
Mr. Dekar, this will take some time. I'll have to see.
No.
Right.
Yeah.
Can it be taken up tomorrow or
What I beg to submit,
or else on Thursday.
my lord, what I beg to submit, my lord, there are some bail application pending, my lord, that was listed, my lord, before court number subject to correction, my lord.
Dispose it off.
Yes.
Before-
Instead of giving
Yes.
some interim order.
Before, my lord, court number 23, my lord,
Huh.
subject to correction, my lord.
Huh.
So, my lord, I do not know what order has been passed because of the case diary was already available. my lord.
Doesn't matter, those are bail, here it is quashing.
Yes, my lord. So, my lord.
Those will
in
not
the
have any
quashing matter
effect.
also, my lord, lordship will have to look into the case diary, since the case diary is already available, my lord. Because they are
It is not
challenging
available,
the,
that
they are
was the
challenging.
commission
Whether case diary is required.
No, that I do not know, my lord, because.
Because they apparently they've sent the case ready back. In any case, my lord, we'll consider this next week,
Okay, Monday or Tuesday, any day.
Tuesday.
Tuesday.
I reckon is a holiday.
Because, oh, Tuesday is a holiday, then Wednesday.
Thursday, is it?
No, Tuesday, Wednesday, then second, second, okay.
Second.
Because I can dispose it off, I'll just see the contents, right? So on second, please will you mention Mr. Chaudhary,
Yes.
okay, so that I can take it. It should not reach at 5 o'clock.
We'll
Ah.
pay for an update.
Okay.
It'll come up for motions. my lord.
Okay. Due to paucity of time, the matter could not be taken up today. List the matter again on 2nd of September. Wednesday. Had it been a small matter, I could have, but then. Eh, 199. Of 59 motion, yes, Mr. Gupta?
May I please, my lord, in this criminal petition, I'm challenging the order whereby, my lord, the informant was allowed to be re-cross-examination, my lord.
He was allowed
For re-cross-examination.
re-cross-examination.
Yes, my lord. My lord, the impugned order is at page 45.
Okay.
Although it is with regard to, my lord, 65B certificate, what happened in this case, my lord? One pen drive is given by the informant.
Hmm.
But as per the seizure list, my lord, there is no mention of any 65B certificate, my lord. Even in her evidence as well as in
Actually, no
cross-examination.
stamina actually. We will take it up Wednesday,
Oh,
coming
Can
Wednesday.
it be on tomorrow? Because the next date is fixed on 29, Saturday
Tomorrow.
for cross-examination.
Tomorrow.
Yes, ma'am.
Tomorrow hoga. Motion. And there is, okay, tomorrow. List this matter on the request made by the learned counsel for the petitioner, list this matter tomorrow. You please remind me in the morning. Yes, Mr. Bora?
So may I pray for a date in respect of item number 48? It's a hearing, Your lordship had fixed it last week, for hearing.
Which one? Item
48.
48.
Yes.
Okay. As prayed for by the learned counsels for the parties, list this matter on when?
On Thursday.
On 15th of September, Tuesday? 15th. Rest of the matters he will give time. Huh?
39 and 42, my lord.
He will give time, it's okay.
But this suspension of sentence, my lord, can you fix a date, my lord?
Could have taken up all those. Okay, any date he will give as soon as possible.
Because item number 50 CD may be called. Item number 50,
50.
quashing for the,
Sure.
quashing for the FIR.
Already scanned TCR.
No, my lord, charge, that is only bail. Charge sheet has not been filed. On the last occasion, CD was called. On the 5th occasion, today also CD is not there. So if the
This is for quashing of FIR.
FIR.
It's not required CD.
But it will require, my lord. In the last occasion, my lord says,
Why? I will see the contents of the FIR. If it makes out a case, I'll not. Why CD? The CD is not required.
Ma'am, item number 22. Item number 22 for criminal appeal. Today is admission. I come from a Tezpur Bar Association. Therefore,
Which bar association?
Tezpur Bar
Okay,
Association.
okay.
Uh,
Stay back tonight. Which matter?
22 item number.
22 years?
Aye.
Criminal appeal.
Yes, ma'am.
What is to be done? It should be admitted today. Right. 22 coordination, 22 decision filed.
No, I'm there. Previous में बता सुन. Admit कोई नहीं. मतलब.
Okay. 22, huh? Heard Mr.
Ranjit Bora.
Ranjit Bora,
Aye.
learned counsel for the appellant, and Mr. R.J. Borua, learned APP for the state. This is a criminal appeal filed challenging the judgment and order dated
17/7/2026.
17/7/2026, passed by the Court
Session
of
Judge.
Session Judge Sunitpur Tejpur in sessions case number 96 of 2025. Full stop. By the said judgment and order, the appellant was convicted. Convicted?
Yes, ma'am.
The appellant was convicted.
75 subsection 2. BNF.
Wait, where is the conviction order?
Conviction order, ma'am, page number 109. If you know the, yeah, yes.
Convicted under section 75.
Ma'am, page number 74, impugn order. 74.
Is convicted under section 75 subsection 2 of BNS and was sentenced to undergo RI for a period of 1 year with fine of rupees 2,000 and in default for payment of fine to suffer RI for another period of 1 month. Admit the appeal. Call for the trial court records. 74(2) is what?
BNS, ma'am.
What is the section? The
Ma'am,
offense?
sexually.
POCSO? No, no?
No, no, ma'am.
42. You have made the respondent a party?
Yes, ma'am.
Appellant to take steps for service of notice upon respondent number 2 by speed post with AD or by usual process. List this matter after 2 weeks on a date to be fixed by the registrar.
May I please note that item number 16, if the case theory has been retained on the last appeal.
Huh.
So may I pray for a date and the case theory may be retained, the short date may be.
16 is what?
16 is admission, quashing of FIR.
Washing of FIR.
Lordship, may I pray for third,
Okay,
third,
on the prayer made by the learned counsel, list this matter on
third,
third is okay. So many matters. not
11th,
prayed.
we can-
11th will be again too late. 9th of September 2026. The case diary which is received by the learned APP should be retained till the next date.
Madam, and 19 May, can we have a date?
You talk with him. He'll give you a date.
Okay.
Okay.